Awards 24-25. BW Legal World Global Legal Leaders Summit and Awards. It's a platform to trace the journey of the legal landscape and also foster cross-sectional growth and relationship. The Leaders Summit this year, it's towards 2026, celebrating excellence in law, leadership, and also in governance. We are joined by some of the top leading lawyers of the country like yourselves, who are all stalwarts in their respective domains and whose wisdom we're all going to cherish in the next few hours. Aaj subah, in the starting, it will be a marathon of panel discussions through which we will have top voices from the legal industry share their opinions, and it will then be followed by the 6th edition of BW Legal World Global Legal Leaders Awards. With that, to give you a sneak peek of what all do we have in store for the day, can you please play the event TV? Launched in the year 2019, BW Legal World is a community of BW Business World, a 4-decade-old publication that has since consistently ranked amongst India's largest and most respected business magazines. With that, may I please request our team to now play the Business World Legal World Community AV. BW Business World, led by Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business World and founder of the Exchange for Media Group, is the fastest growing business media house in the country. With a network spanning across 25 niche business communities and 8 magazines, BW Business World is proud to be entrenched in various verticals in the domestic as well as global business ecosystems. Amid changing times, BW now has a massive readership in the digital space as well. BW Business World's portfolio has 25 niche B2B communities that organize conferences and also forums to facilitate interactions between sectoral business leaders and also create a conducive environment for collaboration. To keep yourself updated about the developments, please subscribe to the BW Business World Group magazines. The latest issue of the magazine, it features India's fittest leaders above 40 on how personal resilience and disciplined lives are shaping India's new leadership mindset. Along with the BW Business World's top 100 marketeers who are redefining business influence in the year gone by and also the forthcoming year as well. आज आप कोई भी opinion, any picture, any view that you share online, please also use the hashtag BWGLLS. And you can also watch the live of this event on www.bwlegalworld.com. A big thank you to our partners for today, joytravels.com, Fandrum, Beanley Coffee, The Thick Shake Factory, Reality Plus, Exchange for Media, IWMBus.com, Impact and Pitch. With that, to formally welcome all of you and to set the context for today, please join me in welcoming to the stage Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business and the founder of the Exchange for Media Group.
Morning. It's a Sunday morning and thank you for making time. As we progress, we'll have more colleagues, but this is being streamed across our platform. First of all, welcome to Shri Lalit Basinji. He's been chairman of our jury. He's been a constant over the last 6 years at all our events. He's always on time or ahead of time. And thanks to him, I am on time always. Because I don't want to be late with him. Me and Sudhir talk often about the kind of energy and commitment he brings to everything he does. So, first of all, if there is a role model one can look forward to, and I genuinely admire him when he's not in the room. So, Mr. Basin, thank you for being such a truly a legend and a stalwart in the legal services domain and still continuing to contribute. I was just asking him, how many years to self, and he said the Society of Indian Law Firm is completing its 25th year and celebrating its 25th year. I don't think, I'm not an expert on law. I'm actually not an expert on, as I'm growing older, I think I know very little about almost everything, but when I'm coming to an event, and I try to keep it short so that we are absolutely on time and you're able to address. But, there are a lot of legal gatherings happening, personal gatherings, professional gatherings. Lawyers are buying real estate, like, I have law legal friends like nobody is buying. There is an exuberance about the legal services domain. That's the point I'm trying to make. And because this is a law firm gathering and we'll have GCs during the day, we combined the Global Legal Leaders Summit, which is basically our law services, law firms, conference and awards, and the GC awards together. And on the 19th of December in the same room, we have our BW Legal World 40 under 40 and BW Legal World 30 under 30. Last year it was on 15th December. I noticed two trends, and yesterday and day before yesterday I was at a legal gathering, and I tried to verify what's happening in the law firms. From whatever knowledge I have and my first-hand knowledge, is there two big trends happening in law firms. One is mid-sized law firms are merging with maybe little larger mid-sized law firms or bigger law firms, right? And why is that happening? That's a question you can answer. My analysis is that in some cases the ambition is bigger. Also, the steady flow of work becomes easier when there is collaboration. Also, I have met lots of young legal professionals, broadly between 6 to 12 years of work ex, who are doing very well in law firms, established law firms, but they've quit and started their own practices. In the last 1 year, 2 years, if they started with 5 clients, 6 clients, they have 12, 15 clients today. So these two things are happening at the same time. Mid-sized law firms are merging with other relatively larger firms, and young legal professionals who are broadly 10 years of experience are going on their own. So it's an interesting time in the legal services domain. Of course, no domain is untouched by what's happening in technology and in tech. The legal tech is an area which is impacting the services we keep talking about. And there is the rise of the small language models in legal tech. What is also happening is there is a drive to do skill development using AI tools for law firm professionals. Also, in the legal services, super specialization has been a big theme over the last 6 years that we have started. But I'm seeing that another trend when I talk to professionals is the breaking down of silos with enhanced integration. And I'm not talking of data, but firms are working closer while the specialization is there in an integrated way. And of course, the last thing that is happening is the AI-driven legal assistance and strategy in work are play in India. I'm not talking of US. I know of law firms and legal professionals who are using AI assistants for doing a lot of work which were earlier done by humans. So there is an upgradation of the quality of work professionals at the entry level are doing. These are the trends I see firsthand. As I said, legal services domain continues to grow. There is an exuberance as India grows, as the GDP grows, as the influence of the Indian entrepreneurs and the ambition of the Indian entrepreneurs grows, and there is a changing policy framework. Every 3 months there is loud. We're talking on a day which is a couple of days after the DPDP Act has come in, and there are huge, there's a huge play for lawyers and data privacy professionals there. So clearly, the future of legal services in India continues to grow. The pie of the legal services continues to grow. And I want to end by saying, I met someone who started a law firm 2.5 years back. He said, I want to build 1,000 crore law firm in 3 years. He may not have got there, but he's made substantial progress. I was recently sent the book on Trilegal's journey. And I was, I read the book and I was so impressed and enthused with the journey. So clearly, if other people, other professionals and leaders can build a law firm which has such a huge impact, 100+ partners, I'm sure the people in this room, the professionals in this room, the winners who are being recognized today will go on to do impactful work and build organizations and collectives which will really in some way prepare all of us for the future of legal services in India. I wish you luck. At 1:30 we have the awards. Mr. Chetan Sharma will be here. These are our GLLS awards, which are the law firm awards, and about 6:30 in the evening we have the GC 100 awards. So my kudos to Krishnendra who's put this together. I don't know where he is. And Krishnendra, thank you for doing it. Please give Krishnendra a big round of applause. He's always at work, so sometimes he may forget something or do it a little late. But earlier Ashima Garima and he used to put this together. Now he's put this together alone. So if there's delay or there's confusion somewhere, please forgive him because he's doing it alone. Yesterday Ved called me. He wanted a list. I think he sent it to you late. So that's because he's doing everything single-handedly. So thank you once again. Our best years are ahead. We stay in the play. On a philosophical note, I want to end by saying, I read this book 6 months back. It's called The Fluke. It's by a social scientist called Brian Clough. And the gist of that is that everything happens in our life is serendipitous. It's a series of miracles. So don't give yourselves too much pat on the back for your success. I'm not saying it is because of the good karma of your parents, of your grandparents, of people who work with you. So of course you worked hard, you put in the effort. So wear your success lightly. God bless you. Thank you.
Thank you so much, Dr. Batra. Before we begin, my only request to you, जो हमेशा होती है, that they've put this big timer here. Just be a little more careful of that because अगर आप उसका ध्यान नहीं रखेंगे, तो ये मुझे यहाँ खड़ा कर देंगे सिर्फ आपको घूरने के लिए. It's very embarrassing for me. My only request to you. चलिए. With that, for the inaugural address, please join me in welcoming to the stage Dr. Lalit Bhasin, President, Society of Indian Law Firm. Please.
Thank you. Dr. Anurag Batra, my very distinguished colleagues, when I use the word colleagues, it includes the General Counsel also, because they are an integral part of the legal profession, as much as we, the all of you. I question Legal Leaders Summit. There are no leaders in the legal profession. I think we are all colleagues. One may have put in 5 years of practice, one may have put in 20 years. Someone like me has put in 63 years of practice, but we are all colleagues. I am colleagues because for lawyers it is always a learning process. Actually, we are all students. Can any lawyer say, I have completed 60 years, but someone who has completed, can I say that I am a complete lawyer? No, I cannot. Because law itself is evolving. And with new laws coming in at the drop of the hat, the so-called established lawyers, we are all students of law. Therefore, there is no leader, legal leaders, in the profession. Therefore, Mr. Anurag Batra, next time I would request you not to use the word leaders, because we are not leaders. We are at par with them. Responding to your two questions which you posed to me, that emerging law firms, young law firms, while they are merging, you see, with the formidable, established, big law firms, I think it is the other way around. The expertise, you see, which the emerging law firms have, the vision you see which the emerging law firms have, that is not there with the established law firms. Therefore, it is the established law firm who are approaching the young emerging law firm to come and share their expertise, their innovative skills, so that, you see, they can progress together. That is answer number one. Answer number two is, why lawyers who have put in 6 to 10 years in a law firm, they branch out. I think they must branch out. I can give you the experience of my own law firm. People have, you see, come out of my law firm and they have become judges of the High Court, judges of the Supreme Court, they have even retired. But they came out of my law firm and established themselves either as head of law firm or as practitioners of law in their own right, like Siddharth Luthra, Siddharth Mridul. They were all a part of my law firm. Like Denton Legal founder Atul Sharma, he was with me. But we have the most cordial relations. I encourage people if they say, now it is time for us, sir, if we can go on our own. I say, you must go on your own. You have to establish your own identity because you have the potential, you see, to do that. And some of them have even, you see, outshined their original law firm of which I was the founder. I am proud of it. So that is the answer. Because no one can bind anyone to remain in law firm. And if some law firm tries to do that, I think they are encouraging bonded labor, which will never be acceptable to legal professionals of this country. Having said that, about AI, I have shared one link, you see, with my very dear colleague, Mr. Mishra, on the address which I gave yesterday in the Vidhi, which is taking place at the Constitution Club, which I gave example, because people were, Justice Manmohan was there, Dr. Manoj Kumar was there, about AI and the important role which AI plays. I just highlighted one incident which actually happened in my office. There were 5 I was taking their interview and I gave them, you see, some dispute. I said, draft a legal notice to the other side based on the facts, you see, which are here in this particular case. And within 20 minutes, I got the responses from all the 6. And to my amazement, to my surprise, to my shock, all the replies were identical. I said, that is not possible. If there are 2 lawyers sitting, they will never, you see, they may agree on principle, but the language will be different. How can there be? So one of my colleagues, who is more familiar with technology, she pulled out, you see, something. She says, sir, this is from that chat GPT, whatever it is called, you see. It is all out of that. I gave, you see, this example to indicate that this is a very sad trend. People have stopped, and particularly in the law schools and young lawyers, they have stopped applying their minds. They just use AI or technology not just as a tool, but as someone who can substitute their own judgments, you see. That is not possible. In law, it is not possible. Maybe in other fields. This is a very, very hazardous trend which I have witnessed, you see, that people have become, instead of masters of technology, they have become slaves to technology. And that is a very bad omen. Yes, use technology as a research tool. Find out, okay, what are the judgments on natural justice, what are the judgments on mergers and acquisitions and all that. Use it as a tool. That will help you. Then you don't have to look into the commentaries and what we used to do in our own time. You don't have to do that. Therefore, use it as a tool and then apply that, because there is no substitute for human brain. Only last year, when the then Chief Justice, Dhananjay Chandrachud, he and I were sharing a platform in Symbiosis Law School Convocation in Pune, and His Lordship gave examples, you see, how technology has facilitated administration of justice. Now people can do the filings online. They can file affidavits, evidence, arguments, everything done online. You don't even have to go to the court. You are sitting at home or in your office, you do all the filing. And then he said, we have had the virtual hearings now in place. So in my concluding remarks, I said, Your Lordship is right. It has facilitated filing of cases, but this filing has resulted in piling of cases. There are, in 23-24, there were 5 crore cases which were pending, you see, in the courts of India. Now that number has increased to nearly 6 crore cases. So it is like a cycle, it is a vicious circle. You have eased the filing, but now the corridors of courts, in those corridors you don't find places for lawyers or litigants to sit, because the space is occupied by files and files and files in the corridors, you see. That is the state of affairs which exists in our country. Sometimes I compare situation when I started my law practice in 1962. And I asked myself the question, today, are we better off or we are worse off? Therefore, so far as litigation is concerned, I can say with some daring certainty that we were much better off at that time. There were no arrears of cases. Even at the worst, there were some couple of hundreds of cases which had to be decided. In the high courts, actually there was no need for high court judges also. In Himachal High Court, we had only 2 or 3 judges sitting. In Jammu and Kashmir High Court, only 2 judges. And so was the position of the High Court. In Delhi, we had only about 12 judges at that point of time. This was the situation that there was no pendency of cases. People were getting justice. Do you realize the significance of this expression? I think you are all lawyers. You must have read the preamble to our Constitution. A preamble is supposed to be the soul of the Constitution. And the very first preamble says that we have to secure for our social, economic, political. Emphasis is on justice. But with 6 crore cases pending, are the citizens of this country, you see, getting justice? High-profile cases are decided, which have religious connotations, reservations, center-state disputes, electoral rolls. All those cases, they get priority. Special benches are set up to decide that. But a litigant's common litigant cases remain pending, not just for years, I think for decades. That is the situation in litigation. Has a way been found, you see, to substitute this? Yes, people said arbitration. Arbitration Act was amended. It has been amended from time to time. And even today, as Dr. Manoj Kumar, the Additional Secretary in the Ministry of Law and Justice, he said they are reworking now the Arbitration Act all over again to make it more dispute resolution friendly. But as of today, has arbitration taken off in this country? I say no. Someone asked me, why do you say no? I say there are 2 reasons. One reason is judges, and then they said, second reason, I say judges. They say, what do you mean? I say arbitration in India has been monopolized by judges, cartelized by judges. Retired high court judges are flourishing because they are people who are appointed on ad hoc basis by the parties to arbitration. Arbitration, 1-day arbitration is split into 2 sessions, and for each session the client has to pay as if it was a full day conference. They have to pay the arbitrator, they have to pay the lawyers, they have to pay everyone. Litigation, arbitration has become very expensive and also very prolonged. So it is no longer an alternative to dispute resolution. So people are trying to find a way out. And that is where your role comes in. My generation, and the next generation, you see, after me, they have also failed in this respect. But the GCs, there is a big responsibility on the GCs, big responsibility on the young lawyers to encourage what I have been speaking on, samjhauta, settlement of this, encourage mediation. For mediation, actually, you don't need law. It change in mindset of people. That there has to be a change in mindset that yes, Let us resolve our disputes. Our President Murmu, last month only, she said one sentence which is of great significance. She said, let not your differences become disputes. That is the essence. That is like a challenge given to the legal professionals, whether GCs or the lawyers practicing in courts, that try to press on your clients that a settlement is the only way out. Not just reduce this backlog of cases, but as Justice Krishna Iyer said in 1978, he said, if you win a case, it is very satisfying. But if you settle a case, it is divine. He elevated, you see, settlement of disputes to that because he was referring to the ancient systems, ancient values, where we had consensual form of justice, not the adversarial form. Our panchayats, our zilla parishads, even during the Mughal times, Adle Jahangir, that is just Jahangir justice, these are well known. They have all been supplanted now by the British system of administration of justice. Anyway, we have to live with it because it is a part of our constitution. Nothing can be done. But within the framework of constitution, there is no disputes. That is the one message which I want to convey to our General Council. Keep having dialogues with the opposite parties. Don't treat them as opposite parties. So try to resolve the matters. And when the matters go to the courts also, try to resolve the dispute. There has to be give and take. That is the responsibility of the present generation of law students, of the lawyers, particularly the young lawyers, and more importantly, the in-house counsel. I see the role of in-house counsel as a very dominant role for the economic development of our country, because without the support, legal support of the in-house counsel, you cannot have agreements, joint ventures, mergers and acquisitions, protocols, conventions, nothing. Therefore, they play a very important role. Therefore, my appeal to you, earnest appeal to you is try to be the agents of this change of mindset of substituting, you see, litigation and arbitration by mediation. Then automatically you become legal leaders without being designated so. So thank you very much. Thank you.
Thank you so much, Dr. Basin, for your address. Thank you. Chaliye, we'll start with a topic that is much needed, which is strategic ESG and climate preparedness, legal, regulatory, and business imperatives. And to share the views on the same, while this at the stage up, please join in. Joining him is Shishir Kumar, Chief Compliance Officer and General Counsel, Asim Infrastructure and Finance. Joining them is Prantab, General Counsel and Compliance Officer, India, South and Africa. Joining them is Bharati Balaji, Director and General Counsel. Also joining them is Sormishta Ghosh, Group General Counsel, Chief Risk Officer and Chief Sustainability Officer, Strides Pharma Science Limited. Also joining them is Praveen Sharma, Associate Director, ESG Deloitte. And this session will be chaired by Mr. Sudhir Mishra, Managing Partner, Trust Legal. Please welcome them with your applause. to make it. I was just told due to someone for Sinaka sounds. Rest, we are all good. Yeah, thanks.
Okay, good morning. So, we have climate preparedness, not an easy topic to discuss while Dr. Bhasin has already set the stage on fire. He talked about how difficult it is getting, what is happening in our courts, and we have a panel where we have lawyers and GCs both. I will only say that last 3 months have been very tough for climate preparedness in this country. We have taken a about turn on environmental responsibility, whether it's the air pollution, whether it's the environmental clearance, whether it's post-environmental clearance, there is a sudden U-turn by the entire ecosystem of this country. And I have realized 2-3 things learning from my younger brother, Dr. Batra, that after a particular age, just to talk nice things is not a great idea. You have to say what is true for this country. So the air pollution, for accountability on for our international conferences which happen in COP and other places, it was virtually semi-disaster this year. In this background, the silver lining is how the Indian corporates have done their bit, because the country believes today, apna apna dekh lo bhai. Even it came from the Supreme Court also that even I have a problem. Even I am coughing, I can't walk in the morning. That's the kind of situation you are in. So I have a very powerful panel. I'll only tell you that climate responsibility, climate accountability is not any particular country's privilege, glamour, appeal. You are in a very crisis situation. I was with a scientist, with a lawyer from Baker McKenzie, 2 major general counsels from Europe's one of the top buying houses, and it was said on my face that it's not about India, about China or Russia. Even if you remove each and every person from this planet today, each and every human being from this planet today, your 2 degrees centigrade accountability will not be complete. You will not be able to adhere to 2 degrees centigrade. You have lost that momentum. Your coal consumption is not going down. Your vehicle consumption is not going down. Last point I'll say, I know I have a panel, but I was thinking I will set the agenda to them. You want a clean air in Delhi. Tell me which capital city in the world is in constant construction mode. The entire South Delhi, where we stay, I don't know about East West, just see all your houses, हर तीसरे दिन एक मकान बिकता है, उसको तोड़ के 6 फ्लोर बना दिए जाते हैं. धूल नहीं आएगी तो धूल कोर्ट कहां से साफ कर देगी? Same applies to your river. You will put the railing on the Yamuna river, but you will stop your car and climb the railing and put the plastic in the river. What kind of climate preparedness you will do under these circumstances? So let's not only think about the corporates, the government, or it's the civil society which has to take it up. And now the time has come, if you really do, which is where only personality rights are not protected by courts, but the fundamental right to clean air is also protected by the courts. So on this note, I will come first to Bharti. Bharti, you have seen from very close what is happening. Tell us how Indian corporate is doing it bit when a lot of responsibility from the courts and from the government is giving directly to the companies now. Apna apna dekh lo.
First and foremost, good morning everyone, and thank you BW Business World Media Group, Anurag Batra and his team, Dr. Lalit Bhasin, And thank you, Sudhir Mishra. And thank you, everybody, to be here on a Sunday morning. I completely understand how precious weekends are. It is indeed a pleasure to be here today to speak on a subject that is rapidly becoming the central of almost every sector. I can say that at least from my sector. So as India is transitional, what we see is ESG has evolved from what was a voluntary corporate initiative into a core business mandate. And as India is transitioning, accelerating towards energy transition and climate commitments, ethanol and distillery sector stands at a very defining moment. Now, this is the sector that I come from, and I can talk about it. And this sector is recognized as a critical enabler of ethanol blending program, where 20% of the oil fuel of the nation comes from this currently, and going forward, we're looking at 80 to 100%. This is also a strategic pillar. The sector is also a strategic pillar of India's low carbon growth, and a key contributor to lively economy and farmers' livelihood and farmers' income, and also a key significant contributor to renewable energy development that we're talking about, how its contribution to the air, water, etc. Now, this is what the reason I'm sharing this is giving you a context to show, to highlight how ESG has transformed from a mandatory, from a voluntary initiative to basically a mandate now, requirement, a business requirement. And regulators, investors, lenders, etc., policymakers, global supply chains are increasingly looking at industries with strong ESG profiles and a greater credibility on sustainability frameworks. This is, maybe I can take it forward.
They come to you because we have been talking about it. Is coming up now, and I want you to delve into it. The companies have been dealing with that, or they have been accused of. Now, blue washing has come the big phenomenon because I think all the supply chains, especially in Europe, they expect that the carbon emissions is fine. You will take care of, curate it at your end if they are seeking anything from India or the subcontinent. But they're also now talking about the S part of it, the ESG's S part. How will you be prepared where you're not making claims with regard to them? So blue washing and what are the risks associated on human aspect? Will you touch upon that?
Sure. Thank you so much. It's again an honor and everyone. So Sudhir, you asked a very relevant question because a lot has already been talked about climate. In COP also, in G20 also, the NDCs that governments have been putting up in terms of their own commitments. And as you said, that we already have set targets, there are deadlines, there are targets that have given by the organization, by the governments to the organizations also. Now what has happened, and over the last 6 months I'm traveling to UAE, European countries, Egypt, and some other geographies as well. And S part and the G part is also very much high in focus, where these two aspects are not being considered soft pillars, but are so critical that they can wipe out the entire organizational value very quickly. Now, coming to the point, such as the blue, aspect, you talked about the blue washing aspect. So in Europe, there is a law, that is a regulation that has come up, that is CSDDD, which talks about due diligence, making it mandatory for organizations, including their entire value chain, to conduct a human rights due diligence and environmental due diligence. Now, Indian labor law reforms that has recently been took shape, they're also covering all, some of it, bit of it, but one important aspect is that the liability is on the employer. Within this CSDDD, the liability also encompasses the civil liability, where anywhere, anyone can put up a litigation if the harm is there in your value chain. So social aspect is very prominent. The risk is very high, apart from climate risk. When we look at physical risks, we talk about climate risks. But when we look at transitional risks, We're talking about laws not only pertaining to climate, but also laws pertaining to governance and social issues. So,
But yeah, very good initial points. Mr. Kalra, I'll come to you, and I will like to know from your experience what our work is happening on ESG in India, which you like to highlight, and which you think puts us ahead. Because I also feel that I started with a little pessimistic note, I agree, but I know, I also said that the corporates have a story. When the 1,000 companies were told to file their ESG mandatory compliance, they went beyond that. Even the financing part of it also, now the banks are looking at the financing very carefully, that whether it's properly green curated. And more than curated, they are putting real meat behind it. So what are your ESG preparedness? What are your plans? How your company, and how is it done at your end?
Great. Thank you. Good morning, everyone. I think what we all have come to accept is that everybody is affected and we have to do something about it. And we have seen very recently how things are going to become more onerous for everybody. And if we don't come together, then I don't think we're going to make it. Probably 30, 40 years down the line, I may not be here. A lot of the young people will be here. But I think the broader line...
50 plus. Brent Johnson is telling us how to live longer.
Yes.
Dr. Batra is doing few therapies in that regard.
Yes. I think broadly, if I, let's say, take the construction equipment industry as an example, since I'm working here before I was in the car industry. Very recently, the industry went through the BS4 to BS5 norm. Just the beginning of this year, 6 months grace period, and then everybody has shifted. It's a gradual start, but if you look at it, it only applies to any equipment or machine that can ply on the road, which is the Motor Vehicles Act. Not on anything else. So if you're working and taking something at the farm, it doesn't apply. Or if you're working in the mines, it does not apply. There will have to be a gradual change there as well, and I believe there has been a miss there. And there are strategic reasons of it, of course, because you cannot expect a farmer to invest so much more money and into a new vehicle, which is, let's say, a BS4 or BS5 compliant. The cost goes up by almost 1.5 to 2.5 lakhs for a single tractor, and the farmers are not able to do it. Somewhere the corporates will have to again step in there as well on the corporate and the agricultural side of things, wherein, let's say, we take the pain and we say, okay, there will be a transition on the costs, the supply chain may bear it, and the corporates may bear it, and you can get it done. And that's also, again, a new approach probably that the financing institutions also, I would suggest, can adopt, wherein you're not overburdening the end user for those compliances. I think that is one. The other part is, as in how the board requirements become onerous. We were talking about greenwashing and blue washing, everything will happen. But as in-house counsel, general counsel, we'll have to guide not just the board, but the ESG teams as well. And we were just discussing that most of the ESG teams do not have lawyers. Whatever the road blockers, again, my request to everybody, and we'll have to, put our skin in the game as well, is that we'll help you build a better structure, better framework for the organization, so that you are confident enough to report, and then you can take away these issues that will keep cropping. I think the bottom line, very quickly, from my perspective, will be that we'll have to partner ourselves with the business. Otherwise, we'll not be able to make it.
Very well said, actually, because this is what is being debated throughout the world. And I was in Berlin 3 weeks back in a ESG conference, where it was a very strange kind of conference where the big four law firms, Becker McKenzie, Hubbard Smith, Cliff, were there, and the big companies were there. And I had the privilege to be the only Asian lawyer there. What they are talking is exactly what you just said. I'm so happy you are already discussing this. That ESG is typically from the safety and environment department. It had no connect with the legal department. The GC had no play in that. And then they realize, no, the labor laws are being talked about, the environmental laws are being talked about, the compliances and the corporate law principles also come in, that they actually started involving the legal, the GCs. And then the GCs started looking for the correct law firm which will advise you on an immediate basis. So that's the crisis, so I can assure you, this is the crisis Europe is also battling with, where the turf domain and the turf war, that whether it's an environment safety department thing or it's a legal department, because nobody is normally treated with due respect as in a non-profit center in every company. Company also very keen that not increase it value or something to be on a point. So Mr. I think you have already thought about it. Take us deeper into it. What is going to happen? Because there is another point which is coming, that ESG should not be just looked as, you will not succeed on ESG unless you live the life of environmentalism. And how a company actually goes into that skin will be the game changer. So what are your thoughts?
So, good morning, everyone. And it's a pleasure to come here on a Sunday morning. I flew in from Pune, so my carbon footprint is not great. But let me clarify, I work from home, so yes, I offset it in that manner. I guess I'm the only lawyer amongst the community we see who's actually a designated risk and sustainability officer. And I was designated even before in by my board. And so I should appreciate my company, the directors. And the risk committee is filled with only independent directors. So I should people your age are actually forward and they are proactive, because that is the board. I have independent directors who are HDFC Bank, who are ex-MD of Tata Chemical. They are all veterans, as they are called rock stars in their field. So in that context, let me say that I also came into conferences 3 years ago when all the lawyers said, this is not our job. And I think I was the only one who was already doing it and was designated. I have been a risk officer for more than 5 years. I have also been a sustainability officer for more than 3 years now. And I handle it globally. So if India, so let me start the bottom line I think we should follow is be the change. This is what is coming out from all of us here. If you want something done, you have to drive it. And that is precisely what is what I will say. And I'll just stick to climate preparedness because I could hear from everyone that they are focusing on the industry. I have tried to go beyond my industry, which is pharma, which will always be chemical driven, which will always have emissions. We all read regulations and laws were always there, environmental laws were there from God knows when. We do file pollution control board. So I come from an organization which is 90% manufactured in India and 90% export oriented. So we are part of the growth story, correct? For and if we have to compete globally, we will have to remain competent on the global standards. So it cannot be Indian government standards at all. And this is what I need all of you to understand is it is actually legal's job to do all of this because we are monitoring the compliances, correct? So when my organization has a UK law where it is mandatory to have net zero targets and we had to take it last year, I have already worked with my team to, and I have non-legal team members. I have civil engineers. So it is core ESG team where I have MBAs and engineers, environmental engineers. So it's not pure legal. I have business team members. So it's a small team, 4 or 5 members, but it is a mix of legal. So we all bounce off our knowledge against each other as a collaborative effort, which goes out into the 40-50 people globally who are contributing. So we got our rating. We are amongst the top 10% in our DJSI rating. So I can tell you it's all hands-on. I literally read my kids' 5th, 6th standards environmental study books. That is where all the knowledge on SDGs is. This is what we all have to do because I will not be here, but all of you will be here another 20, 30 years down the line. We have taken away the resources in our luxuries. Let me be very straight. But the youngsters will struggle. Your lives are going to be difficult. You have to take interest. You can't just say, I'm a lawyer, therefore I'll not know. You have to know the business of your company, you have to know the operations, you have to see what they're doing.
Perfect.
So this is all, I mean, I can go on and say that in my M&A checklist, I have climate risk assessments listed out. My team has done the climate risk assessment for all the manufacturing and all the global locations. So there are a lot of things which one has to do, biodiversity assessment, have the mitigation plans for those locations. Not only in India, for the global, in each continent we have plans, including US. So we are doing all of this. Scope 3, where all the supply chain vendors, and thankfully pharma is very regulated, so we will be collecting the data. So we have done all of that, which is why our ratings are in the 80s and out of 100. And we know that where we have to go next. But the fact is that the strategy we are putting today has to sustain for next 30 to 50 years. And that's the bottom line when we have already gone for assurances, third-party assurance, which will be mandatory in some time in India as well. And also SBTi science-based target initiatives. So everything is legal. I completely agree with my team members here. I call them team members, colleagues, going by Dr. Bhasin's words. There are no leaders from each other. So I was pushed to do this by my young colleagues. That they wanted to do ESG and they said, want to do it, I will lead the team. They are coming into employment only on the understanding that people their safety. So that's how it is today.
Thank you, Shamisha. Very well you respected, and that's why you connected with the entire thing, and you made every small incremental effort matters. Before I'll go to Shishir, I'll tell you on the spot, as the amicus of the carbon emissions matter in the Supreme Court, in last 1 year we had a small opportunity to make a change, and you will like to know that change, that whenever we used to go to hotels, and Dr. Bhasin and all of us have been discussing, we used to see minimum temperature as 17 degrees, 16 degrees. And you are seeing that entire world is now moving to 25 degrees, 27 degrees in Europe. Here a rickshawala is putting his rickshaw and auto rickshaw at 44 and 48 degrees. So I raised it before the Supreme Court, kept on fighting, and in June 2025 a notification has come from the Government of India that the default temperature setting for air conditioners will be 24 degrees centigrade.
Thank you so much for that.
So
Thank you.
that's what I'm saying, every small thing is now critical. Taking the clue from you, what she is saying, and I totally second it, that climate, we should not even think about a large gain. Like there is this village in Haryana where a girl child, and that has now become a movement in Haryana. A girl child is born, immediately everybody goes in giving, no cash and anything is given, a plant is given, and 750 rupees in her account, a minor account with the guardian is deposited. And the idea is that plant has to be taken care. So these dualities are happening. Yeah.
Sir, I would like to end on one more aspect, which again, it is my team's work. Monthly, I hold ESG talks where I have to speak. I literally learn and then speak on every topic. Life cycle assessment of products, right? 70% of your revenue needs to be done, and it is all contractual, by the way. If lawyers are thinking we don't have to do, we don't have to understand, trust me, these are contractual obligations coming from the customers, okay? And my team actually sits down in these negotiations. Responsible supply chain, responsible sourcing. For all these negotiations, my team is being called in nowadays because they have realized we know, okay? My team knows. And last bit, when I do this ESG talk, the last count 2 weeks ago of my audience globally was 800 people.
Brilliant.
Globally.
Brilliant.
I never thought that I'll have that type of audience within my organization. So forget about outside. This is why it just be the change, because we give them a list of things they can do individually, and it becomes personal, right? They do that in their homes. So I'm sure I always talk to the young generation, not to the old people, frankly, because we were taught by our older generation how to recycle products and how to do things, you know. Ghar ka pocha bana lo, purana t-shirt. That's how it works, correct? So we learned something, but in the middle we lost our path, or wherever we went into the profitability game or whatever, industrialization. But please make the effort, because I completely agree, it's 2 degree and 1.5 degree is not going to happen if we don't fight it out now. And that's a fact.
So coming to our last speaker, Shishir, both are classmates, and for the first time we are sitting together on a dais. And I just want to digress here because it's in 1989 we met, and we stayed in a room together, graduation together. And for me, it's a very special moment. He's the general counsel. I'm practicing, but it's such a beautiful thing. You talked about life, who will live and not live. It's a personal thing for me that we both are here after 5 years, and he lives in Mumbai, I live in Delhi, and I feel good. Shishir, what is your ESG story? Sharmistha has set the bar very high for GCs now, and I think BW conference will be remembered for this. And thank you, BW, for letting me know that it's not me personally. Yeah, Shishir.
Good morning, everyone, and thank you, Sudhir. Thank you, BW Legal, and it's an honor to be here. So I come from the infrastructure, and I wear two hats. First, I'm a GC and also a Chief Compliance Officer, which is from our. So there are a lot of things I have to look into, and before the infrastructure perspective, I'm a positive man, and I'll give you some positive also that yes, we are working on it. So definitely it's a long path to go ahead, but at the same time, the survey may be dated or whatever it is, but I can tell you that large companies have already, 50% of them have already embedded in their processes. That is one fact of it. 75% have already a sustainability goals. Yes, the data for the small and medium enterprise is some 29% and all, so but the work have already been done and all. I'll definitely take few minutes because, and before getting into it, would like to mention, and from financial sector, looking at the regulator's position, and I would like to clear perception about the legal being part of, not part of, that we are all working in India to fix it 2047. No industry is going to get, and this is giving the draft guideline stage, there are certain which has come up. You are not going to get capital unless you meet those ESG metrics. Please take it from me, and I can tell with conviction that you will not have, you need finance for any sort of projects, whether any industry, and we maintain IFC standards and all, but the guidelines have come. There is a guideline from RBI which is still in a draft stage, which mentions that unless you have climate risk in your processes and the risk management, that is one part of it. You have a task force for the climate disclosure, that is second. And government is working so much on green financing and the green bond. I can mention which some of you may not have found out, I can tell you what some may be aware of, is then one, we all know that we are moving towards, and I don't want to get into the data, how much we reduce the emissions and all, but from ASEM, I can tell you, like, we have funded 5.6 gigawatt of renewable energy and abated the emission of some 7.6 million tons of emission. That is on the dashboard we present to the board. Okay, I'll mention about the board perspective, how the independent directors are these days, because they are also observable directors. So the independent director is not just sitting on the board, they come for the meetings and all. We are taking them out in ASEM Infra, and likewise I feel all the institutions must be doing to see that the corporate social responsibility is not that you have given a check for whatever 2% that is required, but also to see whether impact assessment is there or not, and you have to present it. So it's not a tick of the box, that is one part of it. There are two aspects which I would like to mention. That one is the sovereign bond has come from the government of India, which is one of its kind for the renewable energy. Second, we are the only institution in the country which is funding, and you need infra if you have to grow. So only institution, and I know a little bit of perspective because we are the only one in private sector funding for both operational and the construction phase. So you need capital during the delays. There can be a number of reasons for it. You may have an ROW issue and various other things which can come up. You may have climate situations, so you cannot progress. Now, the Ministry of Finance and the World Bank has come up with a scheme for those developers who meet this ESG requirement, and they will give this guarantee, which is sort of a sovereign guarantee that you can complete it. So these are the initiatives from the government in collaboration with the World Bank and all. So there are enough positive impact have already been done.
You conclude.
Yeah, so give me a minute or two. So with respect to you need finance, when you need finance, you need to meet those. Now we all know about this BRSR, that core which has, and then finally again basis the FICCI, CIA and all, they have made it. So you have all 9 principles and all. Now it is given from the voluntary narrative, it has become audited. So you have to get into the intensity based and all, it has to be audited, third party validations and all. So, two points I would like to make. One is, and more from the infra side, but at the same time, one is with respect to SEBI, which is, yes, it has come from, it is percolating further. I can tell you with that. Second, RBI has come draft guidelines, which is going to come soon. We all know about greenwashing, that guideline which has come. You have CSR, and Ministry of Finance have come with a lot of initiative on the green financing and various other things, which are all towards that support. But this point, one, it will take time to come to a smaller companies because they have certain challenges, but if you don't meet those requirements, maybe initially out of 10, if you don't meet 2, 3, 4 or 5, you're not going to get money, so it will be difficult for you to move further. Okay. But 10 seconds, as enough to say, but I have restrictions on Sudhir. Only thing is that it's a positive move is already there, long way to go, but at the same time, wearing the hat of a compliance, we also have to ensure, and because regulators are after us, I think will be saying more positive things.
Yes, and on this note, I'll just, before concluding, two important things that, look, as a country, I started with a little to end with like a typical good Hindi movie where everything becomes better at the end. So there are achievements actually, and the courts have played a big role in this entire process. We are the legal ecosystem sitting here, and Dr. Bhasin is seen it all, and what he said, that what used to happen earlier and what is happening now. I'll just like to tell you what he meant by saying what used to happen earlier. So you had a 9% of forest cover at the time of independence. Today you have 17.8% of forest cover. It's because there is a matter called Godavari versus Union of India. It's still going on in the Supreme Court. Tomorrow it is going to be heard, because whether it's a air pollution matter, whether it's a biodiversity, whether it's tiger conservation, whether it's community reserve, tribal rights, protected area management. Can you imagine a country of 140 crore people has protected its species? The intervention of the court, and I have been part of this journey for 27 years. Earlier with the NGOs, worked on more than 100 PILs, traveled more than 200 national. And what is refreshing for me when I get a panel like this, people talk that they understand it deep inside, then you get corrected and you get emboldened. This is the country which is protected either for the world. You breathe, you have still chances to survive, because voluntarily in Delhi, 40% of people have shifted to electric bikes. If you have clerks, you know, earlier you used to get bills for going to Patiala House, Sajari, Kakaduma, and you have to reimburse the petrol bills. Now you charge your two-wheeler and they are fine, sorted. You don't have to deal with all of that. And that's why you are able to breathe little better, because two-wheelers, which were exempted in odd even, because they are important political voting class. Nobody will ask them to come on one day and not to come on another day. They were exempted. They are the people who voluntarily shifted, no government thing. Of course, the free electricity was a major impetus. So we have saved a lot. We have done the renewable in a record time on net zero objective. But the road is tough on air pollution and the rivers and our drinking issues. So we have tough challenges. I have always tried to maintain timelines. And I just want to say this was a fabulous panel. Dr. Bhasin is here. Before he says, I want to take his permission to take few of them in the CIA subcommittee for history. Then you say whatever you say. Yes.
You made reference to the role of the Supreme Court. But in a very recent judgment, 2:1, earlier judgment of Justice Oak was set aside, reversed and all that. So is it a good trend?
So that is what I'm saying. I started that the industry has been told, apna apna dekh lo. And that trend is absolutely shocking. I will tell you, my first reaction was, is there any opportunity left to do environmental lawyering? Because it took almost 2 decades to strengthen the environmental clearance process. And the core of that entire process was that the soul of the entire process was that judiciary will not give post clearance. If you have missed the bus, you have missed the bus. The Vedanta case, all the other cases went through that process. Now you are doing a fundamental shift. You had a 1994 notification for EIA, which came after the Bhopal gas leak. You had a 2006 notification which came up where states were given power to apprise the projects and clear. And many Supreme Court decisions said that it's sacrosanct, you need to have a prior environmental clearance. Now in a review petition you do it, and I have a feeling that if universities can have a 13-judge Keshav and Bharti thing, the 13-judge bench should sit and revoke this order at the earliest. Thank you. Thanks a lot. I'm deeply grateful for this panel. Deeply grateful to Dr. Batra for this opportunity. Thank you.
Thank you. Thank you so much to all our panelists, and thank you, Sudhir sir, for moderating that. Thank you. So the next one, it's on white collar crimes 2026, the new age of enforcement. And to share the views on the same, please join me in welcoming our panelists. Up first, Senior Advocate Pramod Dubey, Supreme Court of India. Senior Advocate Vivek Sood, Supreme Court of India. Joining them is Advocate Sana Rais Khan, celebrated Supreme Court lawyer and founder, SRK Legal. Also joining them is Advocate Devesh Tripathi, lawyer, Supreme Court of India, and this session will be chaired by Vaibhavi Sharma, Associate Partner, Prosol Law. आपकी तालियों के समक्ष उनका स्वागत करते हैं. It's a Sunday, supposed to be happy and relaxing. Don't get so relaxed in your clapping. Also, let's try again and welcome them.
Please, sir, please. Morning, sir. Good morning. Hello.
So good morning, everybody. Warm welcome to one and all. So that's our lovely panel for the topic White Crime 2026, New Age of Enforcement, PMLA, SFIO, and Digital Fraud Investigation. So this topic is new to me, not because it's white collar. We've been discussing about white collar years now. But today we are going to talk about the new age of enforcement, which includes digital fraud investigation as well, which is very new. And since we are living in time where economic offenses have transformed dramatically, transactions are no longer limited to bank accounts, but they move through mobile wallets, cryptocurrencies, NFTs, and digital ledgers. Corporate fraud today is not only about account books. It can be coded into cloud systems, hidden in algorithms, and spread across layered subsidiaries and shell entities. Cybercrime is industrialized with technology. Fraudsters are moving faster than investigative agencies. In response, India has witnessed a wide range of PMLA intervention. SFIO has emerged as one of the most powerful corporate investigative body. And cyber cells, ladies and gentlemen, has played a vital role in catching the fraudsters who are spying away and hiding amongst the coded networks. The central question that we will discuss today as we talk about the new age of enforcement will be, can investigations evolve as fast as the criminals? Or can law evolve as fast as technology? On that note, let us begin the conversation with our first speaker, and that will be Senior Advocate Mr. Pramod. My question to you is, do you believe that the reverse burden of proof under PMLA remain justified in today's new high-tech enforcement-heavy environment? Or should the Parliament re-examine the safeguards, considering because all the substantive offences on which PMLA stands are primarily under trial. They are not decided as yet. So over to you.
Thank you, Babu, and thank you, BW Legal. And my sincere respect to Mr. Bhasin, the Bhishma Pitama of the legal fraternity is here, Dr. Batra. This reverse burden in the PMLA is basically exception to the general law. So they incorporated section 24 of the PMLA. And you find this reverse burden is not only PMLA, almost in all special statute, all special act, there is a presumption, and then reverse burden, and it is always debatable whether the reverse burden would be adjudicated at the time of the remand, time of the bail, time of the charge, during the trial. So different judgments on this aspect, but ultimately this issue was decided in Vijay Madan Lal Chaudhary by the Supreme Court. That celebrated judgment as on date it is in existence, though there is a review is pending and arguments yet to start in the review. But be that maybe, today the reverse burden section 24, one thing we must understand is the reverse burden will come into force only if the foundational fact would be established by the prosecuting agency. So first, onus the burden lies on the prosecuting agency to prove the case, prima facie, so that the burden will shift to the accused or the defense to discharge the burden. On that aspect, the Supreme Court has gone far away. Let us say the Supreme Court was that even at the time of the bail, once the twin condition is there and the burden is on the accused, so the prosecuting agency will supply all the documents which are received. Though there is a law that the document is relied upon and filed by the prosecutor. So the reverse burden is not as small, it has basically enhanced the scope of the adjudication. That's why the court passed the order, you supply all the documents and then the accused would be in better position. Even you have just mentioned the SFIO. So there also you will find the twin condition, the stringent condition. You have mentioned the digital crime, and this is of the technology and the fraud. Today, if you see the Today Times of India, there is a very interesting article which is pertaining to BizLaw. What the new way of the commission of the offense is, they are sending the e-invitation, like the marriage invitation, other things, and the moment you open the invitation, the money will be transferred from your account. So this is also the precaution. Today Times of India. No, don't open the invitation. Suppose Baby you are sending me,
Absolutely.
and I opening my WhatsApp transfer.
Already
So
gone,
this is
yes.
very difficult phase we are going to. And in India still we are lacking. We are lacking. We don't have the infrastructure. Our agency, enforcement agency are not well equipped. The government must spend some fund resources, the proper training. The officers are not duly trained. Every day we are coming across this kind of and forget this, white color, blue color. Now the digital offenses, technology offenses, cyber offenses, this global is now suffering this. So this is very important. Again, I am coming back to your reverse burden section 24. Not only 24, there is also section 23. 23 as the PML Act is also a reverse burden. So reverse burden is not a small thing, but there is one judgment of our own High Court Justice Bambani, and Mr. Sood must be knowing this judgment. Justice Bambani has written beautifully what is the impact of the reverse burden, how it is going to impact the right of the accused. And he has tried to balance the reverse burden with Article 21. So you cannot ignore Article 21. So the genesis of the entire test would be Article 21. And the judge of the Constitution would be paramount consideration. But yes, the reverse burden is a very difficult task for the defense and for the accused. Very easy for the prosecution to argue for the court that there is a. Despite we are coming across every day in the PMLA matter, SFIO matter, every day the first argument that this is the reverse burden, they have to satisfy. Despite law is settled, they are not aware, but the judges are also prejudiced, and we are suffering a lot. So it is giving a lot of trouble these days.
Absolutely, sir. Having said that, I remembered one of my matters in which I was cross-examining a CFSL expert from the chemistry division. And when we cross-examined that expert, we realized that the machines and the equipments they are using for the current year 2023 examination, forensic examination, that machine year 2021. So, rather 2001, rather. So, that is how we realize that in 2023, the machines that our forensic bodies are having, they are of the year 2001, 2002. So that is the current situation of our investigative bodies, and we need to really move ahead of time. And because with AI and the enforcement and digital frauds happening with this energy, we need to really buck up.
For lighter side, baby, I will take your permission because you are the anchor, you are old. I am very happy to hear from your mouth that you were cross-examining because it's a second generation. One thing I would like to mention, baby's father, Mr. Harsh Sharma, is one of the best cross-examiner in Delhi. That is destination every day. No one is coming forward. They are least interested in conducting trial, most interested in doing the appellate work. But until you have the experience in the trial court, you can't become a good lawyer in the criminal side. Mr. Basi is here, and my senior, Mr. Siddharth Luthra. He started his career with Mr. Basi's chamber, and he was assigned to the trial court work, civil work, and the criminal work. That's why he's here. So that I must appreciate your effort. You are doing the cross-examination.
I enjoy cross-examining the most. Thank you, sir. I enjoy cross-examining the most, and that is the high point of my day when I have to cross-examine a witness, and later in the office I prepare for it, so that's wonderful. Thank you, sir. So having said that, so enforcement is one side of the story, and being defense counsel, flip side being the rights of the citizens. So having said that, my next question will be to Senior Advocate Mr. Vivek Sood. Sir, in your opinion, do you think is the current statutory framework doing enough to balance ED's need for quick attachment versus the rights of the citizens, the accuser's right to operate its businesses? And also, sir, if not, what changes do you think the coming year deserves?
First of all, I'm grateful to this forum to bring me here. I think this is the second time I'm here. It's a very interesting question you asked. Let me just give a backdrop of how the statutory framework of attachment under PMLA functions. First of all, when a search and seizure is to be conducted, it has to be based on information having connectivity with reasons to believe. So there has to be a reason to believe before a search and seizure operation is conducted.
Absolutely.
And then we come to provisional attachment. There again, you must have reasons to believe that PMLA, the crimes, the proceeds of crimes are there, or money laundering crime has been committed. Then we have the provision for show cause notice. Again, reasons to believe have to exist before a show cause notice is given. Then the matter goes into adjudication. An adjudication has to be done by an authority. It's a quasi-judicial authority. It's not an administrative act. Again, there has to be judicial application of mind before the provisional attachment is converted into an attachment, or the freezing, retention of assets have to take place. An order has to be passed in writing, showing application of mind. Now, with all these checks and balances at every stage of the PMLA proceedings, from search and seizure to provisional attachment to retention of records to attachment, show cause notice, there are so many checks and balances which protect the rights of the accused and also balance the same with the right of the investigating agency to find the truth. In my view, the statutory framework is in place. And apart from the statutory framework, we have an independent judiciary, and you have a gamut of case law that has expanded the meaning of reasons to believe, application of mind. It cannot be perfunctory. Reasons to believe must be based on relevant factors. There has to be judicial application of mind, cannot be arbitrary. Reasons must be justifiable. There has to be evidence in support of the reasons to believe. That evidence and material has to be tangible and credible. So we have enough checks and balances to protect the rights of the accused under the PMLA regime, that is the PMLA Act, read with the case law. However, the ground realities are very different. Now that's where the problem is, and I will urge the government to conduct some kind of an audit on how the PMLA regime is being implemented at the ground level. All these principles of reason to believe, etc., are only being applied in letter, not in spirit. We have seen, Mr. Dubey and I, we appear in some matters, for different accused, and we see it every day, that at every level, the principles of law, the principles of justice are not being applied. It is very perfunctory. It is very one-sided. The adjudication mechanism needs reforms. Some accountability has to be enforced. There has to be some audit of what's happening, because all these stages are being very mechanically applied. In fact, one also observes that even at the appellate stage, when you go and appeal before the appellate tribunal, there also you find a forward of these principles being applied in letter and not in spirit. So while the statutory framework is robust, the implementation at ground zero needs imperative reforms, so therefore that is my expectation in 2026. Now the last point I want to make is that we have seen that where the ED is investigating proceeds of crime, very frequently they allege as if the entire business is a proceeds of crime. So they are not able to discern and distinguish between what is legitimate and what is proceeds of crime. Now that hurts the economy, that hurts the corporate world, that hurts bona fide buyers of property, bona fide operators, business operators. So therefore I will urge the government to take stock of the ground realities and improvise this implementation at the ground level.
So thank you, sir, for laying out a detailed analogy for a foolproof. Please, sir.
Just he has elaborated reason to believe. The first stage, reason to believe. Second, adjudication. If there is 100 matters before the adjudicating authority, out of 100, you won't find in single order passed by adjudicating authority where the reason to believe has been dealt with. And 99, even 100 attachment is confirmed with one paragraph. What order is coming these days? Their case, the reply, rejoinder, one paragraph, last order confirmed. There is no application of mind, and the situation we are going through, it's a very miserable situation. We are arguing everything not dealt with. So-called notice being issued by adjudicating authority, no reason to believe. Same copy-paste, order is passed, 100% confirmation of the attachment.
Yes.
100%.
Yes. So when we file appeals to the appellate tribunal PMLA, our main ground of that appeal is that the order by the adjudicating authority is not a reasoned order. They've just stated the facts of the case, the reasoning by the prosecution, the defense by the defense counsels, but the order lacks what reasons have the adjudicating authority applied and how they have applied their mind and how they've come to the conclusion that yes, these are proceeds of crime and we need to go ahead with the ECIR. So, very well highlighted, sir. And with that, we had, Mr. Sood just touched upon the corporates and how the corporates need to function in the year 2026. So, having said that, I'll move to the next speaker, Advocate Divesh Tripathi. So, what do you think are the common mistakes corporates are making while dealing with enforcement actions, the organized crimes and the frauds, and how can they avoid them and deal with them? Over to you.
Thank you for inviting me here. So first of all, I would like to take a leverage that there should be reasons to believe on accused also. That is completely missing. So I would like to start my submission here. Whatsoever we submit in our reply, in our submissions, quasi-judicial authority is completely non-judicial kind of authority. Right. So it is a kind of defunct state of mind that you are not discharging your duty well So what kind of judicial authority? Suppose it is quasi or judicial whatsoever, you are not performing your own duty. So what kind of things we have to opt? My reply, first of all, legal awareness.
Right.
The problem with our corporate system, and one of key speaker told very well
Right.
in previous session, that for law, there is always less budget. Okay,
Absolutely.
so we are facing this kind of things everywhere. I am representing to government side also since 2017. You know how government pays to councils, and not like that, but corporates are also having very less interest to pay to advocates. It is again a kind of different debate.
That's a very different challenge that we
Yeah,
are facing,
yeah.
and that's maybe a part of another thing.
So this is this is something legal awareness. Whatsoever in-house counsel, even in India, it is very unfortunate, and I am not hurting anybody's sentiment, any professional. Like we are having anything, any problem, still we have some convention that do not go to consult doctor, go to chemist shop, medical store. So something like that, consult your CA. CA is something, it's okay. I am not challenging and I am not debating on this. But something like expert domain should be there. Suppose you are having PMLA case or FEMA case, you should go there. At least in metros, you can avail that kind of services.
To an expert lawyer
To
who's
an
dealing
expert
with,
lawyer,
absolutely.
domain expert, that is number one. Number two, we always see some kind of nuisance on behalf of our clients, big corporates, that they have called me, they have given me notice, someone, since it was FEMA. So we did not take it very seriously because FEMA is civil law, it is not Faraday. So we went there, but all of a sudden it was converted to PMLA. So after doing some more kind of creating mess, you are coming to us, and then we have to do something to cure that situation. So law enforcement agency, our seniors told very well how they are doing at all. But for this side also, there is some connect the dot which has to be cured. Because if our threat is so big, if there are so much challenges, then our preparations also to be accordingly in the reciprocation of that kind of big challenges.
Absolutely.
So one is awareness, second is expert domain to be consulted, and third, whatsoever digital records you are having, you have to scrutinize those things. Unnecessarily involving your mobile phones, your data, your email ID, because what is the first challenge? If there is any search rate, anything, they always try to snatch your phone. They are
Absolutely.
not concerned with you, because phone is the key. So many things to be evolved by the corporate side also, how to meet these challenges. So this is my point.
Absolutely. Thank you, Mr. Tripathi, for contextualizing it. And the corporates should really, I think he has pointed out some very great points, that instead of waiting for the matter to slip out of hands, in the first instance, just go to an expert. That's there. So having discussed that, nowadays we are also seeing a lot of digital and cyber-enabled frauds, where criminals operate digitally. As Mr. Tripathi has correctly pointed out, mobile phones are the key. And technology itself has become both the weapon and the battlefield. The crimes are happening digitally, and the data is also present digitally. So moving on to our next speaker, Ms. Sana Rais Khan. My question to you, Sana, is, in your opinion, what are the most dangerous digital frauds and techniques emerging in the year 2026? Is it the deepfake KYC or real-time payment frauds?
So each one, the unsettling truth is that each one is a different face of the same monster. Let me deal with the deepfake KYC first, which is AI impersonation. Since I have seen its impact, not just on the financial sector, but also in the world of personality rights, while we were dealing with case of Mr. Kumar Sanu, what was the most shocking aspect was not just unauthorized monetization of his identity, but also manufacturing of his likeness, like his voice, his expression, his emotions were cloned to sell brands which he never endorsed. Though we secure protection of his personality rights, the struggle still continues because we've just recently filed for similar suit for protection of personality rights for Shilpa Shetty, and we are just in the process of filing for Ravina Tandon. What we have discovered is deepfake and obscene videos and pictures created to look real, to feel real, to sound real, somewhere. And the objective does not necessarily need to be monetary. The objective could be harassment, defamation, because public image, unlike financial transactions, cannot be reversed. Then coming to synthetic identities, what you just mentioned, that totally fake identities created through stolen data, fabricated information. These identities can now create accounts, can pass verification check with a real person even, behind them. Then coming to payment fraud, of course, that's the most damaging one, because through a manipulated link or through a clone voice call, the entire money gets transferred, and then there is no reversal. So of course now AI affects everyone. It's not just a big city problem. It affects students applying for jobs, or it even affects a basic shopkeeper having a QR code. Even recently, teachers, a teacher's voice was cloned to demand fees from the parents of the students, and that's how normalized it has become. So, and now, even emotional manipulation is also automated. Like
Not to forget digital arrest. That is one of the
exactly,
things, yes.
digital arrest. Even emotional manipulation is also now automated. Words like, Papa, please send it urgently, I need it urgently. All these words are used, so it looks very real, it looks like family, not like a scam. So, and of course now AI is scalable. One voice can be used to make thousands, one face can be used to create, multiple videos, and just one to open dozens of accounts. So, what is needed now is, of course, investigative and judicial framework that has to evolve more rapidly.
Right.
Because now, what is the need of the hour is that digital identity in India's, digital revolution, digital identity should be as protectable as our financial assets. And the victims of AI fraud should be given faster legal remedies, should be, there has to be a faster takedown mechanism across social media platforms. There has to be a specialized cybercrime courts, and there has to be a digital literacy, not just at grassroots level, but also, in even not just in metro cities, at grassroots levels. Because now identity just cannot be accepted like that. It has to be verified.
Absolutely.
Today, in an AI era, the real battle is not between human and machines. It is between truth and manufactured reality. Because, just like how identity can be faked in seconds, even the protection should be delivered in seconds, because law cannot lag behind technology. As I believe that in tomorrow's world, identity is going to be the new currency.
Absolutely.
Thank you.
Thank you, Sana, for illustrating just how sophisticated and global scalable digital fraud has become, and how enforcement has to race against the time with AI-driven techniques and to enable the threats and combat them. So I'll go back to my panelists one by one, if they have any one line to sum up today's session, and we can start with Mr. Sood.
In one line, I would say that we need to improvise the implementation processes of the PMLA regime, and secondly, accountability. We still have law enforcement agencies who are following a very colonial approach. So I think there has to be accountability fastened on the law enforcement agencies. This is my take in one line.
Sana, what about you?
So our future is definitely not free from risk. So I believe that law, enforcement, technology, and awareness should definitely be one step ahead of those who misuse AI.
Absolutely. can use this one.
The root cause in our country is, Sana has just pointed out some problems and regarding the AI, other things. In India, the problem is we don't see the future. We don't have the anticipation. We don't have the vision. We start working the moment the problem is there, crisis is there.
Right.
If you see the very popular series that's Last Survivors, Netflix, you'll find the entire investigation is based on the technology.
Yes.
Much prior in time, US has started. Now we are following their path in 2025, 2026. Now we are talking about this kind of the problem. You would have imagined then and there, and you had the mechanism to come out from all everything. You have not done anything. Now the problem has started. We all have started suffering. Then is a hue and cry everywhere. So the government should go ahead to visualize the problem. This is not only the technology problem. When you see in Delhi, the traffic problem. We don't have the vision how the traffic is going to there in Delhi after 5 years, 10 years. So what is the remedy? You'll find first there is a construction, then demolition, then construction, then demolition. So this kind of the problems, you don't have the solution unless and until you have the predetermined mechanism and the policy.
Absolutely. Devesh, what are your parting thoughts?
Since it is an opportunity to give a concluding statement, so I will not take much time.
Please.
I would like to say that reasons to believe may be written somewhere in any PMLA anywhere, but people should be having reasons to believe in the reputation of our judiciary and these enforcement agency, then only the purpose will be resolved. Until unless our public is not having reasons to believe in the honest functioning of our systems, it is all the defeat of all the purposes and letter and spirit. So to develop, evolve something that people should have the reasons to believe. Thank you very much.
Thank you. Yes. Lalit sir has a question and we'll go up.
Thank you. It is an observation, not a question. I feel enforcement is of the law which is applicable. In my view, to protect the citizens of this country, and particularly to the instances which Sana pointed out about deep fakes and all that, I think law is inadequate. It requires some fundamental amendments in the law to give some further protection to the citizens of India, not to commit crimes, but to protect their rights.
Yes.
Sir, just I will like to supplement. Here, there you will find the Sana has just pointed out, celebrities are coming to the court for the protection of their right. What about the normal people? We intellectual, and I have already mentioned in presence of Mr. Basin when there is some talk, we are always talking about being the intellectual, the human right. Why we are not talking about the right to be human? The public at mass, the person who is not having all the resources, what about their right? So Mr. Basin has rightly said, why don't you implement the law? Why don't you bring the law? How many cases would come to Delhi High Court, the protection of the right of the individual and the burdening the court every day on the same point, same aspect. One side we are crying the pendency of the matter and we are increasing the pendency of the matter by this kind of the cases. So I would also suggest that the government should go forward. The session is around the corner. It's not a big deal. Let them bring some legislation and get it passed so that everyone will be feel secured.
So I will just conclude the session by saying that enforcement, when we talk about the new era of enforcement, white collar enforcement belongs to some changed laws which are more enabling for the citizens to find the correct protection that they are today wanting. and also to the best intelligence. Because the intelligence is something which will protect us from the upcoming threats that the country is going to face. So with that note, on behalf of the forum, I would like to extend thanks to all the panelists for their insights and valuable feedback, to the organizers for the opportunity, and to the audience for their keen interest and involvement. Thank you.
Thank you so much, ma'am. Picture, please. Aye. Thank you so much. Thank you, ma'am, for moderating that. Thank you. Thank you. Shirley, keeping it on time, we'll quickly move with the next one, which is navigating high-stakes business disputes in a regulation-heavy 2026 economy. And to share their views on the same, let's please welcome to the stage our panelist, Maresh Singh, senior partner, HASA Advocates. Joining him is Manish Lamba, General Counsel, DLF Cyber City Developers. Joining them is Shweta Bharti, Managing Partner, Hammurabi and Solomon Partners. Joining them is Pramesh Diwan, Managing Partner, Lex Favios. Also joining them is Sachin Mishra, General Counsel and Company Secretary, Tata Consulting Engineers. And this one will be moderated by Vivek Narayan Sharma, Arguing Counsel, Supreme Court of India. Yes, please welcome them. Krish, can you call other members from outside? We'll do that, sir. We'll do that. Abhay, please. We'll call them. Ravi, that's your pictures or if you want.
Very good afternoon to all of you who have taken their time to attend today's event. We are going to talk about navigating high-stakes business disputes in a regulation-heavy 2026 economy. Well, the very topic when we talk about the regulation-heavy 2026, so I think last 5 years have been quite regulation-heavy. Am I right? So it is all going to be regulation heavy in the coming another 10 years maybe, till the time the dust settles, because we are maneuvering in a new dimension. We all know when I talk about the new dimension, it's the AI which has taken place in the seats of all the corporations, systems, which is unregulated till now. And more so in relation to the domain of legal sciences, it is totally unregulated. We have DPDP Act now in place. We have DPDP rules which are going to be implemented in some time. But at the same time, those would not be good enough to really regulate the field of law. Like in different domains of industries, we see that there are regulations with regard to the security concerns, the applications, the compliances in relation to the information technology. But that is not there. If suppose tomorrow an evidence has been extracted, taken on record and somebody manipulated, there's no safeguard. So you may not be a convict, but you can be declared as a convict. You may be a convict, you may be declared as a non-convict, because somebody has changed the evidence itself. There's no regulation to that effect. So while we're talking about the regulations, last year Government of India had taken a policy decision with regard to in all the matter which are more than 10 crores of worth of contractual value. Arbitration clause will not be there. They went dimensions to mediations. But at the same time, Indian robust system is not robust with regard to mediation as on today. So while we have omitted the arbitration clause, though in the past contracts it is still continuing, but at the same time CPWD, PWD have removed the arbitration clause per se now even below 10 crore of contracts. So we would be talking, maneuvering in this background, and there would be other, ideologies, other thinking processes which my panelists, my learned panelists would have. So my first question would be to all of you, one by one, we may start. So I would start with Shweta, my dear friend. So as a stakeholder, what challenges you may face in 2026 while operating in such a regulation-heavy economy? Your perspective as a lawyer, as a owner of a law firm. So it would be great enlightening your view for entire audience.
Sure. Thank you so much, Vivek, for the question. Good afternoon, everyone. I think, because the batting starts from me, I get the field to play properly and completely and thoroughly as much as possible. When we say regulation heavy, look at the kind of regulations that we have at the moment for initiating a business, running a business, and even to close a business. There's just way too many regulations, and what is happening in the process is that there are regulations with respect to your local laws, with respect to your state laws, with respect to your central laws, and if you are also having your business cross-border, then international laws. So to have a proper harmony in this kind of an environment where you have multiple challenges with respect to your regulators, it is very difficult to find harmony around it. The second key challenge that I see with respect to being so regulation heavy is the lack of consistency. Because we are talking about the local laws having a central understanding, the central laws having a certain understanding, and your state laws having a certain understanding. So I think there is a lack of harmony. So when we are running the business, if with this kind of regulation heavy environment, it becomes very difficult at that point of time to be able to harmonize all of these laws. And then third, which is the bigger challenge, is unpredictability. I think, yes, last week, in fact, early this week, on Monday and Tuesday, I was in a conference which was on gaming laws. Now there is a certain sense of despondency because of the manner in which, the whole real money game has been stopped. Whether it is right or wrong, I am not getting into the moral debate. But the fact of the matter is that through a certain law, you are able to stall the entire business. So I see there to be a lack of predictability when it comes to the kind of regulations that we have. So some of these challenges we really need to work around to be able to make the business more, more easier, as we say, that ease of doing business. I think unless and until we are able to provide a certain predictability, certain harmony, and certain reduction in terms of the kind of, compliance challenges that we have, it will be difficult for the organizations and businesses to be able to manage in this kind of a regulatory framework.
Well, wonderfully explained. Predictability is the key. If the system is predictable, you know what has to be done and what is the outcome when you do take a step in a particular direction. And in particular, I would talk about the litigation. We don't know the predictability. Means matters are listed, they don't reach in the court. The dates are given for another 4 months, 6 months, 8 months, and then again the same thing will happen over and again. So this is quietly unpredictable. So we have got the key stakeholders here, the law firms, 2 owners of the law firms, and 2 general counsels. So my next means the same question I would see from the perspective at the receiving end, because the General Counsel for DLF, Mr. Manish Lamba, is here. So how do you think, Manish, that is the regulation heavy system is affecting your company and your lobby as a whole?
So whatever I speak has got nothing to do with my past, present or future employers. So this is one caveat which I would like to put, and I would take the cue from what Shweta very rightly said. See, what has happened in the last 5 years has not happened in the last 50 years. So therefore, if you are expecting that everybody will have a free field day, that is not to happen. That is not to happen for a simple reason that we are hearing a new world order which is taking place. While we are sitting over here, at least 3 wars are going on. So one is for 4 years and the other we don't know whether there is a ceasefire or not. And the third big war which is going on is that trade war which is going on in the world. So while the world technologically is getting completely integrated and there is free flow of men and capital and material, but at the same time new barriers have come up, whether it is US, and if you look at it, we have new barriers with respect to the movement of men, material, and even software and everything which you can think of. So we are living in a new world order. 4 years ago, nobody had heard about AI, the manner in which we hear it now, although AI is, as the expression was actually used in 1960. But in the last 4 years, what has happened is with the generative AI, the amount of interest in the application and the manner in which it has done, you cannot leave the world unregulated. So we will have to learn. Regulations are like sometimes like your traffic lights. Now, traffic lights stop you, slow you, but if they are not there, there'll be a chaos outside this hotel, which I face every day while going to Gurgaon, and those who go will realize that what kind of a chaos which is there. So we need some kind of a regulations which are there, and when you will see a company like today, the Magnificent Seven, the large 7 companies, out of which 2 of them have their market capitalization which is more than half the world's GDP, or maybe we were thinking that which company will, whether Google will reach $4 trillion first or the Indian economy, whereas Google and the other companies have reached first. So therefore, these regulations and the manner in which AI is going to be there, the kind of information, data which is going to be transferred, the manner in which today crime is happening, the manner in which commerce is happening, we are going to live in a world where regulations are going to be there. The only difficulty is generally people think that everybody is supposed to know the law. That is not possible anymore. Whereas the other maximum which remains true is that ignorance of law is not an excuse. And therefore, by the time you realize something and you try to settle, you have a new regulation. And this regulation has a problem now worldwide. In US also, the number of regulations which have been amended or deleted are not even 5% of the new regulations which have come in the last 5 years. So so it is a lawyer's paradise. I can't be complaining much on both sides. We have to live with them, we have to improve them, and that's sadly or truly what it is. Life is going to become more complex, and in this complex world, instead of laws, because laws can't change every day, regulations can change more frequently than the laws, and they are the part of that administrative law. And that book by Wade, which was finding dust, today the entire administrative law is going to be something which the young lawyers must look up to. That's what I feel. It's a free day for lawyers.
Well, very nicely explained, Manish. It's wonderful to hear you on the count of how you have presented your view. You are absolutely correct when you said that regulations are going to be, helpful in the coming scenario, but at the same time, there are so many regulations in all the fields. Definitely they would be there. but then burdening with regard to the processes in concerning those regulations. So one regulation is there, but at the same time it contains several processes. So we can always reduce the processes involved in the regulation. So taking the cue from you, I move to Mr. Sumesh Devan on the same question as a stakeholder, what challenges you may face.
Yeah, hi everyone. So, as a stakeholder, we typically see, the biggest challenges, we as a nation are heavily regulated. And there have been numerous surveys when you do a comparison with Singapore or a lot of countries. So we have MCA, ROC, SEBI, labor laws, so the compliances, and then obviously, listed companies have many more regulations to follow. So typically, as a stakeholder, what we see is, there is no sense of demarcation between a mid-size or a large company, unless, of course, you are not listed. So the number and quantum of regulations, and now, of course, we have a data protection regulation which has just come in. So the quantum of compliances and overlap of regulations is something that discourages companies to set up businesses. And that's the reason we see a lot of companies will typically still prefer having their operations from Singapore or overseas. Because it may be setting up of a company, a quantum of compliances, and then also as lawyers we always see, we are always, every week we have to be aware, because every end of every week there are new regulations coming in. And as Manish rightly said, not being aware of a regulation is not an excuse. So the companies, I think I always say the companies are always on a back foot, because the compliance cost is very, very heavy to comply with every piece of regulation. And I believe every company, we statistically get spending 30 to 40% time only in compliances. And probably, I'm sure, as we've heard from a lot of in-house counsels, instead of, growing businesses, majority time is, is in firefighting, is ensuring are we compliant or not compliant with regulations.
Well, we come to the compliance. More than the compliance means the cost of compliance, it is the cost of non-compliance, which takes us to the new preview of the DPDP rules. So my question, next panel, Mr. Amrish. What are the gaps and opportunities you see in current DPDP framework, more so particularly in relation to the compliances and non-compliances? How do you see it?
Sure. So first of all, greetings BW audience and Basin. I have a long association with him. I have not worked in his firm, but I worked along with him. And as ardent cricket player, where he is the chairman of the Self Cricket Organization, I have often faced his regimented, way of tackling. And, in the inaugural speech, the way he's clarified things, I think whoever missed it, it's a great loss of an opportunity. Now, so far as DPDP is concerned, it was really required because, it needed to be aligned with global systems in place. So that came into being in 2023, and with the rules now along with 25, they have created a full spectrum privacy regime. Now, what are the objectives? The objectives are very clear, that they must align closely with global regimes such as GDPR and PIPL. Then there is also a 18 months transition period. So within that 18 months transition period, they need to update their IT systems, they need to appoint their DPDOs, and they need to overhaul all their internal policies so as to help build consumer trust and enable cross-border transfer of data and all of that. So we need to look at the essence, the need of the essence. There is no bar of sharing of data, but it's how you take it, how you process it, and what are the checks and balances which come into place, just to know that this act being citizen-centric has completely lives up to its legislative intent. So therefore, it is very, very important that consents are taken, then the withdrawals are taken, then cancellations are taken. It's a tough call. It is evolving. it has to evolve a lot. You know, I mean, it has to be seen that at what plane and level this is being construed at. You know, it will, at the lower level, you will have these individual customers, and at the higher level, you have these global companies from abroad taking data, processing, and so on and so forth. So all of these are going to be very, very well regimented. Now, what are the basic, you know, some of the gaps, you know, that we see currently is that, you know, there are unclear timelines. So, you know, nothing to really panic about, because as this is in an evolution stage, all these things will be sorted out. Then, of course, you know, there are certain exempted limits. So that also needs to get clarified. Then, you know, then you have certain consent-related uncertainties, you know, with regard to children and disabled and so on. Then, you know, breach notification confusion, you know, so that also needs to be sorted out. And, you know, there are security safeguards without standards. So whilst it says that there has to be reasonable security safeguards, it does not detail what those entails. So sectors like banking and telecom, they need, which are, you know, which are quite closely intertwined with cyber city laws and so on, they need to get streamlined. And, you know, then there are regulatory constraints and overriding clauses, you know, that this act has been made to be a predominant act. So how it configures with the other legislations will also be very, very important. So that's what it is.
So thank you, Amrish, for pointing out certain deficiencies, anomalies, and at the same time also pointing out certain very important features of the DPDP rules and act. And I think this is at a very nascent stage, and as the technology will keep on changing, we will be in constant need to change the DPDP rules or act, and maybe some new rules and act with pertaining to the AI. And I envision a scenario maybe after 5 years, 10 years. Today we use binary computers. Consider a scenario when you have the quantum computers. That would be a great leap towards you know, development of humanities and sciences. But at the same time, the kind of problems it may pose. Today AI is doing so many things. AI can create the same scenario as we are in without we being there, and AI can talk just like me. So we don't have regular, means any particular rules. Nobody can talk. Well, I'm sure AI can. Well, we leave that to the AI's discretion right now. So there are many things which would be changing. Quantum leap would be posing another great, you know, environmental, the tech environmental scenario, which would be difficult to assess, and don't know how the rules would come on that platform. But we come to Mr. Sachin Mishra, who is GC for the Tata Consulting Engineers. Sachin, you must be using the AI, I suppose, in several platforms within the company. In that presupposition, may I ask you the question?
Yeah, I mean, just to tell you, Vivek, AI means, I mean, in engineering from the drone has been used for a long, and drone surveys has been used for geological surveys and those things. But that was more to do with, you know, machine manually.
Okay.
But AI as such, as Manish has said, and I tell you, somewhere we use AI for investigation purposes, internal investigation purposes. Being a compliance officer of AML and bribery corruption policy, earlier we used to go through the email chain and those things, but now you put maybe lakhs of email of accused in that particular system, and it gives you exact trail what to go, and it reduces your time by 70 to 80%. That's the biggest benefit we have seen in coming days. But that's a negative part of it. Come to the positive part of the AI. Contract management, we execute roughly around 1700 to 1800 contracts a year, which means we review more than 6,000 contracts a year, 5,600 contracts a year. And with a team of 11 people, it would be very difficult if you don't have a proper system in place which can give you or which can highlight the risk of each and every contract. See, each contract had some boilerplate clauses, and some identifiable clauses which you can just review, take your action in, give your views. So there I see it's a really revolutionary and we are getting benefit of it. Not reducing the headcount, but headcount is being used for more productive use of the wordings, more use of the, we can negotiate that clause. Earlier when you used to review the, if you have so much content of the contracts, you cannot review all the contracts and then give your intellectual power to that. And you know that this is the focus area and where I have to give my views. I can take some best examples of the same clauses across the globe, not necessarily in India. I can take the same clause, engineering clause being used in France or somewhere, and it's an educative things to the counterparty also. Many times, you know, government contracts are written on a basis of CEC guideline or maybe financial OM guideline of the Ministry of Finance. Tell them something that this is being used in other part of the world. Today, and we are using it very frequently, those things. So contract management, investigation, and then something called as, earlier we used to say the risk management committee. Today it's not risk management, it's called modern compliance and risk management. You know, you need to understand that what are the modern risk of the corporates, which is very important to understand. 5 years back, none of the audit committee may have the terms of reference called cyber risk or digital risk. Today almost all the audit committees have that particular agenda, and to educate the audit committee, earlier the audit committee was more financially acumen, you can able to read the balance sheet and all. No, that's the era now, and that's the era for very long, 60, 70 years. I'm not saying that era is gone, but at the same time you need a person who is equipped to understand how the AI can affect the company in the kind of cyber risk and those things. So that's a third area which is we have seen as a corporate, which is coming in the boardroom discussion, corporate discussion, more positive side of it. We don't see that AI is going to replace those, but yeah, it's going to hand in a more positive way to the corporate function. That's what something I would say.
You know, just to add to that, I mean, whilst AI is going to be very beneficial in many, many respects, but we have to also bear in mind that there's a recent judgment of the Delhi High Court where it says that AI chat GPT cannot be a platform in facts, you know, and I quite agree with it because you know, look at law way progresses and the way it transpires, you know, the Euclid's principle where every judgment is distinguished, it is in relation to a context. The question is whether the AI is adept enough to kind of perceive that and, you know, make it applicable. Creativity of the human mind cannot be replaced. Yes, AI will be there to facilitate things, but, you know, in my view, the way, you know, the education system of the legal arena is improved, you know, lawyers can also research in a very, very competent manner and more focused. So sometimes, you know, this, and we have experienced it, you know, sometimes you want a particular contract to be drifted in a particular way and it throws up a very, very weird, you know, kind of a contract. So, you know, it has to be treated with caution, you know, it needs to evolve quite a bit and reach that standard. But my final conclusion states that it cannot replace the creativity and the creative mind of a human.
Yeah. And I'll just add on to what Amrish has said, and I think while I agree with all that he has mentioned, I feel that to only use AI for the purposes of research is undermining the ability of AI. It has immense potential, immense, you know, usage. As Sachin also mentioned, I think so far as contract management is concerned, it definitely is going to be of huge relevance. And not just that, I feel that it is also likely to reduce the disputes, because if you are able to ensure that all your clauses are mapped, and you are able to then thereafter also act upon those clauses. I think most of the disputes that we see are around non-compliance of certain clauses, and if we are able to map those clauses, I think it is definitely going to also help us reduce disputes. The second, I think that where we also, and I think the government has started working on it, some courts have also started to working on it, is to use the AI tool also for dispute management and dispute predictability. I think it is also becoming more and more relevant to understand if there is a dispute of a certain kind, and if it is actually run through the case history and the data which is available before the court's records, we will be able to also understand what is the kind of likely outcome. It may not be accurate because of course human intervention will still be required, but it is at least giving you a certain likely outcome which can be used for that purpose. And the third, which is very important, is also in cases of mediation, because if you are trying to settle a dispute and if you have an understanding of what is the kind of dispute that it is and what is the kind of outcome that is likely to happen, I think it will also help or enable the organizations try and settle the dispute. So I think there is a lot more that can be, done with the AI.
I totally
than
agree.
just talk about.
Manish, you want to say
Just
something?
to add to what Shweta has said, see, ultimately we will have to realize that a company, NVIDIA, today, which is the backbone for AI, its market cap is more than the GDP of India. In last 1 year, the kind of, it has added $1 trillion to its market cap. Now, the only difficulty with the legal fraternity is that the last big change which came in the legal system was a Microsoft Word. So it's been almost more than almost 2 decades.
More than 2 decades.
And most of the lawyers have not been able to rise or think beyond it. While intelligence has become artificial, stupidity still remains human and natural.
No, I don't agree. Even AI is quite a stupid on certain counts.
It is, but it is not as natural and as human which it is. So it makes errors, but it makes an error. I'll just give you one example. When the car was being made, Tesla, so this same question was being asked and debated upon what will happen if there is an accident. So what happens? How many of you know how to drive a car? Raise your hand. Almost everybody knows. See, what happens, we all have learned how to drive a car, but we have made the same mistake. गाड़ी चलाते हैं बंद हो जाती है. We the same mistake of taking a right turn or a left turn or giving an indicator or not giving an indicator. But when an AI-driven car makes a mistake once and there is an accident, all the cars in United States of America learn that. So therefore, they don't make the same mistake again. Me, my wife, my daughter, my son, my father, almost the same mistakes, if not all, most of them, while driving, we learn how to drive a car. The same mistakes are not made by, insofar as AI is concerned. AI, if it is used for the, if blockchain, AI and your quantum computing is used for the purposes of land records, 50% of the land disputes will not be there. Yesterday I was at a conference and Justice Mohan said that 60% of the cases will have no right to exist insofar as the check bouncing and things of that nature is concerned. 40% of that 60% time will be free for the judiciary, and then there will be no excuses for us to say that we don't have the time to hear all the cases. And most of the time of the judiciary, if you look at somebody was to do an analysis, they will come to a conclusion that the administrative matters take most of the time of the court. That is the area that we need easiest and we need to strike, and we will be able to use them. I'm not saying use it for the purposes of replacement, use it wherever it is possible. And once that is done, a lot of humans' dignity will be preserved. And what I say is that knowledge is free. Today, anything in my era, anybody who knew the 180 country capitals was considered to be an intelligent person. But today, at a click of a button on your mobile phone, that is available. That level to know 2.5, 3.5 pahada. So what we respect Bhasin Saab sitting over here is for his wisdom knowledge and intelligence will come in the lower of the hierarchy. So I understand we're not talking about artificial wisdom. Artificial wisdom will there, and that is why people will pay you for your expertise and wise advice. They will stop paying you for information, knowledge, and content. So
We have among us Dr. Lalit Bhasin. I invite some comment from him. We would be, benefited with his wisdom on the topic.
Thank you. What was the theme of this session? It has disappeared from there.
Okay, navigating high-stake business disputes.
Yeah, navigating.
High-stakes business disputes.
Firstly, high stakes disputes, they get automatically resolved because the parties which are involved in high stakes disputes, they can afford, you see, to go for arbitration in US, in India, whether it is Vedanta, whether it is Adani, Ambani and all that, they take care of themselves. This session ought to have been on dispute resolution, business dispute resolution, not high stakes. High stake is an academic thing, you see. It is superficial. They get resolved. They can wait for years also. Second is, yes, observations have been made about regulations. I can understand if you say that we have too many laws, we have overlapping laws, we have ill-drafted laws, we have outdated laws. That I can understand. But so long as laws are there, there are bound to be regulations, how to implement and enforce those laws. Therefore, first requirement is rationalization of laws. There should be a rationalization. We have brought in the labor codes, old wine in new bottle. Most of the provisions are the same. Something has been added. But when we say that we are over-regulated, is it not a bogey that we are raising? Everything, you see, has increased in volumes. The business, the profits, the shareholding of the companies. Earlier it used to be in some thousands. Then it became into lakhs. Now it is in crores and people are talking of 1 billion, trillion, you see, economies.
Correct.
So the cost of compliances also has to go up. So that is no excuse to say, oh, we have so many compliances to do. Increase your manpower, increase your compliances, and as Shweta said, wherever possible, use AI, use technology to reduce the cost. So in my view, this is like an escapist point of view that we are over-regulated. That is my submission.
Thank you so much, sir. I said in between the discussion that regulations are bound to be there. We only can say that the processes pertaining to the regulations can be reduced. So that's the statement I made. That's confirmation.
I think the government of India has that agenda that insofar as the process reforms is going to be the second generation of reforms.
Yes.
The exact expression which Sanjeev Sanyal used was that they are now going to look at that the process reforms is going to take, substantive reforms have already taken. They are identifying those processes where first you have to go and upload your document, and then you have to sign and give a physical document itself, and then you have to go and make 2 copies and things of that nature. So the government it looks like, is conscious of the fact that the process reform, it is not only the substantive law reforms which are important, but with digitalization, automation, and now AI, we will be taking care of a lot of process reforms. So that is something which
your comments are very much welcome, sir, because you pointed out in a much better way that you all could have.
Vivek sir, I said that intelligence is replaceable, wisdom is not.
That comes to a point, ChatGPT has the transientness of say around 55%, and Gemini has a transientness of around 88%. So that is almost near the human wisdom. So when we talk about the transientness of the AI, that is the human wisdom. So if suppose it crosses 100%, so that is almost identically behaving in the same manner as the Vivek in wisdom says. So
I still disagree with you.
nonetheless,
Spanner in the wheel has already been introduced, by the courts when they say that AI has to be treated with a lot of caution. They don't have an evidentiary value, and lot needs to be done, lot needs to be harmonized.
see, we are all concentrating on AI. We are forgetting one fact, one very, very relevant fact. Generative AI. Generative AI is altogether means it's not identical to AI. For the textual purpose, generative AI can be used by large language modules, LLMs, which we say conventionally. And that way, today we have the keyword search while doing the research with regard to the judgments and other things. We could have contextual search like we do in the chat GPT. Similarly, means it will bring the same results. Okay, these particular paragraphs of these judgments, several judgments, it will bring out. And then today we have crores of papers which have already been digitized by the Supreme Court, High Court, trial courts. So this is that time where we need to use these LLMs to develop that generative AI so that three benefits can come immediately within, say, a span of 3 to 5 years, which I had suggested 2 years back to the Honorable Chief Justice also in a written note. 50% of the disputes pending in the court, which is almost around 5 to 6 crore courts and tribunals, would reduce within 3 to 5 years. That could have the capacity.
By 3 to 5 years, generative AI will have an IQ which is twice that of Einstein. So if your goal is 5 years, you will take 25. It should happen in the next 2 years, and it is possible.
So maybe possible, but at the same time we do not, so till now we have not been able to do this. There are other benefits which can occur. Well, coming back to our principal questions here now. Last year, as I talked about, that there had been arbitration clause removal pertaining to the contracts. How do you see, means I have this question from all the panelists, means what is the impact that is going to happen with regard to the government contracts in the coming time, as you see, and whether it would be beneficial for the litigant and India's image in the international world.
Yes, so once that Mediation Act has come into force, there has been a paradigm shift in how people are looking at it. In fact, the Ministry of Finance has already indicated to the public sectors and the instrumentalities of the state to adopt the mediation route. So, that's what it is. The mediation route has a lot of benefits, and the disadvantages of arbitration is something that doesn't need to be discussed here. It's all well known that how time consuming it is, how heavy litigation costs and so on and so forth. Mediation, rightly pointed out by Sir, that you don't need the law.
Shweta is nodding in negative, so I want to take the Shweta's view immediately because I have to wrap up in 5 minutes.
Yeah, so I'm just taking it from Mr. Bhasin's cue.
So after we finish this round, I will take one suggestion, as you may want to give to the government in relation to either the dispute resolution or the regulatory framework. But Shweta, yeah, you want to say something. Sorry,
I just want to add to say that arbitration has not failed. I'm sorry, but that is not the correct interpretation. Arbitration has not failed. The lawyers have failed. It is the creativity of the lawyers where we find the scope for intervention at every stage to the court. And the courts have failed because the courts are intervening at different stages. So I would not agree to say that arbitration has failed. The purpose for arbitration was different. It was to take the disputes out of the court's regime, and it was only, the court's role was only supervisory to understand if there is any problem, to intervene at the stage of Section 34. The courts have, the arbitration has become a very favorite baby to talk about while it comes to conferences, while it goes to courts in Section 34. But it is not required to be, intervene at this stage, the manner in which it is being done. It is not an appeal.
So also wants to say something here.
Yeah, and just to add, sorry, I mean, before I miss the point is that, if one has looked at the DMRC judgment, where the courts have used the extraordinary powers to kind of set aside the judicial restraint and have actively intervened to sort many issues out. is vindicative of two things. One, that how the arbitration is failing, and secondly, it is setting an example as how things need to be streamlined.
Yeah, Mr. Devan, you want to say something?
Hi. So, I have a little different take. I think the biggest challenge we face is, A, we don't have any institutional arbitration. Unlike, typically we as a law firm would see every contract, any foreign company would insist on a SIAC or ICC. We unfortunately, even after 60 or 70 years, are unable to create. We have so many arbitration institutions, like a formidable institution like SIAC.
They're mostly working at ad hoc.
We don't have institutionalized arbitration. The timelines are always, of course, as Shweta rightly said, there's always a judicial intervention. And we are over-reliant on retired judges for arbitration, who are more than, I work without being prejudiced, I'm happy to say, there's always a welcome thing, okay, fine, there's always extensions being given. So there is no time-bound process. In fact, on the contrary, law of our clients feel, even if, they will go to SIAC, get arbitration in a time-bound manner, but of course, then they face the bigger challenge of, enforcement of the awards. And also, lastly, I will say, the mediation, having issues like, all commercial matters have to be first referred to mediation has been a miserable failure. Because when companies
because
are...
we don't have trained mediators, we do not have...
No,
training is not good enough. The kind of training, 40 hours, 60 hours...
Exactly. And forcing companies to say that, first you go for a commercial mediation and then you file a recovery case. So that means you are eventually waiting for 1 year almost before you can actually go and initiate a proceedings for recovery. So,
yeah, Mr. Mishra wants to say something.
Not on the mediation or arbitration front, but on the regulatory front, I must say that compliance is not in just a paperwork. It's an infrastructure now for corporates. It's not just in paperwork.
Thank you. Manish, the words of wisdom to close the discussion.
No, see, we have to, we can't blame lawyers or the system and things of that nature.
Thank you for not blaming me.
Yeah, of course. The entire polity has failed, and I have not cross-verified it, but this situation was there and Justice Nariman had said in one of the speeches that for 100 years in US arbitration was banned in some of the states. So therefore, whenever there is rough justice, whenever there is something, I think some introspection is required. We need to understand how to improve the system. We don't need to throw the baby along with the bathwater. And
sir, I want to take a comment from you on the last.
So what is required is, as they say, that 3 Gs needs to be introduced. A, geography, so therefore it need not be concentrated in Delhi and the big cities. And second 3 is generation. So I think we must have arbitrators which are less than 40 years of age. So the third is green. We need not appear in person. So these 3 Gs is something which we need to introduce, and that will improve the quality of arbitrations that we have.
Laudable. Thank you so much, sir. Yeah. Your wisdom.
My brief comment is, litigation has totally failed with nearly 6 crore cases. And I don't agree with Shweta that arbitration has some roots here. No. Arbitration has totally failed. As I said in my opening inaugural speech today, 2 reasons. Judges who retire, they have cartelized arbitration here. Cartelized it really.
I totally agree.
And then, secondly, sitting judges, the intervention by the courts. So arbitration has not taken off.
The environment really fructify properly, and
therefore, Indian, parties, they would prefer to go to SIAC than to get matters arbitrated upon in India. And my last message, to this august panel and the participant is, mediation is the only answer. But for that, you don't need a law. You need a change in the mindset of people, the clients, the lawyers, the general counsel, in-house, everyone.
Wonderful. With today's wisdom, we move forward to one last comment from everyone. One suggestion. One suggestion each of you. Whatever you want to say. In half a minute, 30 seconds.
So I think for me, I still say the most important change is required is regulatory ease of doing business. Government is taking steps, but a long way to go.
Mr. Mishra.
Interconnections of the regulators is very important.
Very well. Shweta.
I think there are two things. One is making the timelines mandatory when it is provided for in the statute. I spoke about it in CII as well, but that's something that is now started to pain. And second is don't make mediation mandatory. Let it be optional for the parties to opt for it, because PIMS otherwise in Commercial Courts Act has also substantially failed.
Manish.
I think we must now focus on the procedural reforms and the judicial system. I'm not saying judiciary.
Okay.
The judicial system requires a shake-up. We have had it, some of us have had it too good for too long, and we must give way to new ideas, and we must do whatever is necessary. If with the present speed we were to go, we will take 300 years for all the cases to resolve, and once the message goes to the masses, they will lose faith in the system. Before they do so, we must do all that what is necessary, including use of AI, if that be so.
Ambesh.
Yeah, I mean, pitch for mediation, make it very, very robust. You know, the Commercial Court Act mediation process has largely been very, very successful, maybe at a lower, at a lower level, but I think that's what is the need of the hour, keeping everything in perspective.
Well, thank you so much. These are wonderful suggestions. My only suggestion is let's have more disputes. Thank you.
Thank you so much. A picture, please. And thank you so much. Thank you. Chaliye, quickly moving ahead with the next panel. It's on single tribunal multi-led jurisdiction, opportunities as well as challenges. Please join me in welcoming a panelist for this one. Dr. Mukul Shastri, Group General Counsel, Cube Highways. Anup Rawat, National Practice Head, Restructuring and Insolvency, Shardul Amarchand Mangaldas & Co. Amit Maharia, Managing Partner, MCO Legals. Joining them is Advocate Rashmi Katpalia, Independent Director, former Director, Legal, Technical Energies. Joining them is Riva Gujral Singhal, Senior Legal Counsel, Reliance Retail Limited. And this one will be chaired by Manisha Chaudhary, Managing Partner, UKCA and Partners, LLP.
Good afternoon, everyone. So starting with this session, we're going to concentrate on the NCLT. I think it was missing from the name. So the tribunal which is single-handedly handling the IBC and the company law jurisdiction. What I'll do is I'll let the panel introduce themselves, 1 minute to each of them, and then I'll introduce myself. Is that good? Yeah, starting with you, Riva.
Hi, good afternoon, everyone. Well, I'm Riva Singhal. Currently, I'm leading IP and corporate litigation for Reliance Retail and have been around for almost 2 decades. Look forward to this extremely, I would say, fiery discussion. It can go either way, yeah. So, yeah, look forward. Thank you.
Thanks. So I am Mukul Shastri. I am the Group General Counsel for Cube Highways. We are a Singapore-based private equity platform. We invest into roads and highways sector in India. And we are the largest toll road operating company, private operating company in India. So most of the tolls that you might be paying in and around Delhi or even South India, you might be paying the toll to us, almost 10,000 lane kilometers that we have right now. So I had legal, compliance, contract insurance, and looking forward for the discussion.
Hi, good afternoon, everyone. I'm Anup Rawat. I'm the National Practice Head of Restructuring and Insolvency Practice at Shardul Amarchand Mangaldas. We focus primarily on the stress asset resolution, whether outside the insolvency or in the insolvency. Look forward for the discussion here.
Hello, good afternoon. I'm Rashmi Katpalia. I am former GC of 2 MNCs. I have about 3 decades plus experience behind me, including about 10 years with litigation. And I used to be once upon a time official liquidators counsel before the company court, and that's how far back my knowledge is regarding insolvencies and winding ups, etc. So I'm very excited about today's topic and how it's developed over the decades. That's all.
Hi, my name is Amit Meharia. I'm the managing partner in MCO Legals, having a practice for about 24 years now, and mainly involved in NCLT with restructuring and do a lot of operational creditor parts also. I look forward for a healthy discussion among us. Thanks.
So a quick introduction for me is I'm Manisha Chaudhary. I'm the managing partner at UKCA and Partners LLP. My domain is dispute resolution for corporates and in commercial laws, focusing on PE, focusing on company law insolvency, of course, and also on debt funding. So a corporate ecosystem, I do it all. So that's about it. So we'll start now. With a quick introduction, I mean, most of you know what the NCLT is, and it's in the news for all the good and the bad reasons. So just bringing forward a few facts on the NCLT. Established in the year 2013 with the Act coming in and notified in 2014. The NCLT originally was for company law jurisdiction and to consolidate the jurisdiction from the High Court in terms of the appeals, in terms of the mergers, and in terms of the winding up, which then became liquidation before the NCLT or the ROC, depending on how you want to go about it. And of course, the original jurisdiction of the CLB was transferred to the NCLT, which was operation mismanagement, strike off, which had to move in here. Now with NCLT, at that stage, it was a lot of cases being filed. It was a smaller court, but it was still a great forum for company law to be discussed, for jurisprudence to be made, for cases to actually move forward. Then in the year 2016, the IBC came into being, and NCLT became the adjudicating authority for that. And from that started the chaos, or the beauty of that chaos, because it gave us great jurisprudence in the IBC, but it also sort of treated the Companies Act as a stepchild. So today we are here to discuss all the pros, all the cons, the things that came out well from the NCLT, and what challenges today the NCLT is facing in terms of the IBC and in terms of the Companies Act. We'll look at it from a practitioner point of view as well, from GC's point of view as well, and of course we'll open the forum to you all if you have any queries to ask us, any anecdotes which you would want to share, any experiences, that would also be great. So starting off, how we're going to plan this panel is, we're going to have a general question, and I'll have each panelist put in about 30, 40 seconds, 1 minute, 2 minutes tops, to sort of give their view. We're going to try to keep it a little generic because you don't want to go into number, figures, name of the cases. I think we all read it in the newspaper every day, at least on the IBC part. But I would like everyone to touch Companies Act issues as well, especially operation mismanagement and M&A, because that's taking a little bit of a backseat in the NCLT and not giving the results that we would have sought the NCLT to sort of give us when it came into being. So I'll start, and I'm trying to be paperless, so please do excuse me from asking questions from my phone. So one of my first question is, just starting with you, Riva, what are the experiences that you've had before the NCLT from a GC perspective? Just, you don't have to tell me what cases you have before them, but just as a person viewing the NCLT, how has it gone for you?
Okay, so when you say experience with NCLT, so before Reliance, I was a very active practitioner at the NCLT Delhi for almost 5 years. So, well, experience there was, I mean, I don't know if I but from 2016 to 21, I think Delhi NCLT was the most effective benches that we had, for sure. I mean, there were obviously IBC cases were, I think, still our topmost priority. But now, when I look at these from a NCLT or an organization viewpoint, I mean, I think more than the insolvency or the Companies Act cases, somehow I feel it's become, sadly, a court for recovery, or that's how at least people are trying to, approach NCLT. I mean, we've seen cases where, and also because, a civil suit does not grab so many eyeballs. But the moment there's a IBC petition, it is a higher priority when it comes to any organization. So that is one bit of it. And the other bit that we recently experienced was when you look at company law also, any application, be it for oppression mismanagement, recently we saw something where there was a request for SFIO investigation, and the fact is that on the face of it, sometimes as any practitioner or an organization, you know that this is something that you will get done. I mean, you see that there are no merits. But unfortunately, the system is such that, an application or a petition sometimes takes over 3 years to get dismissed. And the moment, as GC, I mean, I'm sure Mukul will agree, that the moment you have an application like that pending, it is at times something which becomes difficult for you because you're fantastic on merits. This is not something that's going to hurt you, but anything that takes over 4 or 5 years to resolve or to get dismissed is something that, becomes an extremely difficult task for us to explain to the stakeholders. So yeah, that is my 2 bits on it at the moment. But I don't know how Mukul's experience has been. This is.
So Mukul, anything specific in your...
So 2-3 things there. So one is very recently we have completed a deal through NCLT. The deal is CNTL. It is in public domain, 5,400 crores. So NCLT or rather IBC has been really a game changer for India for the investors are concerned. Really it has an investor pull because the earlier mechanisms were not that great, and definitely IBC has been a game changer. Obviously there are still lots and lots to be done. I'll just give you 2-3 small statistics and things as to how IBC has the cons of it. Number one, as what Reva said, the delay. And obviously there are timelines in IBC, but if you see and to simply do a normal Google search, the average time taken for a disposal is almost 650, 670 days, which is too much. And see, from an investor perspective, it's all IRR driven. So if I'm investing in something, I think, okay, in 1 year time, I will get this project with me, and therefore it will up and running for me. So I have made my calculations that, okay, this is what I have to pay, basis this project will come to me after 12 months. Now, if it doesn't come to me in 2-3 quarters, if the delay is, instead of 12, it comes in 24 months. If there's a delay of, say, 4 quarters, every quarter erode almost 2% of my IRR. So what I'm going to get after 2 years, which is the average time, 650 days, is of no use to me because almost IRR would have been eroded. If I have planned for a 12% IRR, a 1 year delay means my IRR has gone back to, 4%. It doesn't make it a commercially attractive deal at all for an investor. Therefore, this delay we have to really stem, and we'll see and we'll discuss how to work on these delays. But yes, overall, IBC has been a fantastic tool for us. But yes, there have been these delays and which are a cause of concern.
All right. So just before we go to Anoop, I'll just give a few statistics that I had noted down. So NCLT, right, we know is handling about 4 distinct jurisdictional pillars. The corporate CIRP, right? So that's about 38,702 cases filed and about 37,233 disposed with a 97.2% disposal rate in section 7 and 10 mostly. The liquidation proceedings is about not really doing that well. So about 33% of the CRPs have been closed through liquidations. The pre-packaged insolvencies, which I don't see really going through the NCLT or people really filing those for some reason, those are about 500 to 600 only, and they're not really doing much in terms of the money involved. However, the Companies Act is sort of they say 94% approximately is the disposal rate, but it is taken a back seat from what most of us understand of those who had been practicing the company law before the NCLB and the NCLT. So Anup, just taking those statistics, not only focusing on the insolvency part of it, because I know that's your practice area and you're the master of it, but something on the Companies Act as well, as to what you may have seen your other partners facing, or maybe you are yourself.
See, I think the topic today is multi-layering within a single tribunal. So if we talk about that in the context of NCLT as a tribunal, as you rightly said, that NCLT performs the role of a tribunal under multiple laws. Of course, there are some laws which are economic legislation like IBC, which have the urgent need of quicker resolution. What Mukul said, that their IRR changes, so you can't have a case lying there for multiple months, forget about a year, multiple months, which changes the whole dynamics of the investment decision. As compared to, let us say, an operational management, which is more like a, how the management should function. So I think the focus and the objective are different, but are within the same tribunal. Therefore, I think we need to fix the design of the tribunal per se. At the moment, it's a bit commingled. The same bench is looking at all the aspects, and increasingly we will have much more nuances coming in even in the insolvency space. See, so far we have dealt with cases where you have the asset heavy resolution, right? Now with AI, introduction of AI, e-commerce and AI failing, you do not have asset to take a recourse on, for example, Bitcoin insolvencies. So I think it will become much more nuanced. So I think the need is that within the tribunal, they need to have specialized benches. There should be a specialized bench which should cater to only the operation mismanagement or the other merger related and other issues. There should be specialized benches who only look at the investment resolution aspect of the insolvency. And that should not get commingled with the other insolvency aspects. For example, avoidance transactions or any other interventions, left, right, center, which keeps on happening. So I think that specialized bench which is looking out only at the time value of money perspective, where they cannot be, there are defined rules, and that is intended to give a very clear, decisive indication to the investors that, oh, we are taking care of your investment and their IRRs, and we are not going to take too much time. And it is very much possible. So I think the design, once it gets fixed, and it's not that, the various stakeholders have not thought about it. There have been, the Law Commission report on how the tribunal should be rearranged. There have been, industry houses like FICCI and all, they have prepared report around that. I think if we take that and also remove some of the control that the existing administrative ministries have over the tribunal, if we take that out and then put it under much more neutral ministries such as Ministry of Law and Justice, and create those segments, I think we will have much more efficient processes.
Right. So, Rashmi ma'am, from your experience as the counsel for the OL, and you must have appeared before the High Court, and changes from that jurisdictional aspect to the NCLT, how do you feel what has changed over the years, or what has been your experience, good, bad? Just share that with us, please.
So going back several decades, while there was the CLB and there was the company court, things were working really well. But I think one of the reasons why this NCLT was created was to take away that workload from the High Court and for CLB, all that to be put together under one capture-all kind of a tribunal. And it has been the times of tribunals. Many other statutes also have tribunals coming into their new forums have come in, like NGT, and there was CSTAT, and of course the tax tribunals were always there. So the thought process for that was to have a to have all company law related things under one roof. That somewhere has gotten lost because we are now looking at, like Riva mentioned, recovery. I mean, everything has now, it's not as if winding ups weren't filed at that point in time to extract money back from whoever was the lender. But now what is happening is the NCLT is looking at all and sundry and nitty-gritties, even if it is somewhere convoluted and connected with either the insolvency or the recovery of any funds from a debtor. Having said that, the pros are that now we have everything under one roof. But the con is that this roof is about to collapse because it has again gotten overloaded with all the work that was there with the High Court at that point. So, although they have created the appellate tribunal also, but that appellate tribunal is also not giving the kind of orders and awards that were given at that point in time by the High Court, which were followed, which were implemented. For some reason, our NCLTs are now just doing corporate governance, they are doing, giving smaller orders or just safer orders or micromanaging and not really getting to the crux of the matter that an insolvency now is taking three years to even get resolved in the smallest way. So somewhere around the line we have lost, I think, the practitioners, the people who are filing before NCLT, using it for purposes that it was not meant for, just as dilatory tactics. We're finding that NCLT is not working the way we were wanting it to work.
Amit, a more microscopic view from a practitioner's point of view as to what you see and your experience before the NCLT. It could be generic, it could be specific, whatever. Take it away.
Thanks, Manisha. You know, India is a big country, so definitely there's a lot of business, a lot of companies. So volume will be there, whether it was under the company when it was with the High Court, or now whether it is with NCLT. The issue which Mukul, everyone was highlighting, it's correct that now people think of NCLT and they just think about IBC. People are forgetting, or even within the legal fraternity, they're not thinking that there are companies and all. So burden is there. My personal experience is the timelines. Timelines are not being met because of infrastructure issues in the NCLT or the benches are not. Multiple applications are filed. I've seen that the NCLT is crossing its line in the sense that trespassing into the jurisdiction of other entities. Few examples. It starts deciding how the RP should function. What should the RP do? How RP should decide. It starts deciding how the COC should function. You know, those are the commercial wisdom. Supreme Court has been very clear that you cannot interfere in those. Now you look at the Section 9. It has started acting like a civil court. It is taking evidence, it is evaluating evidence without the assistance of CPC and coming to a conclusion whether a document is correct or not correct. And the whole thing, why it becoming a serious issue is that at the end there is a threat that overnight your management may replace. That threat is there, so it's being abused by litigants, and to a certain extent NCLT is allowing it to be abused in the sense going into evidence, going into the area of RP functioning. So these are our concern, and you know, wherever in various conferences we have always said about how it's become a civil court and it is just appreciating evidences and it's deciding whether a lease is correct. It is deciding, you know, like whether the admission document which I have denied, whether it is correct or not. Those are not NCLT's functions. They should have just similarly, if it's disputed, just leave it to the civil court for decide. So concern is delay. From delay is the interference in other jurisdiction. Thanks.
Starting with you again, something good about the NCLT. Since it's come into the being, how do you see it has changed the corporate jurisdiction or the commercial jurisdiction even when it comes to the insolvency part?
I think taking into account the globalization and the Indian economy, the way the decision to bring everything under a roof is a correct thing for a corporate world. It's easier, and NCLT has, whether right or wrong, it has created an environment where people are scared of defaulting. There is in the business community, there is whether I get an NPA or whether I'm warned and all that. So like ma'am was mentioned about recovery, so every positives have a gray line where you cross. So in the NCLT case, I think that the default has reduced overall in various legal transactions, and that has happened, and the organization has become far better. NPAs have reduced so much in the banks. So overall, it is a very positive step. There will be backdoors that can be overcome.
Right. Your views, Rashmi?
So same as what I would say that the recoveries of the NPAs has marginally increased, but at the same time, when these smaller insolvencies, startups which were hesitating from going and developing into more serious matters, they find it easier to go to NCLT and get their mismanagement and oppression resolved. We've seen all this time, it was always the bigger companies who were going, their big shareholders were going. We've also seen that now NCLT is trying to get matters settled. There's a little bit of mediation is also coming in. So those pros are working towards NCLT. It's expanding its spheres. That expansion is not necessarily going out of the statute, but laterally into resolving issues.
Right. So just adding to what you had said on mediation, is one thing that is being proposed, but mediation is already there in the Companies Act, and a mediation panel to be made by the RD, depending on where the RD is located, to something for all these derivative suits, shareholder litigations, which is something which can really work also in class action, in my opinion. So Anup, from you.
I have a slightly different view. I think that there are definitely, certain shortcomings, but even with these shortcomings, the NCLTs have been able to achieve a great lot of things actually. You see, nobody would have thought of, changing some of these bigger names that were there, the promoters, which has happened in the NCLT, and NCLTs do draw a lot of power under IBC to do that. I think the only things that we see are lacking is in terms of, the focus on certain time-sensitive issues, which is, resolution, and we need to sift it from the other aspects. Then the infrastructural issues, which is an easier thing to, I think, sort out. And of course, more and more training and more qualified people getting attracted to, join NCLT. I think with that, I think it's a phenomenal model. It has worked really well. If you look at, how some of the other jurisdictions face the issues. I mean, for USA, it took more than 100 years to sort of, come to the place where they are. And, we are already there. So I think though the transitioning issues definitely are there, but we are doing well overall.
Yes, Mukul. Good things only.
Yeah, good things. No, I just take the cue from what Anup has said. No, I feel, yes, IBC has been great. I said that it has boosted investors' confidence, and you can see the proof of the pudding is in the eating. If you see the number of cases, it has become threefold in past 8-10 years. So yes, it definitely is attracting a lot of people. Though people are misusing it also a lot. There are a lot of people who are just filing cases and using NCLT and IBC as just a civil suit recovery, money recovery thing. But then that will always be the case. There are a lot of intervention applications, this and that. But then that will always be the case. But what I feel is the solution lies in the person who are manning it. And I feel that is where right now the biggest of the issues is. As Anup has rightly said that I do not know what kind of compensation they are getting, or what is who are really manning it. Whether the industry people are really going and joining them. Like Anup said, let's have a multi-layered jurisdiction. The person who are expert in say AI and Bitcoin. But then again, do we expect expect a retired judge to understand those things and those nuances? I don't think so. So maybe we really change the entire thing. If you really want to have a multi-layered jurisdiction, it's better that we have those kind of professionals attracted to it.
Technical members from the industry would be great.
Thanks. So I think mostly kind of bulletize it. I'll say number one would be specialization. I think that has something that NCLT is definitely brought in. So at least you have a bench that pretty much understands what laws we are talking about. So that is one. The second would be codification. There has been, the law, the substantive law has pretty much kept in pace. So yes, these two I would say are the top two. The others obviously being, there is, no matter what we say, but the speed has definitely become better than what it used to be. So yeah, these three top
So in terms of the speed, so I have these numbers before me, which is that before in the BIFER, a case for these sick industries used to take about 10 to 15 years, whereas before the NCLT is 597 days on an average, and the NPA that they have recovered is about 1901,261 crores. So that's a lot of money pushed into the economy.
And also there's a single window clearance now. You know exactly where to go. You don't have to run to 500 different places. So yeah, all these, cannot be overridden by the fact that yes, there are procedural delays. Those are there in every, sorry to say, but every tribunal, every court, sadly the infrastructure does need improvement. There is no doubt about it. But all these, I would say, achievements or the benefits that all litigants have had since the NCLT has been set up cannot be taken away.
Right. So Amit, just going back to what you had mentioned with regards to NCLT maybe overreaching its power in terms of leading evidence or appreciating evidence, I would say, or even trying to conduct a mini trial, asking questions across the bench to the litigants or to the lawyers. Also, comparing that under the IBC with the Companies Act, because in my understanding, NCLT has a far-reaching approach, or could have had it under the Companies Act, even to the extent of maybe not adjudicating on fraud, but giving primary finding, looking at evidence and appreciating it on the face of it, not really leading trial, but trying to understand queries from the litigants and maybe taking a view at least in terms of documents which are before it on affidavit. So from that I understand under the Companies Act, but taking a departure from that and then putting it under the insolvency and maybe letting the rules of the NCLT, taking that onto themselves and saying that the rules allow us to do so. So in your opinion, what do you think? I agree that you do not absolutely agree with the NCLT, but what do you think could be their limits or should be their limits, and how they are encroaching upon it, and where, if you on the flip side believe, what could be, how far they can go into trying to appreciate it, and think of it from not just an angle of corporate debtors, but the litigant also, the persons who are before the court who are genuinely grieved. We are not going to talk about any litigants who are there just to sort of create a mess. So your opinion, your thoughts on that.
NCLT, I'm very pro. Issue is that when it starts appreciating the documents, what happens, I'll tell you, they file an application. Let's take an example of Section 9. And this application is supposed to be in totality by the code. In totality means it should establish the case that there is a debt and all those things. Then the proceeding starts, a reply comes, then it goes on to become a rejoinder, a sir rejoinder, a sir rejoinder, and new documents which were existing at the time of filing of the applications are being brought through sir rejoinder, sir rejoinder. So, it becomes a never-ending process. And in that, it is very easy for NCLT to not appreciate where I should be stopping, So that is the concern. So it is also for the advocates too, who are appearing for the litigants, to ensure that it doesn't happen. So, but it is happening, and it's become like a debt recovery in that extent.
All right. So from your aspect, ma'am, on the same issue, but only trying to understand what could be bettered. Do you agree with this tribalization of all these specialized things? Because I think we're up on time, not short anymore. So just your thoughts, your last minute like bullets as to what can be done, what should be done, what ought not to be done. What do you think?
I'll just go with what ought to be done. So the tribunalization is what is required at the present moment if we have to get adjudication done for our disputes, and it's not just up to the High Court. So far as NCLT is concerned, I think we just need to improve the number of people that we have over there, the members that we have over there, and have a specialized team to be addressing. Each member has to have a specialization in what they can contribute to, and not just generally educated people in the law. That is 2. 3, very importantly, we need a better infrastructure for NCLT, which is sorely lacking. It's great that we can connect online and have our hearings, but so far as the actual number of people, where they are located, like we were discussing earlier, they get appointed, they don't even have laptops to be working on. So such like small things, but which go a very long way in actually improving the working, and also for NCLT to realize that they are at par and they need to give the kind of orders that actually move the cases forward, and not just macromanage and give corporate governance awards. Those are a few points that I feel are necessary.
Yeah, time is already up, but I'll come back to the point. I think we are doing fine. It's just that, we do need to strengthen the existing, the bench strength, the quality of bench strength, and the infrastructure aspect. But I tell you one important aspect, if you look at the large Asian economies, you will not have the kind of law that we have. China doesn't allow the foreign creditors to, come directly to the tribunal in China and claim this right, which is, parallel to the right, or same right of the domestic financial creditor. So it has done, very good service. It has improved the way the foreign investors, the lenders look at India now, and I think we should just build on it. There are areas of improvement, but I think we are doing fine.
Mukul and Riva.
Same thing, actually, better infrastructure, and let's have the quality people. And I always say that now there are people in industry, there are people who are good advocates. I should think that they should man these things, and we should really incentivize them better so that they join the benches.
To sum up, I think there have been enough judgments also passed by the Honorable Supreme Court which said, structure first, legislation later. So I think that pretty much sums up the need of the hour. So there's no point harping on the fact that, there is delay. I think there is a need of the hour is to work and support on better infrastructure. I think everything else will follow.
Just to sum it up from what we have discussed, and though we were very short on time, NCLT is a great forum. IBC was the need of the hour. We had to get onto that platform with all the developing and the developed nations to have that law into place. They could give more weightage to company law and infrastructure. And if anybody can take this to the government also, and I'm absolutely pro-establishment, but please ask them that they need to give this forum this due worth, and it needs what it needs to be doing better with the benches, with the actual building, people who are working there, admins, and of course us as lawyers should also be able to contribute and hold on to the litigation there and make sure that it is as smooth and as proper as it can be, and efficient, of course. So thank you so much for your patient hearing, and thank you to the panel. You all have been tremendous. Thank you so much.
Thank you so much. Thank you. And thank you, Manish, for moderating that. It's okay. We'll do it later. You're coming back then, please. Yeah, where's the photographer? I think ये बात नहीं होनी थी. Chaliye, we are done with the panel discussions for now, not the end. And before we begin with the 6th annual BW Legal World Global Legal Leaders Awards ceremony, we have a very special and important keynote address. While they set the stage up for that, please join me in welcoming to the stage Additional Solicitor General Chetan Sharma ji, Delhi High Court.
I think we are privileged to have the presence of Mr. Chetan Sharma, the Additional Solicitor General of India. He is not only one of the most eminent lawyers of the country, but he is a jurist, an academician, a scholar, well versed, you see, not only with law, but also with the culture, with the history, and with the values of our civilization right from the ancient times. Today also happens to be his birthday. So a big hand to Mr. Chetan Sharma and many, many happy returns. Thank you.
So what will be the topic? So a celebration is a celebration, it's celebrated, it's over. Respected Lion of the Indian jurist landscape, a young man, as I said last year, and he's growing young each day, 80 plus and strong, one of the most humble but yet pillars of our legal edifice, especially the corporate edifice. It's almost synonymous with Mr. Basin. And as I said on the last occasion here, he is one man who is feted not by any Indian diaspora or something, but he's been feted by the House of Lords. So this is his humility that he can introduce me in such a manner. I don't know whether I deserve it or not, but coming from an elder, I shall certainly take it with humility.
I think he deserves your support.
Thanks to Mr. Anurag Batra, the soul and spirit behind BW. Well, actually, it's a BMW of law. It's not easy to
configure, organize, run and operationalize such a wonderful system as Mr. Batra has put in place. And you know, you can always conjure up something, but you can't, it's very difficult to maintain it. You can also maintain it, but it's more difficult to maintain it with credibility. You can also maintain it with credibility, but it's more difficult to maintain it with excellence. And above that, the crowning on the cake is, not of this cake, but the crowning of the cake is that it is done with a lot of passion, with integrity, and with a lot of sensitivity. He's there where nobody is, and he picks up those threads which are not visible, those ideas which escape your mind. And I want to share with you, because I was taught this when yours truly was in his teen days, to a test cricket commentary for India versus West Indies in 1983, Kolkata Eden Gardens. I was in my teens at that time, and there was a lot of opposition. Opposition to care, it's been with me all through, even now. So they said, why are you taking this young fellow? So Shurajit Sen used to be old time, he used to be the controller of sports. So he said, we need to put in young people. So we were trained at this place, Sports School Rai, where we also gave commentary for the Asian Games. तो एक मंत्र उन्होंने बताया, और वो सूत्र ये है कि see, Vivian Richards has hit a cover drive, right? It's a wonderful cover drive, it's gone for 4. If the commentator says that it's a wonderful cover drive and it's fetched 4 runs, every viewer in the country and beyond knows that it's a cover drive, knows that it's gone for 4. What is your take on that? You are just stating the obvious. The obvious is for below average mediocre people. You have to find something more. So therefore your research comes in. And ultimately, if you can find out that Viv Richards actually had a fractured hand or a partially hairline fracture and still he executed that shot. And for a cover drive, it requires a particular part of the arm, you know, to play very strong and which can wilt and excavate the fracture, and yet he went for that shot, shows the kind of passion that Vivian Richards has. And that's what makes Vivian Richards Vivian Richards. So that part, if you can tell to the audience, you are a good commentator. So this is the part of a lawyer, this is the part of a corporate lawyer, and this is the part that Batra Sahab has been doing, that what is not obvious, let me put it legally, what is not res ipsa locutor, which is hidden, but which needs to be drawn out and placed before the firmament for its appraisal and dissection and analysis, is the kind that BM world is actually doing. It's bringing out the fine print, it's writing what ought to have been written or what has been suppressed. Not that it is sensationalism, no. Not that it's anything to do with a yellow side of things. But this is substantive, legal, procedural aspects of this great profession that we are in. And let me tell you, today it's the #1 profession. Topmost secretaries have told me, I'm saying this, मैं झूठ नहीं बोलूंगा आज के दिन. Secretaries to the government of India, they say कि सर, काश हम भी वकील होते आपकी तरह से. मैंने कहा सेक्रेटरी साहब 30 साल पहले हम ये सोचते थे काश हम कोई सेक्रेटरी बनते. So you know, life turns full circle, and you have our topmost lawyers. Very well, they can be almost, you know, counted at par in the commercial earnings with an industry or a film star or a rock star or a golf champion or a tennis champion. It's as much earning. But it's not as if the entire parametrics of the edifice is left high and dry. No, there is ample space for everybody. I can see a lot of my friends here, friends whom I'm meeting after I met them abroad. Of course, it's no rhyme to giggle, but after having spotted them and met them in Georgia, I'm seeing them now. So, a lot of people are there. If I take names, then I'll be partial. Of course I am. But then it's such a wonderful feeling, you know, you bond with each other, you've grown with each other over the years, and you have actually, with a magnum opus, wanted to look at the faults of others while not looking at yourself. This is the beauty of growing up. But I think now that we are settled, and today's proposition, if I understand, let's get to the point, is the legal governance. Batra sahab yahi hai na? The legal governance, if you want to add or subtract, bata do, to let's go ahead with this. So the legal governance is in 4 parts. Number 1, everything in law is in 3 stages. In the past, which is precedent, in presenti, which holds the moment, and in future, what to expect. I think the pace at which we are moving, we might as well concentrate on the presenti and the future. Because past laurels, apart from nostalgia, will get you nowhere. Sorry, Basin Saab. But he's not a relic, let me tell you. He's one man. He's one man who is more futuristic than us even. He may be quiet, but that doesn't mean that his vision of the future is any manner limited. So what is the presenti and the future in a hybrid? And where is the governance headed to, and where are we placed? So AI, 1, deepfake, 2, digital crime, 3, cyber crime, 4, and 4, a cross-border cyber crime, cross-border digital terrorism, and of course international cyber terrorism, which is when countries and rogue elements within countries hack your essential services, which is what India has faced also. The governance here, reflective of the interface of the governance on the international scene, has to now evolve into a tribunal or a court of sorts to deal with this futuristic, this in presenti challenge that we are faced with. One is on the technological side. आपके पास unwanted calls आ रहे हैं, आपने spam develop कर दिया. Digital arrest हुई तो आपने उसका बता दिया, साहब digital arrest is bad, be beware. So you will have a technological antidote, like you had ना कि पहले चोरी चोर करते थे, तो आपने चोरी को offset करने के लिए you had various things in place. But now for this, apart from the technological, you need a robust legal regime. This is governance which I have to talk today. And what is that robust legal regime which will put the fear of God into those people who choose to tread on this nebulous line to say that because there is no coded law. So therefore, let us have a free run till such time that we can. So there has to be what I will now call a preemptive, anticipatory penal regime in place. You are not, and this is a thought that I am putting it before you. It is not that you, till such time that you are proven guilty, you are innocent. Pari materia with what the UAPA holds, paramateria with what the UAPA law holds or the POSCO law holds, this part should come in. Insofar as cyber crimes and digital and deep fakes are there, that you will be presumed to be guilty. And the law enforcing agencies, which will be very specialized, will have an internal mechanism. Wasim Saab, so much for freedom of speech. I'm sorry, but we have to pull the rug somewhere. Otherwise, it's going to go berserk. And not for us, but for the... We need to provide this. So as I was saying, paragraph 1, the other part is your mechanism which is there in the IT Act and the rules, which say that the intermediary will be notified and within 72 hours he'll pull it down and so on and so forth. I think that also needs to have a few more schedules and a few more regulations. It can't wait for someone to go. Now, please don't take, I did this matter in court. In the general election, there was this fake or what, constitutional changes. And that caught on so much that by the time that we could stymie it in court, it had probably cost 80 to 120 seats. So the governance, ladies and gentlemen, the governance in law is now not only the governance in law, it is the wider aspect of governance and security of your country. Because you are not having individual thieves who will come at night, crack jokes and pilfer away jewelry. You have conspirators across, and sometimes even governments who do not like you, despite the tariff. In the third quarter, you've grown 8.2. You've grown 8.2 now. Who is going to like it? And if this exponential continues, which I assume that there's no reason as to why it not, it could even go to 9 or 10. So yesterday, I was hearing a Pakistani anchor. He's quite a respected figure. Cheema Saab hai, wo ganje bilkul hai. He's more bald than even Batra Saab. हाँ, उसने क्या कहा, पंजाबी में कहा उसने, क्यों है तो वही के ना, but he's in the United States. So he's Tarar, sorry. Cheema has a lot of hair. Tarar doesn't. So Tarar and Cheema were debating. तो कहते क्या नाम अपना Tarar साहब भी 8.2 हो गया है. You know what his reaction was? And this is to do something with governance. It's not out of the way. He said 8.2 नहीं हो सकता जी, ये गलती लगी है तुम्हारी अखां च. 2.8 है. These are figures which you can't fudge. But if this is undigestible, then you will adopt every hook, line and sinker method to see that a country which is now on the cusp of being an economic power, as probably the fourth largest economy in the world, is brought down. So it's not some ego. There's a calculated regime all over. There are deep states, there are any things. And if your legal system of governance is there to withstand it in anticipation, you will not have saved not only the integrity and the credibility of your legal system here, but you will have also contributed to a very, very major extent of your national well-being, national security, and national राष्ट्रोत्थान. तो ये है आज का परिप्रेक्ष्य, या यूं कहें कि ये है आज का परिवेश जिसमें हम आपसे ये संबोधन आदान प्रदान हो रहा है. थोड़ा हिंदी में भी बोल लें, थोड़ी सी अंग्रेजी आती थी. तो बंधुओं, इसमें हमारा जब तक वैचारिक हम अपने मंथन नहीं करेंगे, जब तक वैचारिक मंथन नहीं करेंगे, और इस वैचारिक मंथन को देखो, संस्कृत में कहावत है संघ शक्ति ही. कलयुग में जो यूनिटी है आपकी, दैट इज योर ग्रेटेस्ट स्ट्रेंथ. और संघ शक्ति का सबसे बड़ा प्रमाण यह है, द पावर इज नॉट द पावर ऑफ द सॉर्ड. पहले कहते थे द पावर ऑफ द पेन. इट्स द पावर हियर. मनैव मनुष्यानाम कर्म बंधयो. यहां से मन से ही मुक्ति है, मन से ही मोक्ष है, मन से ही सेलिब्रेशन है, मन से ही आप 80 साल के बाद भी यंग लग रहे हो. ये मन ही तो अच्छा है. ये मन ही तो अच्छा है. आपका मन ठीक नहीं है तो आपका तन भी ठीक नहीं रहेगा. अच्छा, तन भी ठीक नहीं तो कुछ भी ठीक नहीं होगा. So everything begins here, and this has said कि wishing you all a very wonderful program here, which is organized as it was last year also. It was absolutely remarkable, very spick and span, and it's still doing better. I have friends who are sitting at the back. I can recognize some I can't because the lighting over there is not that much. सामने lighting बहुत अच्छी है, सबसे बड़ी light तो ये बैठे हैं. And so I think that's it. ज़्यादा बोलना भी नहीं चाहिए. युक्ताहार विहारस्य युक्तश्च कर्मसु. Everything should be in balance. और it's November 30th. It's a great day. Some foolish people were born on this day. And for whatever it is, it's the most beautiful time of the year. And you can be assured that Sagittarians speak too much, but they're very harmless. They have never harmed anybody. They'll take harm, but they'll not harm anybody. कभी किसी का नुकसान नहीं. ये लिखा है. मैं अपने मन से नहीं बोल रहा हूं. आज तक किसी सैजिटेरियन ने कोई बड़ा क्राइम नहीं किया. वो क्राइम के लिए कॉशन करते हैं आपको. So all the best. Keep smiling, keep laughing. It's a beautiful day. एयर में थोड़ी पोल्यूशन जरूर है, लेकिन अगर आपके माइंड में कोई पोल्यूशन नहीं है तो ये एयर की पोल्यूशन भी आपको कुछ नहीं कहेगी. आप जीतते और हारते अपने मन से ही हैं. तो इन्हीं शब्दों के साथ आप सबका बहुत बहुत धन्यवाद. आप खूब अच्छी तरह से खाना खाएं. दिस इज अ सेलिब्रेशन. ये कैलोरी शैलरी के चक्कर में ना पड़े. ये जितना गिल्ट यहां होगा उससे ज्यादा नुकसान होगा. आई एक्चुअली वेंट टू माई डॉक्टर. कहते शर्मा जी जरा टेस्ट करें आपका शुगर. मैं कह रहने दो डॉक्टर साहब. पंजाबी. मैं कह रहने दो डॉक्टर साहब. कहते नहीं जी करो. अच्छा आ गया जी 165. एकदम से चार्ट निकाल लिया. काउंसिल जी. मैं कह डॉक्टर साहब 2 मिनट ठहरो. सामने गया मिठाई की दुकान पे. रसगुल्ले. मैंने कहा रसगुल्ले खा के उस सीरा होता है ना उसका, वो पिया मैंने. मैंने परमात्मा को याद किया, बसीन साहब के आशीर्वाद हैं ही है मेरे साथ। डॉक्टर साहब हम देखो होनी था कि मैं कहा देखो ना 128 कहता हुआ क्या, मैंने कहा माइंड ठीक हो गया, खत्म हो गया। So it's there. So with these, please enjoy yourselves and thank you Batra Saab for calling me on a very special day. Thank you very much.
It's working, sir.
I hope you have understood whatever words of wisdom have fallen from the learned Additional Solicitor General. If you have not followed them, then it is your loss. इन्होंने हिंदी में बोला, मैं उर्दू का शेर, या तो ना वो समझे हैं ना समझेंगे मेरी बात, दे और दिल उनको जो ना दे मुझको जुबां और. Whatever he had to say, I think that deserves the attention of each and every one of us, because that is our value, that is our responsibility, and that ought to be the spirit of governance so far as lawyers are concerned. There is a prime duty on this profession, the only profession which is recognized in the Constitution of India in Article 22, only profession. Therefore, it's a big responsibility. Therefore, what he is talking about futuristic, those goals are already set, not just for lawyers, but for the entire country. Viksit Bharat 2047, and also importantly, Atmanirbhar Bharat. That is what Prime Minister has laid the vision for all of us, and we have to achieve that. Thank you.
Thank you so much, thank you.
I know some of you have flights, so first of all, clapping is good for heart muscles, so it'll be good for your heart muscles. It will. That's what the yoga teacher tells you. So for Mr. Sharma and Mr. Bazim, also Mrs. Sharma is there. So and thank you, Mr. Chetan Sharma. And you know, I was listening to you and don't have my phone fully in the conversation. And I know that you have a little Krishna. Whenever I meet him, even when he is doing his puja, I've gone sometimes, and he's always joking with the Panditji also, right? So there is always a feeling of taking things lightly while he takes them seriously for his work. I think that's the greatest quality. And when I was listening to his speech, I was reminded of in 1853, Swami Vivekananda went to the World Religion Parliament, and he talked about India and what India has to offer. I think if you have people like him in the kind of position he is in terms of their ethos, you know what he does every day apart from being the Additional Solicitor General. I know what he says on stage is what he really means. So we are blessed to have somebody like him amongst us. And, he said kind words about me, and being kind, whether I deserve those, he's trying to be kind to me. He's always kind to me. So please give him a big round of applause. We need more people he elevated the conversation to beyond legal, because we are thinking, I was recently on a podcast called Beyond Billables, because we're mostly thinking of billing, whether if you run a company or you're an individual. But I think he's elevated the conversation beyond law, beyond governance, about national security, because if our national security and the fabric of what we stand for is disturbed, nothing else will matter. Second is, yes, the pollution is there, but there's so much positive. Life is a trade-off. And I'm sure in the next 6 months, I don't know, I believe in God, I'm sure next year it won't be this. I promise you, it won't be. I don't know, but I'm sure the government will do something about it, because it should have done it earlier, but I'm sure it will do. And third is Mr. Bhasin. I jokingly sometimes say to some people that when I grow up, I want to be like you. But in Mr. Bhasin's case, the passion and the seriousness and the contribution he brings to anything that he gets involved, and he takes ownership. which is great. I tell my team, whatever he wants, please, anyway, a very high integrity. So thank you. Please give Mr. Bhasin a big round of applause. Mrs. Sharma, आइए. Bhasin साहब बोल रहे हैं तो मैं कौन हूँ? Just be. And we'll have the awards immediately. I know you have, some of your flights, some of you have changed it. We have a lunch and we have the GC 100 in the.
Thank you so much, Dr. Batra. Okay, now that you have first presenters, Chetan sir, because हमारे पहले presenters आप तीनों ही and ma'am as well for the award ceremony. We quickly start with that. My only request to the winners, once you receive your award and you step down, please एक बार stage left पे जाइएगा for your picture.
Not playing the jury heavy to save time. That's it.
Yeah, we have it. वो है, process पूरा है, निश्चिंत रहिए आप, जो list मेरे को हमें मिली है. And after that also step up a group picture. Again for editorial purposes, उसके बाद we will all have lunch together. चलिए जी. Our winners of the Global Legal Leaders Awards 24-25, can we have the first award on the screen, please? Award. We skipped the jury, maybe that is why. Let's go. चलिए. Outstanding achiever. Divya Hazra, co-founder, Explorer Legal. For Divya, everybody. Congratulations.
I would like to firstly thank BW Legal World for organizing such an amazing event. As for the award, I think I'm extremely humbled. It kind of motivates me every single day to kind of make a change, because I think, as mentioned, like, we have a very important responsibility in this society, and in our own way we should try and contribute that. Having worked, because I work in the India-China space, which is an extremely sensitive issue, I try and do my best to represent what we as a country believe in, our values and goals, and I hope I can continue to achieve that forward as my career progresses. Thank you so much for the appreciation.
Thank you. Because I also have to make sure कि वक्त सही चले, हालांकि हम थोड़ा नहीं ज़्यादा late हैं. So if you receive the award and you wish to give an acceptance speech, try and keep it to only 20 seconds. I know it is very tight, but I'm sure you're lawyers. You can. ठीक है जी, चलिए. Now we come to organizational category. The first, it's ADR Law Firm of the Year, and the winner, please. The partner to receive the award. The honors apex of excellence.
Thank you so much, everyone, on behalf of the firm, and many thank you so much, BW Legal. Thank you.
Congratulations. Aye. Our next one, it's Banking and Financial Services Law Firm of the Year, and the honors Outstanding Achiever. And the winner? And partners, we have with us Nishna Arora and Ayushi Parna, the associate partners who received the award. for them, everybody.
A big thank you to BW Legal for this honor. It's been an amazing journey till now. We look forward to serving our clients. It's for Team SNG. Thank you so much.
Please come. Winners, don't forget group picture in the end, individual pictures now. The next category is Best Service Provider to Legal Sector of the Year. Consulting, we have with us Pawat Singh and Sagarika Chakraborty, President and the CEO to receive the award.
Give Mr. Singh a bigger round of applause,
Thank you, Business World. Thank you, jury, for bestowing this wonderful coveted award to Iris Consulting. So we're not a law firm, we support lawyers. So we do forensics, expert witnesses and stuff. So we do treat, lawyers are the Formula One drivers, but they need the right team to win the race, so that's what we provide. Thank you so much.
Congratulations, sir. Next, it's Emerging Law Firm of the Year. And the winner, please. Legal, we have another founding partner, Rohit Sharma and Pranesh Goyal to receive the award.
Good afternoon, everyone. We're very, very grateful for this recognition. And as two 26-year-old founders, we know for a fact that this goes a very, very long way in at least proving that we must be doing something right. And this is for my team and everything that we've done in the last 2.5 years. Thank you.
Congratulations.
One of the things with awards is to discover new companies, new ideas, new people. And second is Mr. Basin said, we talked about in the morning, how young lawyers are starting their own law firms and how mid-sized firms are being merged or collaborating with other firms for talent. So recognition for people like you proves that that's happening. So please give them a bigger round of applause.
Thank you so much, Dr. Batra. आगे बढ़ते हैं. Next, it's Intellectual Property Law Firm of the Year. Technology and IP attorneys, we have as a managing partner, Ranjan Arula and Rachna Baku to receive the award. और तालियां applause guys.
Yeah, thank you so much. Thank you, Dr. Batra, for organizing such a beautiful event. And thanks a lot to the jury for having the trust in us. We are here to take the award, but the credit goes to our team and our clients, and of course the jury. Thank you so much.
Thank you. Congratulations. Congratulations. आगे बढ़ते हुए, the next award is for Oil and Gas Law Firm of the Year. And the winners, please. Associate Managing Director, Investigations, Diligence and Compliance Associate, also Managing Director, Investigations, Diligence and Compliance.
I keep saying that apart from the fact it's good for your heart muscles, it also builds your karmic balance. When you prepare, you lead the applause. So do it because you will need it. Can you clap for Mr. Amit Maharia? Thank you.
Thank you to the jury member and to Batraji. It's been an honor for this award, and I congratulate my entire team and the clients who have kept the trust in us. Thanks a lot.
Congratulations. Next, it's a real estate law firm of you're an outstanding achiever. A&M and partners here with us, a partner. Sudeep Cecil to receive the award.
Thank you, Business World and the jury for choosing us as the real estate law firm of the year. It's a matter of great pride for the firm and to all its members. And we're really grateful to Business World for organizing this lovely function. And once again, thanks very much for recognizing us. Thank you.
Congratulations. आगे बढ़ते हैं next it's restructuring and insolvency law firm of the year. The honor bestowed again is outstanding achiever. Robbie and Solomon partners, we have with us Jyoti Kumar Chaudhary, senior partner, to receive the award. For them.
Thank you so much, BW Legal World, for this recognition. Thank you, Shweta ma'am, for all the opportunities, giving all the opportunities to me and my team. Thank you all the clients for entrusting their mandates with us. Thank you so much. This gives me impetus to continue delivering excellence. Thank you so much.
So thank you so much, BW, for having considered us for this award. This is actually a team effort. Jyoti has been managing the restructuring insolvency practice for the firm, but I think it is the team which is standing committed to behind him, and they are the ones who really, really deserve this award. So thank you so much, everybody, for this this recognition. Thank you. Thank you to the jury. Thank you. Thank you, ma'am.
Yeah, please. Winners, don't forget individual picture, group picture in the end. इसी के साथ the next one, it's tax law firm of the year, outstanding achiever again. Raghasi Das Gupta, Executive Director and Head of Tax, to receive the award.
Good afternoon. Thank you, BW Legal, for the opportunity, and also the jury members and the August audiences, everybody. Thank you very much.
Congratulations. आगे बढ़ते हैं next. It's Real Estate Law Firm of the Year and the honor bestowed is of Excellence. And so we have with us Avnish Sharma, partner, to receive the award.
Thank you very much, BW Legal team. Really an honor for us, and it would have been possible without all the partners working through 7 offices that we have. And to the team, to our clients, thank you very much.
Congratulations. Thank you, Chetan sir, ma'am. Thank you so much. Thank you, sir, for episode of the awards. Thank you. Lalit sir, आपके भी थोड़े से रह गए हैं. Dr. Lalit sir, Dr. Basim, a little few more with you. Thank you. Now please request Advocate Rashmi Katpalia, Independent Director and former Director Legal of Technip Energies, to please join us on the stage and help us present awards for next set of winners, please. Ma'am. Chaliye, with that, the next award category is Banking and Financial Services Law Firm of the Year, and the honor, it's Apex of Excellence. Let's go. JSA Advocates and Solicitors, we have with us a partner, Nand Gopal Anand, to receive the award. JSA, everybody.
Thank you to the jury, and it's a testament where I'll thank to my team and the management for getting us over here, and thanks a lot to the client also having trust in us. Thank you very much.
Congratulations. We take the next one. It's General Corporate Law Firm of the Year, and the honor bestowed as Apex of Excellence. Mangal Das. We have with us Mohit Gotia, Managing Partner, to receive the award.
Thank you, Dr. Batra. Thank you, BW Legal and the jury.
I accept this award on behalf of all my colleagues across all our offices and our managing partner who leads the corporate practice, Mr. Cyril Shroff. I think all of us have worked tirelessly through last year to get us to #1 across all league tables on the corporate side and contributing to the 8.2% which many of our corporate clients contributed towards achieving. So thank you to our clients, thank you to all my colleagues.
Congratulations. चलिए जी आगे बढ़ते हैं. Next, it's Oil and Gas Law Firm of the Year. The honor bestowed is again Apex of Excellence. HSA Advocates, we have with us a partner, Abdul Narayan, Pragya Ori and Amresh Singh to receive the award. Oil and Gas Law Firm of the Year.
We're extremely grateful for this honor, and it's a great honor for me to receive it in the presence of Chetan sir. So it's absolutely wonderful. A huge thank you to our clients and the teams who worked tirelessly for us to be able to achieve this. So thank you so much. Thank you to BW Legal, and many congratulations to Mr. Batra for holding this amazing ceremony. Thank you.
Congratulations, man.
You know, Krishnendra has put this together. He works tirelessly. I do miss Garima and Ashima because they really built the base for it, but solely handled by Krishnendra. Thank you, Mr. Basin, for always being there, giving your time, patronage name. He was also our jury chair for our GC100 and co-chair for this. So please give Mr. Lalit Basin a big round of applause. Thank you. Thank you. I would like to request Mr. Tedin Sharma to come and give away the final few sets.
Thank you, sir. आगे बढ़ते हुए next, it's Restructuring and Insolvency Law Firm of the Honors Apex of Excellence. Shardul Amuchan Mangaldas. We have with us the National Practice Head, Restructuring and Insolvency, Anup Rawat, to receive the award.
Thank you, BW Legal, Dr. Batra, sir. I think this is for the entire team. I think they've worked tirelessly for this. Thank you so much.
Congratulations. Next, it's Tax Law Firm of the honor bestowed is again Apex of Excellence. Practices, we have the managing partner, Sohail Lathani, to receive the award. Not here? No mind, congratulations. चलिए, आगे बढ़ते हुए. Next is Bank and Finance Law Year of the Year. We now come to individual awards, and the honor bestowed is again Apex of Excellence. Senior partner, APB and Partners, we have with us Riyashad Goyal to receive the award. We still applause, though he's not here, but team members are here. Congratulations. आगे बढ़ते हुए, again individual, this is a banking and finance lawyer of the year. The honor bestowed is outstanding achiever. SLJ Partners, Managing Partner, Corporate and Non-Conventional Practice. We have with us Ayushi to receive the award on behalf of Amit. Congratulations.
I would like to extend thanks on behalf of Amit. Thank you, BW Bank Legal. Thank you so much.
Congratulations.
I would also like to call Sri Shashank Bajpayee ji on the stage to give away awards. He is a standing counsel for the state of Gujarat, standing counsel for the state of Orissa, and standing counsel for CBI, ED, and I can go on. But he just had an accident and he's come out unscathed. But it's commitment that he's still here at the end. His driver is not well, and that's what me and Chetan ji were discussing. And that's what happens. They do Rudrabhishek every day. They pray their obeisance to God every day. So I think they're discussing that. But give Shashank ji a big round of applause.
Thank you. आगे बढ़ते हुए next, it's Best Corporate Governance and Compliance Lawyer of the Year. The honor bestowed is Outstanding Achiever. Partner JSA, we have with us Nan Gopal Anand who receives the award. Nope. ठीक है. आगे बढ़ते हैं. Next is Dispute Resolution Lawyer of the Year and the honor bestowed as Outstanding Achiever again. Partner, Ramal or Associate.
Thank you everyone over here. Thank you BW Legal, Chetan sir, Sin sir for this opportunity. I would like to thank my parents, my family, my fellow colleagues for allowing me in unconventional journey where I started as an in-house legal counsel and moved into a dispute resolution practicing lawyer. So I want to leave with the note of two liners. किसी ने सही कहा है, मंजिलें मिलेगी भटक कर ही सही. मंजिलें मिलेगी भटक कर ही सही, गुमराह वो है जो घर से निकले ही नहीं. धन्यवाद.
Congratulations, Nitin. Moving ahead, next is FinTech Lawyer of the Year and the honor bestowed upon the winner is Outstanding Achiever. Associate Partner, SLJ Partner, we have us to receive the award.
Another thanks on behalf of Rashmi. Thank you so much.
Congratulations. आगे बढ़ते हैं next again FinTech Layer of the Year and the honor bestowed is Apex of Excellence. FinTech and Financial Services. Cyril Amateur Mangaldas, I will see now to receive the award. Congratulations. आगे बढ़ते हुए next is for Life Science and Healthcare Lawyer of the Year and the honor bestowed again is Outstanding Achiever. Ishan S. Nayak, General Manager, Legal and Compliance, Ananta Medicare Limited.
I'd like to thank BW Legal, Batra ji, and the distinguished members of the jury for bestowing this prestigious award upon me. So this award doesn't just belong to me, it belongs to my parents and it belongs to my mentors and my partners who have supported me and encouraged me throughout this journey. So thank you again for this honor. Thank you.
Congratulations. आगे बढ़ते हुए next is Private Client Lawyer of the Year and the honor bestowed is Apex of Excellence. The council decided eager to receive the award. He's the winner, Private Client Lawyer of the Year.
You rather bigger round of applause.
Thank you, BW Legal and the esteemed jury members. This recognition goes a great way, in recognizing that the specialized and deep work that we do for families, family offices, and business families on their estate, wealth structuring and succession planning. Thanks a lot.
Thank you so much. Congratulations. Thank you, Chetan sir, and thank you, Shashank sir. We'll do one more while they're occupied. Next one is Labor and Employment Lawyer of the Year and the honor bestowed is Outstanding Achiever again. Dinesh Pandey, Managing Partner, Next Alliance.
Thank you, BW Legal World. Thank you, jury members, for honoring me with this beautiful award. Thank you very much once again. Thank you.
You know, ये BMW, BW का कमीशन होता है। ये मुझसे पहले भी सुनी है। मैं भी हिंदी में बोल रहा हूँ आपके बात। When I acquired Business World, I started my first media company was 28 and a half, Exchange for Media. Those who are aware of Reality Plus, those are products I started. Business World I acquired 11 and a half years back. Still a long way to go, lots to improve, but we're in the play, घर से निकल चुके हैं. तो मैं रोज ऑफिस जाता हूँ जब दिल्ली में होता हूँ और मैं लेट तक काम करता हूँ, and you know that's my life. Those who work with me, in fact, last 2.5 days I had not gone to office, so everyone was very worried. So one day मैं एक party पे गया sir, तो मेरे को एक लड़की मिली और उसने बोला, so what do you do? I said I am at BW. So I come to BW every day, but I don't see you. I said I also go. So I said like I would know because if you had, but I said I have also never seen you. So she was referring to BW, the nightclub in New Friends Colony. And I was referring to BW Business World, so इसमें कोई बड़ी बात नहीं है. No wonder we had never met. So it's BW Business World and BW Legal World. And we have a long way to go. KJ has put in a lot of effort. Please give him a big round of applause. And hopefully we'll take our events to Bangalore, Bombay. We started a journey on 12th December 2019. That's when we did the first GLLS at Imperial. Justice Sikri was a chief guest. It was his wife's birthday. And then Shirupa, she's a very dear colleague of mine, doesn't work with me, one of the nicest people that I worked with. She's the one who put the seed for what we have, the Shima KJ. KJ has been involved from day one, and he's done heavy lifting every time. Thank you, KJ. Please give KJ a big round of applause. The shy person works hard.
Thank you, Chetan sir, and thank you, Shanti. Thank you. Thank you. I please request Raju Sasdevaji, General Counsel and President, JK Organization, along with Amrish Singhji, Senior Partner, HSA Advocates, to please join us on the stage and help us present our next set of awards. We'll have them also stay and you'll also join in. Aye. While we're being joined by them, next again it's Labour and Employment Lawyer of the Year. The honour bestowed upon them is Apex of Excellence. Rashmi Pradeep, Partner, Head, Southern Region, Cyril Amachal Mangalas, we have with us Soumya Kumar to receive the award. Congratulations.
Just 20 seconds. So thank you very much, BW Legal, for this recognition. With the labor codes, our quote-unquote support practice is going to take a new runway. Thank you for the recognition.
Congratulations. Aage बढ़ते हुए next, it's Real Estate Lawyer of the Year, the honour bestowed as Outstanding Achiever.
Thank you, BW, and thank you, jury, for recognizing me. I want to thank my clients for trusting me, and I also want to thank my team, my colleagues, my senior, my managing partner for all the encouragement and support. Thank you.
Congratulations. आइए. Winners, don't forget individual picture, group picture in the end. इसी के साथ next, it's Real Estate Lawyer of the Year again, and the honour bestowed as Outstanding Achiever. Ramesh, everybody.
Thanks for the award. Thanks a lot to BW jury, Dr. Batra, and it would not be possible without our clients and all team members.
Congratulations. Again, it's real estate law year and the honor bestowed. This time it's Apex Excellence. Sharma partner, Ketan, and go. अब why so much कंजूसी अभी आधे 10-12 रह गए हैं और
BW Legal, esteemed jury members, really honored. This is really, and I'm going back more inspired. Thank you.
Next is and the honor bestowed is standing achiever. And associates. We have with us Riddhi Ratan to receive the award. Congratulations. Next, we come to Environment Lawyer of the Year and the honor bestowed is Outstanding Achiever. We have to receive the award. Congratulations.
Thanks again, BW Legal. I'm collecting this on behalf of Radhika. Outstanding achievement.
Congratulations. Next, it's Environment Lawyer of the Year again, and the honor bestowed is Apex of Excellence, and the winner. Sudhir Mishra, Managing Partner, Trust Legal. We have with us Vikram to receive the award. आगे बढ़ते हैं next it's Criminal Lawyer of the Year and the honor bestowed is Outstanding Achiever. The winner, please. Celebrated lawyer, Sarki Legal. Prasanna, everybody.
thank you, BW Legal, for this honor. This pushes me to fight with more conviction and more clarity every single day. In criminal law, stakes are life-altering. So I feel that this award belongs to every client who trusted me with their freedom and every courtroom where I stood my ground despite the odds being impossible. Thank you.
Congratulations. Next, it's Emerging Lawyer of the Year, and the honor bestowed is Outstanding Achiever. The winner.
Principal Associate, Cyril Lavachan.
He's Emerging Lawyer.
Thank you so much, BW Legal. Thank you so much to the esteemed jury. This is a sheer blessing of my parents, not just as a kid, but in my professional journey as well, my sister, and my organization, Cyril Amarchand Mangaldas, for giving me the right opportunities, for giving me a wholesome environment where I can prosper. Thank you so much.
Congratulations. And we have another Emerging Lawyer of the Year, and the honor bestowed is Outstanding Achiever. The winner, please.
Sharma, Associate Partner, Crystal Law.
So thank you to BW for this well-organized award, and I would like to thank my mentors, my brilliant team, and my colleagues for being there, the clients for supporting and trusting us. Thank you.
Thank you, ma'am. Thank you so much. Thank you, Amrishi, and also Sathya. Thank you, Rajveerji, for helping us. Thank you so much. I please request Ved Shukla, advisor to BW Retail World, to please join us on the stage and help us present the last set of awards. Next, it is the Managing Partner of the Year, and the honor bestowed is Outstanding Achiever.
Managing Partner, MCO Legal.
Sorry for snatching the mic. The MCO members who have believed in the innovations we have introduced in our law firm. And like Sharma sir was saying in the earlier, that past, present and future, we have adopted technology where we believe in the, apart from the quality of your legal services, is the process of delivery of the legal process. Thanks a lot too, and I appreciate it.
Congratulations, sir. Akhri these are our hallmark awards that we're doing now. This is again Managing Partner of the Year, and the honor bestowed is the Apex of Excellence.
partner,
KZB and partners. When you receive, are here please. We have with us Priyasha to receive the award. Congratulations. And next, it's litigation law firm of the year and the honor bestowed is Apex of Excellence.
and companies, we have with us Manmeet Kaur, the partner, receives the award.
Thank you once again for this wonderful award and recognition of the work done by my firm and colleagues. Thank you so much. Thank you, BW. Thank you.
Congratulations. And the next and the last one, it's law firm of the honor bestowed is Apex of Excellence.
Bangladesh, we have with us the partner in Northern Region, Ajay Sahani, to receive the award.
Law firm of the year, everybody.
On behalf of the firm, many thanks to the jury, PW Legal. Just elated to be receiving this recognition on behalf of the firm. Thank you everyone once again.
Congratulations. And with this we come to the end of the award ceremony. But क्योंकि सारे winners यहाँ पर मौजूद हैं, the jury maybe there's something to say to all of you. That well wished as well. Can you please play the jury, Avi?
this year, we met a number of young, dynamic, enthusiastic participants. They were very keen and the jury, which was of retired judges, retired bureaucrats, general counsels, from the law firms, had some queries, and the participants with a lot of patience. We thoroughly enjoyed the participation, and as jury member, we can say that the selection process was absolutely transparent. Each jury member gave their own markings, which was not known to the other co-jurors. Therefore, the participants will be very happy with the outcome. So all the best to the leaders, and we look forward to them receiving the award. The best of luck.
I'm a proud recipient myself of BW Legal World Top GC Awards in 2024. Being in the jury for the 6th edition of BW Legal World's Global Legal Leaders Awards 2025 was a true...
Put it out on social media.
You will, yes.
It's a long one. We're running only 5 minutes in the morning, and then we've kind of gone off. We have the GC thing, and we need to thank Mr. Sharma for being here on a day that is important. Janamdin परिवार वालों के लिए हो सकता है, तो it's not about what he said, it's the bhav, and he's acknowledging everyone, trying to make them feel special, and I think that's the great quality in a person. So please give Mr. Cheti Sharma blessings and dua se badi koi cheez nahi hoti. I will dua. I checked 3 times on my team ki eggless cake hai, nahi to paap lagega hame. To ye eggless hai, main certify kar sakta hu. I know there's a group photo I forgot.
Yes sir, there's a group picture of the winners.
एक सेकंड में काट लेते हैं फिर कर लेते हैं एक सेकंड
आप पहले आगे आ जाएं for the cake cutting. Then all the winners please join us on the stage for group picture again, which is the most important bit for the editorial purposes. You all come forward for the cake cutting and then for a group picture after that.
Happy birthday
to you.
Happy birthday to you. May God bless you. May God give you long life and happiness. देखो कितनी सफाई से ऐसे ही आर्गुमेंट ऐसे होना चाहिए. Their lunch and शुगर कम करने का नुस्खा आपने आज बता दिया है बस काफी लोगों को कि आप रसगुल्ला खाएं तो उससे शुगर कम हो सकती है. अगर मन ठीक हो. गॉड ब्लेस यू. पत्रा साहब आप भी थोड़ी शुगर बढ़ा लो. कम होएगी.
Happy birthday sir, all the very best.
Very nice.
Before lunch we'll do a group picture with the winners as well with your trophies please. वो बहुत जरूरी है.
It's a good cake, I must say.
And 4 o'clock sharp we'll start with the next panel discussion. Sharp at 4. Winners please आइए. With your trophies. On the stage please. All the winners. इतने हैं. No, it's okay. All the winners please. Please join us on the stage. I've done it. All the winners please with the trophies join us on the stage. This is for editorial purposes for the magazine. Very important. आइए. Please come.
चलिए सर.
आइए प्लीज. And while all of you are here, 4 o'clock sharp, we'll start with the next panel discussion.
मैम आप आ गए
Thank you. Please enjoy lunch. Please have it.
Tanvi, can you?
Congratulations, Amresh. शुगर कैलोरी बढ़ जाएंगी
Hello. I would request everyone to please try and have the lunch a little quicker, because 4 o'clock we have the general council conclave. We want to start that on time. I mean late but on time. The second time we planned. My only request. Thank you so much. Thank you. Hello. Hello. We'll be starting in the next 2 minutes. I please request everybody to start settling down. 2 minutes और we'll start the next panel. Friends outside, अगर मेरी आवाज पहुंच रही है, चलो अंदर आ गए हैं. We'll start next 2 minutes. Thank you. Welcome back, everybody. It's my honor and a pleasure to welcome you all to the 5th edition of BW Legal World General Council Conclave. The Conclave and Awards 2025, it's a celebration of the revolutions brought by general counsels like yourself in the legal industry, where we will discuss and indulge in thought-provoking discussions to interrogate diverse dilemmas. The theme for this year, it's a celebrating excellence in law, in leadership, and also in governance. During the GC 100 conclave, we will witness experts sharing their insights during panel discussions on various topics of the law. And in the evening, we will celebrate the top 100 general counsel of the country in the 5th edition of BW Legal World GC 100 Awards. And before we move ahead, may I please request our team to play the BW Legal World Community AV. And we would request you to keep yourself updated of all the business world developments. Please subscribe to BW Business World's magazines. The latest issue for this time it features India's fittest leaders above 40 on how personal resilience and disciplined living are shaping India's new leadership mindset, along with the BW top 100 marketers who are redefining business influence in 2025. With that, may now request the team to play the legacy AV.
Years, BW Business World has chronicled India's growth story with credibility, transparency, rigor, and courage. Insightful journalism conversations and dialogues that go beyond headlines, decoding policy, powering innovation, and shaping how India thinks business. Editorial commentary from industry captains and business leaders. Driven by algorithms, stories remain journalist-led, backed by AI efficiency, not AI storytelling. Every fact, every quote, every number, verified, trusted, transparent.
And any picture that you share online today, any views or link online share karte hain. Please also use the hashtag BWLegalGC100, where 100 is numeric. We're also presenting this live on www.bwlegalworld.com and also all social media channels of BW Business World. इसी के साथ we'll begin with the next panel discussion. My only humble request, I think ये आपको बताना सही है, because हम वक्त में काफी लेट चल रहे हैं. My only request to all the session chairs, we want to end it on time, we want to start the awards on time. So we are going to keep a strict 28-minute timer panel discussion. The timer is right here for you. If not, they will make me stand up here and just stare at you, which is embarrassing for the both of us. But chaliye, usi ke saath, let's begin with the next panel, which is on legal as a profit center. How GCs add measurable value to business performance. Let's welcome our panelists up on the stage for this. Sushil George, General Counsel, Think Gas. Rajiv Malik, Legal Leader, LG Electronics. Amit Gupta, Vice President, Legal and Land Acquisitions, Purva Green Power. Joining them is Devasmita Nandi, Head Legal. Cinepolis, also joining them is Prakhar Sharma, General Counsel, National Investment and Infrastructure Fund. And this one will be chaired by Ved Shukla, Founder and CEO, Milomart, and also advisor to BW Retail World. Let's please welcome them collectively with your applause and energy. Thank you.
एक चेयर हटा दो. हाँ.
How's the Josh? आवाज नहीं आई. No, it's very difficult to moderate a session. I mean, chair a session after the lunch break. But good, we should have some energy now in the room. Can I have a round of applause for our panelists? I mean, these are accomplished leaders. Right from there, we have the money man, the lady who entertains you, Mr. Renewable Energy, and the cooling and all done by LG. and of course, think gas, so power. So, I mean, you can read their designations of wonderful people, accomplished, in the legal world, and I'm privileged and honored to be, having a session with them and having being in their August company. So, the panel topic is legal as a profit center. So how GCs add measurable value to business? Now the world is moving, the business environment is moving. Outside, I was telling them, I was heading a marketing function, and 20 years back we were the cost center. So marketing was a cost center, and we never bothered about. But over the years, the business environment has changed, and every money counts, every rupee counts, especially in the digital era when the marketing is measurable, every penny to, so I think that's what has happened also to the legal function, and legal function is now seen as a value add to the business, not only a cost. So that is the point of the discussion in this panel is. So starting with anyone who would like to start. The question is, how have you seen the role of the General Counsel evolving from a cost center to a value creating function within an organization in the last 5 years? Opening question to all, anybody can take. Or you can start one by one, I think that would be the best. Very briefly, how you've seen it change over the last 5 years.
Thank you very much. See, traditionally, if you see some 20 years back, or more in 90s and early 2000s. The legal was more of a litigation management, and whenever any litigation came up, so you were supposed to do the litigation management. But as the economy opened up post 2000, all cross-border funding came in, major multinational companies funding in India. So a different type of in-house legal job evolved, which not only involved your contract management, it involved your compliances, your various policies to be synced in with international policies, privacy laws, data protection, your M&A, your cross-border funding disputes, international arbitrations, international agreements. So a different game together changed for the in-house legal role. Today, it's not only litigation management, not only contract management. You have to be, your business, everything about your business, because any day-to-day decisions which have to be taken, legal is consulting. I cannot say, let me consult my lawyer. You should know everything, whether it is your M&A, your company law, your due diligence, your taxation, everything has changed today.
तो शुक्ला जी, यू हैव राइटली मेंशन्ड कि कॉस्ट सेंटर है हम. एक्चुअली दिल से पूछें तो हम कॉस्ट सेंटर ही हैं. अब ये
यही डिस्कशन है ना सर. It's not the same money you add value. So
now how the role is GC is evolved in the last few years. Now it is a paradigm shift actually from cost center to show management. हम cost center है नहीं, चाहे लगता हो आपको, क्योंकि हमें भी लगता था एक जमाने में, but अब नहीं है. Now we can project the things in a much better way, और बहुत ही paradigm shift हुआ है जिसमें we can show the management and ourselves also, to prove ourselves also that yes, we are not a cost center, we are now as productive as the another center, right? Can you give me example? For example, customer support department भी एक ऐसा department था जिसको हमेशा बोला गया कि you are a cost center, but in our company, right? Although these were used on my personal, right? So we have changed the model, where from the cost center, even that department is a profitable center. So why not legal, right? So it's a big challenge. Of course, it's a challenge. Still today, it's a challenge, right? But there are many ways which we will discuss in this panel only, that we can change the perception by really looking into the good areas where we can project ourselves as a profitable center.
Wonderful.
Thank you, Ved, for inviting into such a thought-provoking session. I would say, long back DCs were looked upon as risk mitigators, but the role has drastically changed. they are now known as growth creators. How they are growth creators, I give you an example, right? Earlier, GCs used to give an update on the deal closure as a vetted, negotiated, and closed the contract, right? Today's GC used to say, I have closed the contract, unlocking an investment of $10 million. Now look at the two statements. The two statements are completely different. From risk mitigation, compliance management, there is a ownership on the GC to retain value in the organization. See, legal pitfall erode your profitability. And, profitability lost cannot be recovered. If you are a watchdog on the business team, on the legal pitfall, you can preserve value within the organization, and this is a wealth creation. So although not directly involved in wealth creation, but the GC's role is indispensable in wealth creation today. I give you another example. The role of a GC is like an aircraft pilot. How do I say that? The primary role of a pilot is to fly an aircraft, but ostensibly, the responsibility lies with the pilot is to ensure that the passengers reach on time at their destination safely. Similarly, you have a strategy which is turned into a contract, right? GC's role is now more visible. He is expected to be an industry mitigate them. And how can these things be put into a contract to make it watertight so that whatever bottom line you have assumed, you are able to achieve at the end? So the role has drastically changed.
Right, and going forward, we'll be dwelling deeper into it. Ma'am.
Hi. I believe the shift has been happening for quite some time now. It's not recent. In fact, I am maybe the youngest GC in the panel, and I've been fortunate enough to step into the role without having seen this shift personally. So I would say why they would call cost center, it's mainly because in-house department would be mostly doing litigation. Litigation was, of course, expensive, right? I mean, that's the only place where in-house counsel end up spending money. But over time, because GCs have brought in so much value, like all my other panelists have mentioned, in compliance governance, in risk mitigation, in helping in closing high-value deals, in quickly turning around contracts, that over time, it's no more cost centers, definitely a very big support function to the, not only the business, but also the board.
Yeah, so that's why we put the panel topic, KJS, legal as a profit center. So that's the discussion. Prakarji.
Yeah, thanks. I think it's an interesting topic, but to start with, where you actually mentioned the role of the GC, but I'll take a step back and talk something about the legal profession. So I think some of my colleagues did mention that, earlier it was a localized litigation management sort of a department, but with the advent of businesses becoming global, complexities and multi-jurisdictional disputes, as well as, transactions and international investors also coming into the picture, things have become complex and to that extent quite competitive. If you look at it, all the returns that are expected from a particular entity by their stakeholders is actually risk-adjusted returns. So if you look at it, let me just try and analyze it from a financial, point of view. You cannot become profitable unless revenue increases or cost decreases. And that's where I think the real value of legal lies, that either we are in the revenue increase, there are some in which you have recoveries and, litigations in which you have saving. The part is basically the saving of costs. So if I'm able to save by doing some things proactively, for whether it is litigation or maybe assessing the risk and allocating the risk importantly, then I think that is where I'm adding value as a GC.
Awesome, awesome. So, what I could pick from your opening statement is that now, or somewhere, Amitji, I think you said that, you have to understand the business fully. Now, GCs is not only a role of as everybody agree that, it's not only litigation and stuff like that. You have to understand the business. So how that has changed in terms of the company seeing GCs as, are they the drivers? And then proactively, as you said, before anything comes up, are they involved in the decision-making process? And how does it go in the companies you are running?
See, I work in a company who has 100% FDI in our business. So for them, the role of a legal department or a general counsel is very, very important. So they do directly report to board. They don't report to CEO. And the independence, their own analysis, every business decision which has to be taken, these are on the board. Why they are on board? Because the businesses today are so much regulated, whether the risk involved in a particular business, whether you can do a business in a particular way or not, what penalties can be imposed tomorrow, what are the risks involved. So sitting on a business, on a table when the decisions are taken, GC is a very important part today. Not only in this, you have, whistleblower committees, compliance committees, due diligences. In every committee, GC is a part, and his opinion matters today. So apart from what I said, litigation management or general legal work, which a GC or legal department does, these are the new roles, and GC is recognized as a very, very business enabler who guides, strategizes with the business teams.
Just to add here, just mentioned, this is actually true and fact, right? तो बोला कि नहीं होगा, मतलब अगर नहीं करना के पास भेज दीजिए, नहीं होगा. आज today the scenario has totally changed. We cannot say no to it. So we have to understand marketing better than the marketing people. Only then we can guide him. So we can say, okay, yes, what you are saying, we can do it. Then how we can do it safely? That's more important. And another area where we have seen the dynamics changes from the how we can become the profit center. If the contract is there, right? For example, some project is coming, and we can see that contract we can get the $1 million per month in, right? But if the contract period is too long, and it has stuck with the legal department for long. So ultimately what we are losing the revenue. So the turnaround time of the contract vetting and negotiating, everything has to be on the legal. So in any case, we are now becoming as a important person in it.
So I mean the revenue impact have to be seen from, I mean the GC has to see the revenue impact and then work accordingly, which is very good. I mean GC reporting to the board, everybody, I don't know, all the organizations work like that. Prakhar, you fund companies and all that. So is it happening that, GCs are part of the board or reporting into the board?
So not exactly part of the board. That is basically you are responsible to the board in fund. So I'll just take a second to give the structure, because essentially we are India's sovereign backed fund. So we have foreign institutional investors, sovereign wealth funds, pension funds, and likes of other institutional investors. Plus we have directly the government holding it. So to that extent, we are extremely responsible, and we have to be on our toes all the time, whether it is about governance, it is about compliance, or in an overall scenario from a legal perspective, because this is we have to cater to the Indian businesses, but at the same time we also have to cater to global standards. So that is how we are. But as far as reporting is concerned, yes, we are directly there at the board, but not exactly directors.
Understood. Amitji, you have worked in various organizations, all kind of businesses. So how do you see the contracting, as said, Rajiv sir said, that when you do a contract, you are actually accelerating it. So how has the contracting framework changed? How do you help in accelerating revenues? And how have your perception changed or the way of seeing things changed in terms of contract management and stuff like that?
See, how we perceive the contracts has drastically changed over the years, and currently, basically the GC's role is not only, offense and defense, limited to offense and defense and risk mitigation. They are strategic business leaders. So their main responsibility is to align different business teams to achieve the organizational objective, assess the risk involved in a particular transaction, because you know very well business is a risk. Whoever takes risk can reap the profit or leave it on the table. If risk is assessed properly, right, probably business risk is assessed by the business teams, but at the same time overall risk, in terms of legal, industry perspective, environment, and you can say regulatory risk. Because, if you start with a particular project and you face legal regulatory challenge which halts the project, probably it eats up your entire bottom line. So contracts are drafted from a perspective where the risk is pre-assessed, right? There is a proper workflow analysis which is documented and probably digitized and compliance oriented, so you don't miss out anything, right? And you achieve the project within the timelines you have set for, because lingering the timelines means additional overheads, right? So as a GC, first of all, you are aligning the business teams to assess the risk, that no surprises come tomorrow while execution. At the same time, you are reducing the cost and timeline. So you are a watchdog on your contracts.
Awesome.
So, rightly mentioned that now we are not only the caution keepers, right? We are architect how the profit grows actually.
Yeah, so Debasumita, you are as you said, you are the youngest GC. So, young people are into technology. And so, we are talking about accelerating contracts for profits and stuff like that. What all technology enhancement or process enhancements you have seen or can be done to do this acceleration and, profit enhancement?
I must say that we don't use any technology apart from the usual ones, but no tool, nothing. In my view, just a tool or like a contract management tool, they are not useful until it is properly executed. So we have steered all of that. What instead we have done is we have set up processes. So what usually used to happen is that when the business would send a contract, they would not really send all the information. So a lot of time to get all the information from all the involved functions. So we have created a process where the intake, when they're sending the contracts for review, they send with full information at least once they have. So that gives us a full picture as to what is the transaction for which the contract is to be reviewed. That's one. So that has drastically reduced the turnover time, because that is a measurable KPI which, that's part of the in-house team's goals, and which is also shown to sort of showcase how legal department has been partnering with the business. So turnover time is very important. So we have set up a process of intake, and then the second aspect where the timeline was really getting stretched was, after the negotiation, everything is done, then what? Either business is clueless, they are trying to get it executed, it's taking time, lots of back and forth, printing and all of that is happening. So we've end up with a e-sign tool. So that has again really made their lives easy. So now they also know that the moment it is done, I can immediately shoot off an email, and that's how my contract is going to be signed. And other than that, of course, the usual measuring tools and trackers, which we measure sometimes in the Microsoft environment, which gives us, the in-house team, also the visibility as to how we are doing. So the TAT, whether it's reducing or it's in a comfortable range, And also there are sometimes those recoveries which are to be done, which are very necessary. And recovery, I think, is the sure shot way to show that legal has created value, that, we have recovered this much money. So all of that is also kept a track of, that this is the outstanding and this is how we have recovered. And it's not always through litigation. It's mostly through, notices and negotiations and over, across the table discussion. And the best part is, I think, business is now understanding and recognizing that. So for any of these sort of activities, they involve legal right at the beginning. So then, we are always there so that, things get done quickly, rather than earlier business would close commercial and then the legal negotiation would start. That is not the case anymore. It's a one set of negotiation right from top to bottom. Because, a contract is not commercial and legal. It's everything is legal, I would say. So that's how some of the processes we have tried to use it.
Great, great. Yeah, please, Rajesh.
Yeah, I'm saying you have asked about the technology, and yesterday I was with my MD sir for the strategy meet, and there was a last slide for request support. So I have only put one thing, that manpower, and he said no to it. I can only give you AI manpower, right? So that's the scenario which is going to be there, and for the taking just ahead what she has said regarding the AI and technology, that is the one part. I think there are still loopholes, no doubt about it, but if we have the data, in-house data only, and we trained it better, only then we can use that AI tool. We cannot use the public tool available in the market, but it has to be trained on our models only, our policies which we have drafted. Only then it can be successful. Of course, the future of litigation, I think the mediators will be putting the AI camera and Apple VR frame 3D things, then mediators can put. So that can be another scenario in the coming years.
Great. Yeah, Amji.
Add what eminent speaker just said. See, GCs have largely looking at contract as data assets now. So whatever experiences we had in the past, good or bad, those are incorporated in the contract, and the contracts are, as I said, standardized so that it takes minimum time to conclude the documentation, and strict compliance management ensure that we have the speed, standardized clauses and risk management. With all this, the idea is that we are able to conclude the contract fast, thereby saving the time, and the time is cost. At the same time, the adequate protections and indemnities are built and retained, right? Past experiences are incorporated so that, we do not come.
Awesome. So there are young GCs probably in the room and watching. So looking ahead to 2026, what would you identify as the most important area where GCs should focus to deliver measurable business value? So if you can just share.
I think, to me, the area which is untouched, and I would like to explore it more, is the litigation financing. The third-party litigation financing, which is very crucial, because sometimes, litigation is a long phenomenon. It takes years to settle, right? Sometimes, because of the, pressures that we have for top line, bottom line, and all those stuff, there are decisions to settle it, right? Whereas, we are confident that we are going to win it. If there is a mechanism where, litigation can be financed on the basis of its merit, probably you end up to, receive a good recoveries that will add further to your bottom line.
What do you think the GCs should focus on creating impact and value for next few years?
Next year, actually, I think what is expected of GC is the faster contracting, right? Predictable compliance, and then strong governance, data-driven policies, and then technology-enabled process, and a solution-oriented process also. So these things, I think, we need to focus more upon in 2026.
Now that data protection law is in place, so it's very, very critical for GC to implement the data protection law, then AI-enabled technological advancements in the systems, that's very important. Then timely closure of all the contracts and due diligences, that's very important. And end of the litigation wherever possible. Maybe it's the cost of, you have to settle some litigation, but no protracted litigation.
Understood. So starting with Prakhar, we'll close this in few minutes. Are GCs only reactive, or are you guys involved in, proactively looking at what can go wrong and then add value prior to things have gone wrong? Is there, so everybody, and you can also share your concluding remarks in how legal can be a profit center. So we finished.
No, so that's a very interesting question. See, in terms of, let me just try and answer the first one. As far as the role of GC is concerned on 2026, just to conclude on that part, I think technology enablement and be ready to, assimilate technology, but AI, I would think, is a word of caution because that needs to be imbibed in a calibrated way. There are a lot of pits and faults. Also, the, data protection needs to be kept in mind. More importantly, the governance framework has to be embedded in the beginning. Like, for example, if we are concerned, we actually get into the structuring and also start looking at the exit from the time that we are looking at in evaluating an investment. I mean, it's not even getting into the investment life cycle. So yeah, that is one thing. As far as the cost efficiency is concerned, I think stronger due diligences so as to be able to anticipate risk. Allocating the risk is equally important because then only you can have risk-adjusted returns that one is looking at. And more importantly, aligning the governance structures in line with the best practices globally. I think these are the central themes, I would think.
Thank you. Devasmita.
Just to also talk about 2026, goal for me personally, I want to focus on compliance because this is one area which doesn't seem very obvious as adding measurable value, but it is a very important area because one instance of non-compliance can wipe away a lot of revenue or growth. So definitely yes, compliance, I will be focusing on how to make it even more robust. Of course, it is presently very well settled, but something, of course, and everything can be improved upon. Secondly, yes, GCs have to be proactive at this day and age. That's what a true role of a GC is. There are many ways various organizations and teams try to achieve it. In my case, I am part of all the meetings, the weekly meetings that the business carries out. I am part of the quarterly reviews that goes on, so which gives me a bird's eye view of what's going on. And once I know that is when I can also percolate that down to my team. So my team is also aware of, the focuses maybe, for example, next quarter will be on strategic alliances. So when all the contracts that come for that purpose will be prioritized and quickly closed. The strategic review meeting. So these days, organizations are making their GCs part of all the key meetings, so that he or she is able to gain the insight and also advise when the time comes.
Thank you. So time's up. 10 seconds. Amitji, Rajiv, and Mr. Sushilji, sorry.
So my concluding remarks, so as organizations have started realizing that it is not only the business strategies which are important, but legal strategies, too, are very, very important for the businesses to achieve their objective and business goals, right? Whether it is, speed up the contracting, whether it is risk mitigation, whether it is, analyzing the potential risk of the industry, and whatever. So I think all those things are being given due emphasis these days.
Thank you. Rajiv.
So I would like to end in a poetic way, as I told. In 10 seconds, I have to end this poem. Let's see who can understand. It's a challenge for audience now then. So in boardrooms where numbers rise and fall, and strategy speaks in a measured drawl, the GC walks in, calm, clear, awake, a guardian of value in every decision we make. No longer the keeper of caution alone, the quiet architect of profits grown, turning clauses to catalysts, risks to light, finding revenue in the plain sight. In contracts, we count tomorrow's speed. In compliance, we turn the culture's seed. Through disputes, we recover lost gold. Through force, we protect dreams untold.
Processes. Now we have a shortage of time. We are all running behind. So we will try to keep our discussion very crisp. I will try to allow my panelists to spend as much time as they would like on the questions that are really intriguing. So what we've tried to do is we've tried to structure the discussion actually in a three-part model so that we are able to cover as much as we can. We'll start off with the foundational concepts of, how exactly do hybrid teams work? Do we really need hybrid teams? Why do we need hybrid teams? Questions like that. Go into, what are the practical implementations when we are talking about AI, legal ops, any kind of automation, etc. And then have a discussion on what the future outlook is going to be like. So without further ado, let's start with you, Roop, who is the farthest away from me. So why do we need a hybrid work model, and why is it that, in modern legal teams, we need to maintain, collaboration despite working in a hybrid setup? What are your thoughts on this in terms of both the teams as well as the technology that is required for it?
Thank you, and very good evening to everyone. Well, I think the businesses have changed now in today's scenario. We have more hybrid form of businesses. So looking at that scenario, I think hybrid teams, legal teams is the way forward. And as far as hybrid business teams are concerned, legal teams are already very stretched, so they have to work close to 12 to 15 hours sometimes, so it will also give them greater flexibility. It also brings in better productivity when your work hours are so stretched and you have to deep dive into a document. I mean, I personally like to work from home when I have to deep dive in a document. So it gives that kind of flexibility. It gives flexibility to the talent as well, and it will allow legal teams to attract talent because it will give better work-life balance as well. And as far as I think I agree with you when you when you raise this point that how this can bring in collaboration, because human collaboration happens when meetings happen face to face. But I think post-COVID, we have evolved as a system, as an ecosystem. There are shared digital channels, and there are, and then of course, human interface is very important. I think hybrid business, legal teams can have weekly check-ins, and they can also have, twice a week kind of where entire legal team is available in the office. So those kind of, processes need to be built in, and I think it's a way forward.
Thank you so much, Roop. Let's come to you, Komal. Why don't you share your thoughts, how exactly can law firms help in operationalizing these kind of hybrid, teams? How exactly would you see this in terms of, driving measurable efficiency and having a better client outcomes?
So there are two things. One, the law firm itself has to work with a multidisciplinary team, and that's what is hybrid working, where it's not just the lawyers, practicing lawyers who are working alone. They have knowledge lawyers with them, they have innovation lawyers with them. There could be an application development team working alongside. And then there are so many other roles in business services. So it is not a practicing lawyer alone who is doing the job. There are lots of people who are supporting in the entire transaction of whatever the lawyer is doing. So number one is, doing it yourself, practicing it yourself. And second is, how do you work with clients? What we are seeing is lots of clients are actually coming to us because we have been there and doing this from very early on. So, when now some of the clients want to bring in that same hybrid model in their own organizations, they're actually looking at us to share our knowledge and experience with them, and coach them on how they can work and how they can build a multidisciplinary team in their own organization. And then comes the question how both the organizations, the law firm and the client, can work together, who are both now having multidisciplinary teams. Multidisciplinary teams help a lot because then you get a full picture. It's not just only a practicing lawyer's point of view. You are getting to know, and actually, even before you are getting to know, you are assigning the right people the right job. So, I'm not doing something that I get bored of doing or that I don't wish to do. I am doing exactly what I'm meant to be doing. And you dissect roles and you dissect the work to assign it to the right people. Now, when there are right people on both the sides, the communication becomes very easy. The communication, each one knows what their role is in that entire transaction or whatever the, work may be. And the working of both the teams becomes very, very smooth. And with that smooth work, obviously the outcome is going to be superior legal service delivery. So that's really, the way to go about it.
Absolutely. You put a very important point. Both in-house and external law firms have to talk the same language. And if they're not using similar technologies, if they're not aware of, what is going on, it's very difficult to collaborate, right? So there has to be, matching of pace, both in-house and external. Absolutely agree with that. But then that brings us to an important topic, because it's not always that it's easy to pick up technology. there is somewhat a resistance a lot of times. And at the same time, there is also a different set of soft skills that need to be developed in order to be able to manage in a hybrid sort of a model. So coming to you, Preeti, what are your thoughts on, what kind of soft skills do we really need to make hybrid teams work like this?
Maybe I think just technology, I think you just need to turn it on. When in doubt, turn it off and turn it on. So look, Ojaswita, very interesting topic. Maybe just take a step back and understand a little bit about why we are in the future of work, hybrid working models. I think Igloo very quickly taught us that there are modern technology that is underutilized, that need to be utilized, and that we can all work together without being in the physical space. And of course, that shifted, economy from a real estate heavy economy to a perhaps slightly more technology heavy economy. Having said that, we're human beings connect, we're social animals, human beings like to connect person. A lot of the times we find that what is common sense is not always very common. We need to provide training and insights and direction for teams to work together and collaborate. But what I'd like to say is we keep it very simple. What is important is mutual respect. We drill down through a lot of training what you can wear on a Zoom call or a Teams call, how the simple rules of office work or professionalism continue as much offline or continue as much online, and it's very important for you to have that kind of emotional intelligence, mutual respect, making sure that there are no your dedicated workspace for when you're not in the office is as professional as it possibly can be. CRISIL is a very interesting organization in the sense that we have always had a large workforce that is not in the office. We're also in various countries where sometimes in those countries we don't always have offices. And so how do we make it an environment where we are able to provide the same consistent service delivery? Also, we put our employees in a client environment as well. So it's not just our systems, our technology, it is also client systems and client technology. I think my sort of very quick takeaways is that we need to ensure what we would enforce offline continues to be enforced online. The other thing that we find, and I understand that in forums such as these, we're working with cross-cultural, workforce which comes from different backgrounds in different countries. So what may be a general how are you may seem intrusive in another culture or another country. A manager may think that it's appropriate to send you a text on WhatsApp in perhaps one country, but in another country it may be taken amiss. Therefore, it's very important, as legal teams, to be aware of the various regulations that impact workforces across countries in which we operate, ensure that there is adequate training around that, and make sure that we manage and mitigate discrimination litigations, because those also happen and they are a reality. So it's very, very critical, high risk to ensure soft skills or skills that we don't often think of when we're all together in the workplace are equally stressed on and incorporated when we're not in the workplace. And more so we find this acutely so in a hybrid working model where we're not always coming together and able to have subtext and context and body language to clarify things.
100%. Couldn't agree more with you. As the general counsel of, having 16 countries across Africa, Middle East, APAC, this is something that we face. My general counsel in South Africa doesn't mind actually dropping a message on WhatsApp, like you said, but then in Australia, if you drop a message to somebody over the weekend, it's not considered very professional. Right, so I couldn't agree with you more, I think, and the complexity is increased by the fact that you don't meet them face to face, so you don't develop that relationship as strong that you would if you were meeting them every day. 100% agree with you, and I think that is an important aspect that general counsels need to consider when they are looking at hybrid models and implementing AI and all the buzzword that's going around these days, automation, etc. So thank you so much, Preeti, for sharing softer side of of technology. Let's now go to the hard part of it, this hard skills that in terms of what kinds of, things that you believe law firms or in-house teams should work on before they start implementing something like a hybrid and something like an AI tool and things like that, in terms of policies, in terms of regulations, in terms of governance?
So actually, these are two very distinct topics. When you're looking at a hybrid team, and that was really the peak in the pandemic. If I think that, telling people that, oh, my network is weak, or, I'm dressed in casuals today, and all of that should be acceptable, but actually it is not, then I need to be told that this is wrong by the guidelines. If I'm not given any guidelines, I get away with anything. So that's the policy for, hybrid teams when we talk about working, in various offices or at home. But when we are implementing AI, either we're becoming an AI first organization, or when we are beginning to start using AI, there are very different things that you need to focus on, because now you're transforming the way you're working. You are moving away from your old traditional ways. You're redesigning processes around the technology. And when we talk about AI, the first thing that people need to know is what are the do's and don'ts. Therefore, even before you talk about rolling out an AI technology, you first have to have the AI policy in place. Because again, it's like school. If you do not teach the student what is right, what is wrong, the student can get the student is going to say, I never knew it, you never told me. So therefore, such a big initiative such as AI, which has so many risks associated with the outcomes, it's important that you have an AI policy in place. Now, not just in theory, but multiple training and awareness sessions need to take place, where you not only run people through that entire policy that you would have drafted, but also some of the examples of what the do's are and what the don'ts are. So then that registers in people's mind. Now, alongside, as a law firm, it's very, very important for me to also take people's acknowledgement that they have read and understood the policy. Because, again, I can be saying that I'm doing this, but then if people are not understanding the policy, then what's the point? So I need their acknowledgement that the efforts that I have taken to teach you and to make you aware, you've also understood what I've done. After the AI policy is in place, then you can go ahead with the rollout, and then there are practical sides to the use of the technology, and what the use cases are, how best to use it, how do you keep communicating to people, how do you improve the adoption rate, how do you teach people to use the technology in the right intended way and not incorrectly and say the technology is bad and all of that. And alongside all of this, even before technology has been selected, it has to have gone through.
where it would have gone through all audits to check that, my data is not going to be used for their trading, my data is not going to go out the internet, etc., etc. So the InfoSec team would have done all those checks. Now, alongside training, communication, AI policy, implementation, use case identification, also is a regular audit by the InfoSec. Because you may have cleared the test once and first time, but you have to continue keeping up with the standards and the changing standards as well. Because the technology is so dynamic that today what may seem to be right and the best practice, tomorrow it's going to become outdated. So whatever is the change and however the technology is, advancing, so do my measures of auditing and confirming that it meets all the basic standards has to keep getting upgraded.
Absolutely. Thank you so much, Komal. I will come back to you again for some practical examples of, how we implement these technology. But first, let me go to Roop. So, Roop, when you look at your own organization, when you're looking at, how we can be future ready, how exactly can legal teams, better be prepared for transformation and for, any kind of technology barriers. What do you think? What do you think that we need to do in our teams to make them ready for the future?
I think first of all and the foremost is that they have to get used to the technology. They have to be digitally fluent, and that's the core part. And then secondly, they have to have a process mindset. Because when you are working remotely, you will be subject to more processes. So they have to have that project mindset. And thirdly, how they make their visibility and presence felt. So they will have to, because now for maybe 3 days, they will be working remotely. So they have to ensure that how they keep in touch with the business and are in sync with the business. So these are few things which are at top of my mind that they have to be prepared with. There will be some behavior changes as well. So yeah.
Completely agree. I think we will come back to you on exactly how we can actually develop these within our teams. But let me continue with you, Komal, because you talked about these technology, and we talked more on a hypothetical level. But if we dig down a little bit on the practical aspects, what do you think are the ways in which AI and technology and legal ops team can really support in-house teams, especially given everybody wants to get on this AI bandwagon, because it's such a buzzword. Everybody is experimenting with different tools. There are companies that are using off-the-market, off-the-shelf tools, because they are specific to legal. And then there are companies like CRISIL that cannot go to off the shelf because there are a lot of regulatory requirements, confidentiality, etc. So what kind of, legal ops and AI tools do you send for an in-house team?
So there are a number of questions in this one question of yours. The first is whether you should build or buy. Again, every organization has to decide for themselves.
That would depend on the regulatory requirement of that.
I mean, if I have to recommend, I will also deep dive into your processes. What exactly is your requirement? And if your requirement is for a build, then so be it. And if your requirement is such that there are so many tools already in the market, then why are you going to build and why are you going to waste your time? Rather go buy off the shelf. So really there is a build and buy strategy which each organization has to decide for themselves. If you are going by the build, it's obvious that you are going to have a team or an external developer who will develop it for you. And if you are going to buy from the market, it's important to go and check against your needs, what are the solutions available. It's not important to buy what is popular. What are the big names? Big names may be there, but you first check what your need is and accordingly match your requirements with the solution offering, and experiment with not 10. If you've selected 10 out of 10, again shortlist and come down to 3 and experiment with them and then choose the best. And that best has to be not just the product but also the team that you're going to be working with. It has to be both, because you may have a great product but a bad team, or maybe a less committed team. They're just looking to grow a little bigger and sell themselves off. And mostly I have in my experience seen, especially AI technologies, they're all startups who've
maybe some of them become unicorns, but the startups, the ones sold to one of the biggies, they don't bother about that product. And who's the ultimate sufferer? It is the client. So that's number one. Number two, how can clients and law firms work? Again, coming to that second question, depending on where you are, everybody is at a different stage in their. Some are already at a very advanced stage, such as my organization, and some are just beginning to even think, not even experiment, they are thinking now that, okay, now the world is moving and now it looks like that we will not be able to avoid this journey, so now let's get started. So some are there. Depending on where you are, you have to find that partner for yourself who will be able to guide you. Look, even when we started with the AI journey, we had some of our global counterparts who had already moved ahead in that. And we waited deliberately to see what they have to say. We didn't think that this one is the one where we need to be the first ones. We felt let's wait, let's see, and then we will, take. So really that's for each organization again to decide. But how I as a law firm can help my clients is by sharing my knowledge and experience. And if some of the clients who absolutely want us to handhold them, so, really then that would be called a consulting piece, where you want to engage me as a consultant and I handhold from your, from understanding your process from scratch, doing the entire process mapping, evaluating what is it that you need. Is it technology? Is it resources? Is it just some little process engineering? And from there, then identify the right technology, help you with the training, implementation, and also then that continuous learning. Then you're really giving me that entire responsibility of helping you with the entire selection and rollout, and then sustaining it, continuing with that journey. So again, depending on every client's requirement, some of them just come to us asking us to have 2 hours, 1 hour call to share our knowledge and experience. And while some of them say, can you recommend some tools for this purpose? Or I actually do not know what purpose, but you come and you meet us and meet my team, ask them what their problems are, and then accordingly suggest. So lots can happen, but again, every organization is different. So we need to decide when we meet the organization.
Correct. Absolutely right. I mean, I think you have hit the nail on the head, because what solution is best suited for an organization would depend on, one, how ready they are to adopt technology, and two, what exactly is their requirement, right? So for example, in my organization, we started using AI for contract review and things like that back in 2021. And we did not get an off-the-shelf requirement that fit us as a perfect solution. So we bought 2 different tools and we integrated them at the back end to make a perfect fit for us, right? So, absolutely right that it has to depend on what exactly is the requirement, and it has to be something that also, fits within the governance structure that you also talked about of the organization, right? But then there is also aspects of, you do all of this, you do the soft skills bit, you create a team that works, you get the right tools, etc., and everything. But then you have to also motivate your team to actually adopt that technology, and to the tool is useless if it is not adopted and used by the intended people, right? So coming to you, Roop, according to you as a leader, what do you do as a leader to motivate your team to adopt this sort of technology, to be more ready for adopting AI tools?
I think again the behavior and the cultural change has to be brought in, and that can be brought in by showing them some quick wins, showing them that they can be quicker solutions around things, and quicker and smarter solutions around things, which saves their time, and then also putting them through some data that these are the quick wins that we have had. So that can bring in a lot of mindset change. I think most of the lawyers, we are trained to not use technology unless we touch the paper. We don't derive that satisfaction, because touching the file, touching the paper, it brings in that satisfaction. So I myself I'm trying to change. I'm not reached destination as still, but point is that we have to evolve. So I think the faster we evolve to the AI set technology, the better it is, because it saves a lot of time.
Thank you so much, Roop. I completely agree. And I think, Preeti, since you are also a general counsel, I will come to you with the same sort of a question. What kind of strategies should in-house legal teams implement so that, we have an effective adoption of the tools?
So I have a few not so routine thoughts about it. So one of the things is that a lot of the times we have a conversation about what does legal departments do? What are we doing? Are we basically managing risk, mitigating risk? Are we called into the room when there's a big fiasco and you have to put out a fire? So I think some of the business case for adoption of technology is the fact that we get to participate in proactive and strategic risk management when the routine tasks are automated, right? And automation does not need to be as sophisticated as AI. It could be something as simple as a enterprise-wide contract workflow management. The other thing is that, of course, we are moving towards self-service models, and the more we can enable a self-service model, the more I can encourage or entice a smart young lawyer to say, hey, you're not going to be doing operational routine work, you're going to be doing strategic things. And the kinds of strategic things that we do are very, very diverse and very, very interesting. Also, a lot of the work that we do is creating a seat at the table, right? So we're not just business partnering, we're also business leaders, and we don't necessarily see ourselves as, you have a problem, let me come solve it for you. How about we co-create solutions whilst we're sitting at the table? I just happen to wear the legal hat. The other thing that helps and that I've found is very helpful is when you give them data-driven insights, right? Here's the data, here's what works. Like Roop said, demonstrate early wins. But you also have to ensure that the business case, the return on investment, the outputs are significant and that they are measurable and they are tangible. Also, before you can convince a team to use technology, you also need to convince a department to invest, an organization to invest, to make sure that your technology is going to enable. I often times get asked this question to clarify what legal in-houses versus outsources, right? Because there is still today a mindset or a perception that I have an in-house team and therefore I should not and need not outsource anything other than an appearance in a court. And therefore, one of the things that we also oftentimes are dealing with is what is it that we are doing as an in-house team, right? And if I give you a few examples, so very recently, we were tasked with, and because legal ops and AI is a topic of the moment, we were told that AI can potentially cannibalize our business. So when you're doing research and consulting and summarizations and you're using public and private data to provide research, how are you going to ensure as a business you have the right licensing models for how are you protecting data, you have the right licensing models, and how are you protecting revenue? And all of this comes at the back of the ethical use of AI, confidentiality, proprietary data, proprietary processes. As a legal team, are you even thinking about process patents? Can you go out and perhaps patent a index and things like that, because a lot of these are innovative, creative work. Of course, they don't always use hardware and software, so sometimes it fails that test. But these are the kinds of questions that we're grappling with. So the use case or the business case for adoption is fairly well established, but sometimes the fact that, you know, it's not still able to see that kind of ROI in the 1 year or the 2 year. So to show them value creation and to make them see the long road or the road down, you know, down the road, which they will see soon enough, is a little bit of our job to do, both with teams and with businesses and organizations.
Yeah, I think you have really touched a sensitive nerve for any general counsel trying to technology, because it's difficult figure to it, right? So I mean that's really something that is that needs to be measured, and that needs to be the panel before us was an interesting topic. You know, they talked about how legal can be a profit center, right? We are always seen as, so unless you set up a GBS, and we were having this discussion, unless you set up a GBS and you start selling legal services for profit, you cannot be, and then you lose what you said, Preeti, the seat at the table, right?
So I'll just add, you know, one point. More and more, I think businesses want to see lawyers bring their experience to the table, not just their legal know-how, right? So technical legal know-how we all got, right? What sets one in-house team apart, what sets one lawyer apart is how much experience he or she has, they've done it before, and how can they solve the problem. I overheard a conversation from one of the lawyers who was actually talking to you, and he said, do you want me to tell you the technical way or the practical way? And what was really impressive was that he found a practical solution. So experience matters.
Absolutely, absolutely. I think it's been a fantastic discussion. Before we close the discussion, can I spend a minute asking if anybody has any questions, or if any of my panelists would like to give any concluding remarks to add to whatever they have said?
I think I just want to conclude saying that legal excellence alongside digital fluency is really defining the lawyer of today and tomorrow. It's not even tomorrow, it is today. So all of the stuff that we've discussed, I'm sure since the morning, it must be the same discussions and the same terms must be being used continuously in all panels. Everybody has to understand that this is ground reality, and what will differentiate
law firm side of things as an in-house team, legal service delivery models matter. What are you looking at in terms of legal service delivery? How are you curating what the delivery model should look like? What are the tools or operations and processes that you're putting together to ensure that delivery? What is the value creation? And ultimately, what is it that can be self-service and require low intervention or low touch? How much can you make organizations independent such that they can help themselves? That really removes barriers. And we're here to solve the slightly more strategic problems, just like how you would go to your chief marketing officer when you want to come up with a marketing plan or strategy. You go to your lawyer when you want to do launch a new product, go to a new market, or do business in a new way. You have a new product and you don't know what to do with it, and you go to your lawyer and says, help me do business.
Absolutely. Thank you so much. I completely agree with the thoughts of all my panelists. I think it has been a very interesting discussion. On the topic of technology and adoption and AI, I think it's safe to say the future is not lawyers versus AI, it's lawyers who know AI and lawyers who don't know AI. So with that, thank you so much. You've been a lovely audience. And sorry for going a little bit over time, but it was an interesting topic. Thank you so much.
Thank you so much. And thank you, ma'am, for moderating that. Thank you so much. Sure, the next one, quickly moving ahead, it's on DP Act and AI governance guidelines, what business can expect in 2026. Please join me in welcoming our panelists for this one as well. Rajbir Sachdeva, General Counsel and President, JK Organization. Dr. Pawan Duggal, Advocate, Supreme Court of India. Joining them is Srinit Mishra, Board Director, General Counsel, India, Regional Senior Counsel, EMEA and Asia Board Corporation. Joining them is Talish Ray, Advocate and Managing Partner, TRS Law Offices. Also joining them is Amit Taneja, Partner, Ikigai Law, and this one will be chaired by Jagannath PV, Global Data Privacy Head, LTI Mindtree. Yes, please welcome them with your applause, enthusiasm, excitement. Thank you so much.
Good evening, everyone. I guess this is the most interesting time of the day. It's because it's just before your tea. But we'll try to keep you awake. And with this interesting topic of DPDPA, I'm sure all of you are aware that DPDPA rules are out on the 13th of November. And every lawyer who's working on personal data is all excited in trying to see how to meet the 18-month timeline. And also, in parallel, India has the AI guidelines that was passed, that was given to us by the ministry. Very interesting guidelines, more self-governed guidelines. So we're going to try and talk about both these aspects over the next half an hour. I know 5 people in the next half an hour is going to be a challenge for me. Of course, but the points that are going to be discussed are very interesting. Having said that, privacy as a fundamental right always existed in the Indian Constitution. But now we have a law called the DPDPA, which is the Digital Personal Data Protection Act, which gives empowerment to data principals, that's you and me. We have rights to exercise and obligations on data fiduciaries and companies to ensure they protect our data, they collect our data in a lawful manner, protect it with the right safeguards, and also have obligations flowing down to data processors to ensure our data is protected. So with that, having said that, let's dive into our questions on the Act as well as the AI guidelines which came out recently. My first question would be to Srinit, right? We'll cover the Act first and the rules, and then we get into the AI guidelines. Well, with 18 months to go, Srinit, I think the regulators have given us 18 months to comply with the Data Protection Act. Must it be a policy first approach, or should it be a technology first approach? That's my first question. And you can follow up with what do you expect from the Data Protection Authority or the Data Protection Board to facilitate in this journey towards compliance?
Okay, let me get started with the first things first. When you said about the fact that whether it's going to be the policy first or it's going to be technology first, I think both have to go hand in hand. Policy will define what is required to be done. Technology would define how it's supposed to get done. I think all of us who are present here have abundant knowledge about the kind of policies that will have to be introduced or have already been introduced in a number of companies, whether it's privacy, whether it's grievance redressal, whether it's your data retention and erasure, whether it's your consent management policies, and a number of others as well, including employee trainings. What's required to be seen or where technology would play a key role is about how these policies would actually get implemented. If the data has been retained, what's the technology, what's the process that's being followed? And if that data has to be erased once the consent has been given or once the request has been made for the purpose has been achieved for which the data was collected, if that is automatically getting done. Similar work is for the consent management as well. Exactly where I think the legal team and let's say the DPO or the IT team would work together to ensure that policies, the right policies are there and the right technology is there so that it becomes user-friendly. And that's exactly where the employee trainings would also be very handy, because what needs to be done at this point of time, if God forbid anything goes wrong, it is not a policy driven by declaration. It's a policy or it's a framework which has to be proved to the adjudicating bodies or to the authorities or to the data protection board. And that is exactly why both have to work together. Coming to the third question which you asked, what do you expect or what the companies would expect from the DP? I think one of the first things will be explicit and absolute clarity. Things like significant data fiduciaries, things like reasonable security measures, that have to be defined explicitly. I also have a board seat, and the first thing the board asks about are, what the repercussions penalties they're looking at? Oh, it's nothing much, it's just around 250 crores plus. And the moment you say that, at that point of time, they would want to understand what is the explicit security measure which I need to adopt to ensure that my company doesn't get prosecuted. And that is why an absolute clarity from DPB on a number of these similar aspects would be welcome. Secondly, as an industry, we would love if the DPB and other agencies actually conduct FAQs and sessions with different industries. Like I come from a manufacturing company, manufacturing, healthcare, IT, fintech. If those sessions are conducted with these to ensure that going forward, we understand what is expected out of us so that voluntarily a mistake is not made. So that is something I think, because of the paucity of time, these are some things I would really appreciate clarity from the authorities.
A very good important point that you brought out, that is the involvement of the regulators with the industry. I think that's key for the success of this act. So Mr. Dugal, the next question is for you. With minimum no obligation on the data processors, because most of the obligation or all the obligations is on the data fiduciaries in this act, do you see a challenge with the data processors aligning with the technology measures that is mandated by the rules and the nuances of the act? And especially in today's scenario where there are so many SaaS-based providers and other outsourced providers, do you think that this would be a challenge to align with, or do you think the regulator should have gotten obligations onto the process to make life easier for the fiduciaries?
Well, ideally, the data processor, if he wants business, will have to ensure compliance with the DPDP Act and rules. The law is silent, but then primarily it's the data fiduciary who's responsible for all the compliances. Data processor is pretty much in an insulated space. But when I look at holistically the reading of the IT Act and of the DPDP Act and the DPDP rules, I'm very clear that the obligations of reasonable security safeguards will have to be adopted by data processors as well, because in any case, they can also be potentially sued for 250 crore rupees in terms of fines, in addition to the data fiduciary per se. So I don't expect any running away. It would be far more better if there's more clarification. And I expect a number of clarifications coming in the next 12 months by the government on what needs to be defined as parameters defining reasonable security safeguards. You see, reasonable security practices and procedures are well defined under the IT Reasonable Security Practices Rules 2011. But I think with these safeguards being far more broader and covering elements like encryption and other stuff, which don't form part of the IT Rules 2021, more clarity is going to be required. And ultimately, the ecosystem is one and the same. Data fiduciary is not going to give business to the data processor if the data processor cannot indemnify the data fiduciary, and if the data processor does not go ahead and satisfy the data fiduciary that it's ensured compliance with the provisions of the DPDP Act and the rules. That, in a nutshell, is what it is. You see, it's a common boat. They'll all both either sink together or they will swim together. So it's not a question of that my role is slightly slated less under the DPDP Act, so I'll do less. Sorry. in practical business terms, if you want business, if you want to be protected, then putting these things will be very much in place.
That's a very important point that you brought out. If you want business, you better align with the Act, right? I think that I see it as a boon rather than a bane, not having put obligations on the processor, rather giving control to the data fiduciaries to be able to ensure that the provisions flow down to the data processors. Thank you, sir. And also, you brought out another important point that the Data Protection Board should be coming out with certain guidelines, which is very important as well. Like the European Union, the ICO and the EDPB guidelines that come out very often and to the fiduciaries, their controllers and processors. So the next question to Mr. Sakdev, it's now I think the industry has beaten consent a lot. So, but still, we want to call the consent part out. Do you see it as a consent fatigue? I think one of the key lawful basis of processing under the DPDPA is consent, right? So are you going to see, or are you suspecting there's going to be consent fatigue in the provisions of the Act, in the implementation of the Act, especially with the consent manager coming into the picture, right? And the fiduciaries need to start aligning with 2 or more consent managers apart from their consent management system. So is there going to be consent fatigue that's going to be built up, sir?
Thank you. Important question you have raised. Before I come to consent manager, we need to see the definition of consent under the Act. Now, Act defines consent. It must be freely given. It should be specific, informed, unconditional, unambiguous, and clear affirmative action, which means every consent shall be accompanied by or preceded by a notice given by a data fiduciary to data principal, and this notice must be clear and in simple language. Data fiduciary must state the purpose of processing personal data, and therefore, when he is obtaining a consent, he will have to go by the rigors of the Act. Now, there are deemed consent principles also laid down under the Act, and this is the legitimate use, where a person has given a voluntary, giving of personal data, anything for benefit of data principal for issuance of any license, certificate or permit based on use of previous data, anything which is required for the state and that is for under the law or in the interest of sovereignty, for compliance with any judgment, decree issued under any law, for medical emergency relating to health, or any other person, for medical treatment to any individual during an incident. In the cases where it will be deemed consent or legitimate use, and you don't to the data consent managers which you have raised as an important issue. The DPE Act defines a consent manager as a person registered with the board who acts as a single point of contact to enable a data principal to give, manage, review, and withdraw the consent and interoperable platform. What does it mean? So, be registered, he will require to obtain registration from the Data Protection Board. He will be subject to technical, operational, financial, and other conditions as described. The introduction of mechanism, what is the purpose? This enables a fast and efficient means of achieving data principle. The use of consent manager benefits both principles. This improved efficiency of consent, security and efficiency of personal data flows. Another will assist data principal in exercising their right of grievance with no efficiency. DigiLocker is a prime example of the possibility. The consent manager is likely to increase significantly over the next year as they use more and more online transactions and e-commerce. I think we will see more consent managers, but I think one caution is acting. Those activities will have to be clearly defined in the ambit of data processing or data processor. So I think that part we will have to have a clarification in coming years or maybe the 18 months period, how that, the consent manager and the data processor will have to be segregating their roles. Thank you.
Thank you, sir. I think you've laid down a very clear articulation of what consent is and how it can portray the act. To the next question, Talish, this one is for you. Very different question. I'm sure globe, approximately around 120 countries that have data protection acts or are coming out with data protection acts. India's DPDP is the only act that actually throws an obligation on the data principle. So meaning to say, if I put a frivolous claim or give incorrect information, I can be fined for a sum of 10,000 rupees per instance, right? So typically privacy laws are to give right to the data principle or a data subject, but having an obligation on the data principle and a fine associated to it, is that actually going to hinder data principles to exercise their rights? That's my first question. And second thing is, while data principles, on the hindsight, do you think it's also this obligation and the fine, primarily because you the disgruntled employer of the disgruntled so, Ms. Is this going to be a deterrent?
Yeah.
And or it's a good thing?
That's actually, to me, one of the most exciting parts about the Act. And, because going back, the Act has been around for a bit longer than the rules. And to me, when I and therefore, when we are looking at it, I think the step back is, let's also look at give to the data principle. And those are to change information, including information about identity and other things. To get section 15 in its entirety, essentially outside of safety, security, sovereignty, it is only subsections B and C, which talk about a responsibility to ensure that there is compliance that is there to all laws at that point in time, as well as no impersonation should take place. Therefore, what is there is a safeguard. And I know that there has been a fair bit of excitement for some of us who deal with the questions of rights of individuals, the system that has come up and the generative intelligence system that's coming up. But the other part to it is that these are merely safeguards. So I actually don't look at it. I think so far as the lawmaking went, I think the GDPR experience was taken on record because there is a deep crisis that we also have. Let's also acknowledge that the EU GDPR rules, the size of population is really small. Ours is a much larger size. Ours is also without being a fully integrated market, we have had cell phones long before reach the last mile connectivity, and with that the internet reached the last mile connectivity often before essential services. Therefore, there is also that risk that was felt in terms of data impersonation. And that is what has been dealt with. So essentially it is a system of care that has been introduced. And if you look at the language of the penalty that's imposed, it also says a fine that may be up to 10,000. So you see that itself is also left on to the board while it's deciding. So I don't see that as a penalizing regime. I mostly see it as a disincentivization for rogue elements to block the system down, wherein there is a lot of compliance that is being called for. There's going to be a lot of audit mechanisms that would be there. There's an entirely new processes that have come up in order to be able to safeguard one's right to privacy on the online persona. So this is a very minor part of it, but I think it's a step in the right direction. And eventually I also see the board being able to lay down far more expansive definitions towards section 15, because impersonation, yes, but for all the other elements, given of course our geopolitical dangers also that are in existence in the system,
system, I think it is something where we can turn around and say that this is not in that sense taking away from civil rights and liberties, instead ensuring that there is a concept of balancing the rights with certain responsibilities.
Thank you. I think that's a very good point you're bringing out. It's not a deterrent, rather it's more accountability and responsibility that is shared with the data principle. Right, Amit, this one is for you. The next one. This is a global problem, right? Data retention, deletion of data. So the Act actually calls out you need to delete your data once the consent is withdrawn or the purpose of processing is over, right? Whereas there are certain other obligations of other laws in the country, such as RBI guidelines and so on and so forth, that mandate you to keep certain data for a period of time. Beyond that, there are certain government organizations that come back to companies to be able to want to seek for data beyond the retention timelines quoted by RBI. Like say 7 years is RBI for financial data. But an example is Provident Fund. They come back after 10 years, 12 years, 13 years, right? So what is your advice to organizations on looking at such scenarios? Should they go hard and fast guideline oriented, like look at RBI, look at Aadhaar Act, look at several other acts and then decide on the timeline for data deletion? Or should we keep the aspects of government agencies coming back for legitimate reasons, not for any other reasons, and come up with a much higher timeline to facilitate everybody together?
No, thanks for that question. I think it's one of those really instances where the law itself on one hand gives you very clear retention timelines, right? It says for certain categories it lays it out. It says 3 years you're expected to retain, and in general everyone should retain for 1 year, because I think that's coming from the perspective of law enforcement requests coming in for data. I think for organizations, it's hard to give a blanket answer, but what I'll try and say is what is that path to balance, right? Where, like you rightly said, there are government agencies which could come 7, 8, 10 years later, or there could be legal obligations which require for example, under the RBI requires you to keep, your company records, or even the Companies Act requires certain records to be kept for a longer period. So the mindset needs to change, right? Like, one, you cannot be retaining on that off chance that it could come in handy later, we might be asked. I think there needs to be that mindset change that needs to come in. And what that requires is essentially a mapping exercise to be done, right? One is, what is the purpose for which I have collected, like very clearly tied to that purpose, you have a retention schedule around that. Over and above that, you then overlay the legal obligations that are at play. And with that, you get a sense of, okay, what are the additional periods and what are the kinds of data I need to maybe perhaps retain for a longer period. So that retention schedule becomes a very key part of this, and this mapping of both purposes, but also legal basis. So you split that exercise. And so that does one part of it. The second part is, even if you're choosing to, or you're required by law to retain certain amounts of data for longer than what the DPDP expects as the right retention period, then you'll have to find some ways of maybe putting those in an archive. So you're retaining it, but you're not actively processing it. I can't justify sending marketing communications to a customer who's not used in the last 6 years. It makes no sense. But yes, for say purposes of limitation, because there could be a dispute that customer has with me. So for 3 years, I will retain it, transaction records for that purpose. So there I'm storing it in an aggregation, active processing and archiving. Also downstream, if you're employing any vendors, it becomes very important to also the same processes that you had in place for, for your confidentiality obligations, non-disclosures, that at the end of a relationship or at any point, you need to make sure that your vendors have also followed the retention schedule that you've given them or have actively deleted it. So superimpose some of these incremental data protection obligations now on processes that you might already have in place, and that's a good, happy kind of outcome where you're achieving that right balance.
It's a very apt point that you're bringing out. Many a times the vendor contracts are terminated by the procurement teams, right? And they pretty much forget what data the vendor has about you, right? The termination is more on the contract and the revenue or the money that is going to be given, but not on the data. That's very important to bring out. And I think another important aspect that you brought out was segregating the data and then putting the retention timelines accordingly, which will be more effective. So I'm going to shift the panel now into AI, right? Mr. Dugal, this is for you. I would want you to respond to this. Well, the Indian AI governance guidelines that was rolled out a month ago, close to a month ago, actually calls out there is no need for an AI Act, right? It has around 7 sutras they call out, which is very much in line with the responsible AI principles. But they very clearly call out there is no need for an AI Act, and also say the relevant sectoral agencies should take the lead on regulations. Whereas they have come out with a structure on who's going to govern and so on, very clearly called out structure. But the point I'm trying to make is, wouldn't this actually end up becoming an after the fact act, because these sectoral regulations and the other regulations will kick in when something happens. If I had an act earlier, I would have taken into account the nuances to not reach there first. Right? While there are guidelines, but there are no obligations, there are no penalties for it. So what are your views on this, sir?
Well, with utmost respect, I completely disagree with the recommendations given in the AI guidelines. Why? Because you cannot keep your eyes closed at mid-noon and think that the sun does not exist. You have to open up your eyes very, very quickly. The world is not out of its mind to come up with dedicated laws on artificial intelligence, whether it's the European Union, whether it's China, El Salvador, South Korea, Japan, Hungary. So to say that, look, we in India, we are good with our existing laws and we don't have a new law on AI is nothing but shutting your eyes to the ground reality. The ground reality is that India will have to very quickly come up with a very detailed, comprehensive legislation on artificial intelligence. Why? Because information technology is incapable of dealing with aspects pertaining to AI. Further, the Bharatiya Nyaya Sanhita has never been drafted keeping in mind the AI paradigm. So trying to just justify that, look, our existing laws are the best and we don't require anything is nothing but closure of an eyes to an inevitable thing that's going to be happening. I believe India has to lead from the forefront. India is a natural leader of the global south. And what we do today will become the benchmarking standard for the world. So India will have to very quickly look at issues pertaining to accountability, transparency, liability, and even personhood. I'm of the strong opinion that India will have to grant first conditional personhood to AI and ultimately full personhood to AI. Why? Because the entire issue of accountability and liability is connected with the issue pertaining to legal personhood. And at the top of it, when you look at the latest trend that's now come from Japan and Hungary, the focus is turning on to completely different. Today, the narrow AI is the AGI coming in. The year thereafter should be the year of superintelligence. Superintelligence, which is going to supersede the cumulative intelligence of humanity as a race. Now here we are looking at such humongous existential issues, and we are all out in a cocoon to say, hey guys, the laws are the best, we are the best and our laws will suffice. Our laws are an utter failure in the face of AI, and the quicker we start realizing it, the better it is. Just having these AI guidelines in the form of draft IT Amendment Rules 2025 is not going to serve the main purpose. Why? Because the primary issue of deepfakes has not been addressed by the primary legislation. And no amount of secondary legislation can go ahead and supersede the primary legislation. So we have some intrinsic problems. I think in that regard, we've started something known as the International Artificial Intelligence Legal Framework Initiative, where we give an a la carte menu of legal principles to governments, saying you want to come up with a law on AI, pick and choose your legal principle depending on your national interest, and come up with a new law. So laws are coming in. You're saying that you don't require laws is just an indication of the fact that you're closing to your eyes to the fact that the last train has arrived on the platform and you are still not decided whether you want to get on the train or not. Because you don't know when the next train is going to come, and I'm very sure by the time the next train has come, you've already lost the battlefield. We have lost a lot of previous battlefields in the times of history, including after independence. I think we need to seize this. Even when I look at the guidelines, I look at various legal issues that they are highlighting. but they're saying, oops, this is okay, but no, our laws are good enough. I mean, it's time for us to be more pragmatic. Let's look at the examples shown in the European Union AI Act. Let's look at China. China has come up with 3 laws on artificial intelligence, including a new law that's come from September 2025, saying, guys, you will have to now label AI content. You don't do that, you go to jail, or you face unprecedented fines. Here we are saying we will only give a notice of 10% of the total content. Where is that 10%? Who's going to give that particular notice? Who's going to incur the cost for that? And ultimately, how will you implement it both within India and outside India? Most of the AI providers are located outside the territorial boundaries. I've been telling the government it's time that you will have to come up and adopt this concept of artificial intelligence sovereignty, where you have to say that my sovereignty extends not just to my territorial boundaries, it extends to all AI that are located in India or not, which is available on computers and computer systems located in the country. In addition, it will also include the right to go ahead and have sovereign large language models to protect your national interests. So a lot of work to be done. With utmost respect, I disagree with the guidelines, and I think time will only tell us what is the best way we can go forward with. Thanks.
Thank you, sir. Very well articulated. I think I agree. I agree with you. I mean, I think it should be beyond guidelines. Guidelines is self-regulatory, and then if I don't regulate myself, there is no penalty.
Guidelines have no danda of the law.
Yeah, exactly.
And in our country, without the danda, nothing works.
Exactly. Yeah, very true. Mr. Sakdev, the next question is to you on AI. Several companies are adopting AI. I think in the previous panel also there was one articulation saying we are in the AI race. It's really the AI race. I mean, even if you don't want AI, you want to use AI because you want to tell you want to use AI, right? Having said that, there is a lot of usage of open source LLMs and closed source LLMs and various types of LLMs. Even the authenticated LLMs by large companies are also purview to this point which I'm calling out. So I'm sure all of you agree the AI models have been built over time by streaming data across the internet, right? Which could include copyrighted information, intellectual property, personal data, and so on and so forth. And there are, especially on open source LLMs, there is very limited guardrails put around such scenarios. So what is your advice to companies which are actually working on such LLMs and such models that are being used to develop AI systems, and they deliver services to their customers, and in the midst of all this, they breach copyright?
Important issue, I think, when we are dealing with the generative AI platforms. 2 questions, and those are the important questions one has to keep in mind. Who owns the content that generative AI platform create for you? Who owns? That's the first question. Second, uncertainty about ownership of the AI generated work. Today also there is no clarity. We all are using AI in the belief that AI content is, all protected, it is compliant. But at the end of the day, if there is a non-compliance, it is going to be on you, not on the AI, the generative AI company, because you will be answerable how this particular piece of information was being used by you. So the second issue, while this is when we are using in India, and I think it is coming in the entire globe, legal system is being asked to clarify 2 things again. Bounds of what is derivative work under the AI. What is that derivative work, how it has to be defined. Number 2, what is the interpretation of fair use doctrine, which allows copyrighted work to be used without the owner's permission. Now, most of the time, AI is being used on the premise that whatever information or content you are going to get from the AI, that is legally permissible. Maybe there is a violation of the Copyright Act. Nobody knows. There is a violation of third-party rights. We don't know. So I just did some research before this topic was allotted this morning to me, and I found something very interesting, and I will share it with you. There is a case of Anderson versus Charity AI. There were 3 artists classed to sue multiple generative AI platform on the basis of AI platforms using their original work, and as a result, this was seen as an unauthorized derivative work. So I think, and they succeeded because the information which finally was culled out, and this could be seen that there's an imaging service provider, and this was the unauthorized use of the photos violating copyright and trademark rights it had in its watermarked photograph. So the AI which was generating the photographs was not, but it was copying the imaging services of the earlier AI work, and this was the watermarked photographs of some other artists which was being reproduced through the AI model. In 2023, similar case was filed where AI tools using data which were be seen as unlicensed works. These are all in US. This US case laws are there where the liability was then fixed onto the person who was using the AI tools. Now, I also came across one health case law. This is versus Dinerston versus Google. Health Insurance Portability Act was violated in this case when healthcare organization granted access to patient medical files for AI data company DeepMind. Data was used by the Google to train its AI for proposed potential patent. When it came to the notice that the patient files, and those were the medical files, those were given access without the consent. Obviously, no consent was taken from the patients. This was a case which was highlighted, and Google was sued for millions of dollars, and the people company is going to be, providing you, or you are taking the AI, should have the models which should be in compliance and properly licensed from the content owners. And this should not be something where you see a violation of the copyrighted work and they then take the interpretation of fair and do use the function. So I think AI content, while we are using AI, one has to also whether the information which is being derived is correct and is not in violation of the third right.
Thank you, sir. I know the time's up. I'll just give one more prepared. I don't want to deny them the second chance. So we'll start with you, Talish. Again, keep it just 1 minute. What are your views on the importance of AI, testing AI systems? Because using third-party tools, I think like Mr. Sakdev was saying, you can't nobody else's content, but you are the owner of the content.
The advice that we go out and give our clients in this. Now, number one, look at global best practices, because as Mr. Dugal before me pointed out, this is an entirely new world and an entirely new beast. And therefore, to turn around and say, well, this is what is applicable in India, but is not applicable. You see, those rules are applicable there. China's territoriality, that those functions are basically collapsing. So, while doing that, first run across a global compliance to see whether you are following the best practices internationally. Simply because technology itself, generative intelligence technology itself, is moving at a much faster rate than you and I can imagine. That's number one. Number two, have a very, very robust, transparent system. Ask for sources. Get down to the basic principles of any research. Go back to the source, ask for them, and ask them to give those undertakings that are there as to what their compliances are about. But very useful in the long term when we are advising and is to have risk assessment. Regular risk assessment, classify system, looking at also the ethical principles that are in. Those that tend to make a fairly robust system, but again, it is nowhere in keeping with what would be much better if there was a established legal system saying this is a checklist, go on for it. Because currently, like the Wild West, everybody is following what they imagine are best processes with very little understanding of what liabilities might arise should it be taken to court.
Sure, thank you. I think a very important aspect that you brought out was monitorability, which very seldom is thought about because everybody is thinking of deployment. Thank you for that. Amit, this question is to you. What are the, again, 1 minute answer, what are the contractual obligations you advise when you are actually delivering AI systems to your customers?
No, sure. And if you'll give
I know it's a huge topic by itself, but I'll give you only 1 minute.
And I'll tell you where the need for strong contracts comes in. Right? Value chain, you have a number of players. You have the model developer, like some create be integrating it in your systems. You're using it with your end customers. And there's a lot of talk around, a shared responsibility. But end of the day, regulators aren't necessarily viewing it that way. They look at, if you see the RBI's outsourcing guidelines, for instance, they say regulated entity, I will catch your neck. You use what you want to outsource certain parts of your processing, to an AI, you want to do it for any purpose. I'm going to eventually come after you. And therefore your contractual safeguards actually become very critical in that context, right? Regulators are eventually going to come after that point of, at the point where it's interacting with real world people and that. So up the value chain, it becomes very important to push certain responsibilities where you're sitting in that. So, a model developer will need to tell you that what your use case is, this is a fit for purpose. That representation warranty becomes very important. We were talking about IP earlier. Is there going to be IP infringement? So is your data set trained in a way that allows also becomes a market differentiator. So, certain tools that were one of the first to come out and say we will indemnify from any downstream like IP infringement. So those indemnities also become critical. So indemnifications, but also your ability to audit and verify this. You can't take everything you hear at face value. So up the chain, your ability to audit, ensure that things are being done according to what has been promised to you, become critical. I will just take the last 5 seconds to respond very quickly to Dr. Duggal. I'm not sure I agree with the need for a general purpose AI law. I think the regulators, at least this governance guidelines, say very clearly that they've done that mapping of risk and see for a large part of those risks, existing regulation does hold the field. Where there's a gap, you might want to step in and regulate or tweak existing regulations, because we should also be mindful that as a country, regulatory capacity is also something we kind of overlook. When we're saying, let's bring in a new law, do we have the capacity to necessarily implement it in a meaningful way? It's better not to have a law that you can't implement well rather than forcing one on the books is just, and it's something we can disagree on, but just wanted to respond to that.
Last question to Srinit. What are your views on, or maybe some examples on the biggest mindset mistakes that AI leaders have? Maybe if you can throw some light on that.
Okay, there are way too many senior people sitting in my corporate career. A lot of times AI is being a technological tool or project and change in complete mindset. So what all organizations, including myself or my organization, I work for a Fortune 500, we should be doing from a leadership perspective is that view it as a capability. Like you see marketing, like you see sales, like you see finance, just as a technical project. And invest in platforms, absolutely, but invest more in people. Your success and your company's success while using AI. Just say, okay, AI is just a technical project and I'll look after the intricacies later. I cannot allow my ego to sort of, my inflated ego to be very vigilant about what we are doing as an organization. So if I just, AI is a mindset change to embrace. It's not just accept it as it is. Thank you.
Wonderful. Thank you. Thank you to each of you for your wonderful sharing of experiences and your points of view. Well, with that, I think we have really run out of time. I would like to end with one note. Data literacy and AI literacy is, I think, one of the key and most important aspects for the world today, because if you don't know how to use your data, I'm pretty sure all of us in this room would have given our phone number for 10% more discount in some time or the other, right? Even I have done that. So even if you don't lift, I know you have done it too. So, and similarly, AI, the usage of AI, we may find a wow factor, but you should understand why you're using it and what happens behind the scenes. And I can quote several examples, but then again, no time for it. But again, thank you very much for the wonderful panel and the kind of points of view that was shared. I hope it gave an insight into an overview of the DPDP Act rules and AI guidelines that we were wanting to intend to talk about. Again, thank you very much for your patient hearing, and with that, thank you again.
Thank you so much, sir. Thank you for moderating that. I'm very sorry for the time a bit. It's not in my hands today, but please, aye. Thank you so much. And thank you, Jagannath, for moderating that. Thank you. With that, it is now time to move ahead with our last panel discussion for today's sort of culmination of everything. This is the GC's agenda for 2026. Leadership, risks, governance and strategic priorities. And to share their views on the same, please welcome our panelists. First, our Sundaram General Counsel, Senior VP, Legal and Chief Compliance Officer, NEC Corporation. Dr. Kumudni Sharma, Head of Legal, Indian Oil. Joining them is Bhavna Ranganathan, Senior Vice President and Deputy General Counsel, Legal Compliance. Joining them is Devashish Roy Chaudhary, Head Legal Compliance in Solutions Global. Also joining them is Preeti Wadhwan, Head Legal India and Regional Head of Compliance India APAC, and also ME. And this one will be chaired by Zameen Athani, Global General Counsel, DNEG. And Zamir has... I'm the fire brigade. Let's welcome them with your applause, everybody, please. जोश में शुरुआत सुबह की हुई थी, अगर वो सेम जोश let's all welcome them again, no? Thank you.
So, thank you everyone. Good evening to everyone. It's been a long day, but we'll keep it. We are also looking forward for everyone, right? Okay. Is focusing completely the leadership, risk, governance, and the strategic priorities as a general counsel on the high level what you see, right? Like for example, you are hammered with some 5 principles. They always say that every leader, whether you are a general counsel, CEO of a company, or a chief marketing officer or anybody, 5 components is what is required for your success. Leadership. So leadership is all about backing your role model, leading from morality, do the right thing. You want to run a long company, long term. Which you can outsource to tech so that you can more focus on your productive work, on your productive time. And 5th is execution. So you plan, but if you don't execute, you are not a good leader. So leadership, strategy, culture, operational efficiency, and execution. That's what the stalwart panel we have today. They are all well-known general counsels of the country. They've spent their time. They have done their metalwork at the organization, gone through ups and downs where the organizations were in the news for the wrong reasons, for the right reasons, etc. And they have laid out all on the leadership where conceptually earlier the CEO of the company would come and say that I will take a business call. It's no more now because one bad news can cost your stocks in the stock market, right? So that's the leadership skills, the risk and governance appetite, and the strategic priorities, which we will discuss today. All right? So just going before for the first question to my panelists, just give you some raw data statistics of how legal role is now increasing in the organization and how it is globally now recognized. So Indian corporate sector is projected to grow at about 9% annually through 2026. Over 72% of the Indian CEOs expect legal leaders to play a strategic, not reactive role. 65% of the Indian general counsels now participate directly in enterprise strategy discussions. 58% of the boards say regulatory complexity requires stronger general counsel board alignment. 47% of the general counsel in India now manage cross-functional teams beyond legal. 60% of large Indian enterprise plan to invest in legal technology in next 18 months. Leadership roles for general counsels in mergers and acquisitions have risen by 40%. 54% of high growth organizations rate the general counsel as a culture influencer. 3 out of 5 Indian boardrooms prefer general counsels with business, digital, and governance fluency. That's what the power of the general counsel and the legal role we are talking about on the leadership side. And my first question goes to Debashish. We have discussed about the strategic role of the general counsel. We have seen now the numbers, what importance has now been placed by the organization, CEOs, boards of the company, chairman. Everybody sees the governance news by way of newsletters in the morning, emailers. So that's the board's role of general counsels. Now, how do you see the boards in India are expecting the general counsel to be also an early warning system and a strategic interpreter of India's fast changing law? You have DPDP rules coming up, you have something on AI, some modifications in intermediary guidelines happens, labor codes have been introduced, overnight some guidelines comes in from Reserve Bank of India, etc. AI governance, competition, etc. That will impact in next 12 to 18 months. How do you become early warning systems for the company and the board on these aspects? Your views.
Thank you, Zamir, and thank you BW Legal World for making me a part of this stellar panel actually. A lot of experienced GCs over here. So I think it's a fascinating question, Zamir, what you have asked actually, and let me answer it in parts actually, and let me give some practical context also into it. So the question what you have asked, I think this is something which I have lived in last week only. So we had an extensive audit committee meeting, and in that audit committee meeting, basically we had few agendas. The first agenda was with respect to this entire regulatory landscape, what changes, what we are seeing. The DPDP Act, the AI governance, the labor codes, and since it's a fintech, I come from a fintech organization. So basically we have a dual role of seeing the financial compliances as well as the tech compliances. So the next piece was with respect to cyber strategy, cyber resilience and all. So when I have made the presentation from my legal team's end, basically the presentation what it covered, it was not only the legal part of it, but how it is making sense to get it converted into business strategy. So what we call it in our organization, basically it's more of a LBS kind of thing, which is legal, business and strategy. So the most important aspect was the questions that were asked to me, like when I have given a presentation on DPDP. So I have given that background saying like the DPDP Act with the rules coming in 3 phases. So first starting the data protection board and the consent management 1 year from that 1 year from now, and 1.5 years from now the entire rest of the provisions. So I've given the explanations in terms of our role as a data fiduciary or our role as a data processor and how we are managing the data breach compliances obligations and also the data localization. The first thing they've asked, are you working in siloed manner or are you working with your team? With the entire team, cross-functional teams and all.
Do they also inquire on the fines?
Absolutely. So basically the first question in terms of data breach, they've asked me, are you working with the cyber security team? On the data localization things, and also they've asked, or the data verification and background, are you working with the HR team and all? So when my presentation I had given, I have included everything and all the parts were covered. Like even from the product perspective,
what kind of, what you call as privacy by design and all these things are getting implemented or not. So the moot point is, it is not about a legal presentation, it is a cross-functional presentation that they wanted to, and they're very senior audit committee members, they wanted to understand. So that was the first point, to address your regulatory concern and all. The second part, basically, in terms of the role, the tectonic shift, what we are seeing, the role of GC now, and what the board also expects to see, that how I am handling my stakeholders. Like if I talk about a stakeholder for a GC, it is not only about the shareholders or the board members and all. It covers the employees, it covers the vendors, it covers the suppliers, it covers your private equity investors or strategic investors, everyone. So whether I'm having a right kind of a mindset and approach in terms of handling all these issues. I'll just give a typical example. Like in one of the association what we have with strategic partners, we have a MSA where there is exclusivity clause actually. And that exclusivity clause was actually not helping us in terms of going ahead with the competitors, in terms of reaching out to them for business with the competitors. So since I joined this organization much later to this particular MSA, so I find it really challenging how we can channel that, because marketing team used to come with all the competitors bids and all, say, go with those competitors. So we are not able to do that because of that restriction in that clause. So basically when we are drafting that clauses, we have to see that we are covering the business aspects also in mind and not only wearing the legal hat. Did you advise them on the abuse of position also? Absolutely. That's the and we got it changed actually. You made an amendment and we got it changed also. And the third most important aspect is that when you talk about risk mitigation strategies, it's not only about the legal risk. Legal risk is one when you talk about the regulatory and aspects and all. But you have to see the cyber resilience, cyber security risk, the data breach risk, your financial, operational, other risks and all. So the sum and the long and short of my answer actually at the first instance is that it has to be a cross-teaming kind of environment. You have to understand the business both from legal, business and strategic front. And just to end on this, as the quote often goes, probably in many organizations, if you don't have the accountability and overall culture into it, then basically culture and accountability eats your other aspects for breakfast. So that you have to understand. So that is my first comment on that. I'm happy to hear from others here. No, I agree with you. So that's a Harvard quote only. Culture eats strategy for breakfast is the quote. Basically, the idea is that, like that Warren Buffett said, that you require a person to be, there are three criteria where he said 1, 2, and second is integrity. He said if the third is not there, then the first two, energy, etc., intelligence, energy, and integrity. If integrity is not there, then intelligence and energy is not the right thing to ask for. Just final point, like I have my board members who are up 75 plus and all. Okay. And I'm just find it amusing. They're so much curious to know what DPTP obligations, AI governance and all these guidelines. They are curious to know about it. So where we are at a much younger stage, if we are not putting that effort and investment, so that's very wonderful. Place. Yeah. Very wonderful for a board because they are governance conscious. And plus you have those multiple projects, cross-team projects which are going on. So that's the way you have pulled out a solution on your leadership part as a general counsel. Preeti, question to you is that the general counsels of the company are gradually getting into the roles of CEOs of the company, managing directors of the company, board members. I myself a board member in Singapore, UAE, etc., cross country. Today, and this was a trend earlier in United States, where if a candidate has a law qualification and he goes for a position of a CEO, they would prefer the person with a law background because the expectation was that the CEO of the company who knows the law will better manage the company, right? Now, when you think about in today's time, governance is seen as a value driver and not a burden, okay? Because the company is CEOs and everybody has now recognized that it's hardcore that if a bank gets a fine and it gets reported, it's not only the board member, but if you have big investors, Blackstone, BlackRock, etc., they will put down an email to you questioning what went wrong, please report, right? These are conscious things. How do you think as a general counsel, you can encourage business leaders to see governance as a value driver and not a burden? Because at times it's looked upon as administrative, tedious, burdensome, till you break some breaking news and then you realize the importance of governance. How do you do that?
Very interesting. Just one thing to add to what you said as a comment. It's working. Hello. Well, I'm loud enough, generally, yeah.
Yeah,
So I'm
normally
saying
if
it's not only your PE investors. I think the question is being asked a global organization also with a lot of internal stakeholders where you kind of get asked this question. So I think very good question. I shift. It's not something that traditionally the role the legal function was playing or the general counsel was playing has gone a fundamental change. Thanks to, I think, social media and the news that, the kind of quick news that you get in, any kind of wrong, news for an organization, it's out in the newspaper and everybody gets to know. So I think that's kind of a, one of the points for an organization to see where do they see themselves. Fine. So I think, and when I as a general counsel would look at, how do I build that credibility with my stakeholders internal primarily, where I tell them that, doing the right thing or being compliant is not something which is burdensome, but it is going to get you real value is by making them understand what I'm bringing to the table. Fine, that's very important. So I think with ESG laws, when it came in, still I know a lot of organizations, mid-sized organizations see ESG as a burdensome thing because that brings cost to them. But when you see the benefits in the long run, they reap so many benefits that possibly it outweighs the cost. Fine, and you look at it more from a holistic perspective. So I think when it comes to my organization, I can give you an example. So let's say, for example, we talk about supplier due diligence, and that's one very important aspect of our working, where we have a complete program as to what kind of third parties do we work with, due diligence program in place. Now, if I roll it out, as to say, okay, this is something I'm saying as legal and compliance, we have to roll it out, you may not get that buy-in from the organization, from other stakeholders, because they see you as a burden, because you are trying to impose new things on the organization. And possibly for them, it may mean you're delaying the process. You need to onboard the supplier very fast, there are deliveries to be made, and legal and compliance is pushing something which may derail the process. That's where you kind of make them understand as to why you're doing that. Because if you get in a wrong supplier, you don't do a proper due diligence, you may end up working with a supplier who may be known for, non-compliance, who may bring you reputational damage, which is damaging for you in the long run. And I give some classic examples within my organization all the time, and I'm sure everybody is learned, everybody is aware. Long time back, it's been many years, there was a news around Foxconn as a supplier for Apple. Fine. It was in the headline and the front page of the newspaper that they were non-compliant with the labor practices, I think around, working conditions or something. And while Apple would not have endorsed those non-practices, for sure being a brand that they are, but they were also, the news headline says, Apple's major supplier. Do you want to see yourself there? Or do you want to associate yourself with suppliers where you don't get into, news like this? So that is where, when you educate your stakeholders to see that why do we incorporate a new process or bring around new, compliance practices, something like a DPDP. I think what he has done is another fantastic thing. What all of us, I'm sure, in different contexts would have done is educating your stakeholders the importance of compliance, and like, our panelists before were talking about, when you tell them about a 250 crore penalty that the act is coming up with, obviously it brings value if you're compliant and you don't want to end up, paying high penalties. So I think that's one important thing, is that you navigate or, make your stakeholders understand the value that you're bringing to the table by telling them the stories of cost and the negative reputation that brings, that brings with not being, kind of being compliant. So that's how I would say that, that's how things are progressing, where now boards are understanding or stakeholders are understanding that being compliant and following the legal and compliance advice is not a burden, but something which will give them success in the long run, reputational, protect them from reputational harm, may also help you with, not having disruptions, because if you engage with somebody who is kind of non-compliant, tomorrow the government may say shut down the plant till the time you fix it.
Absolutely.
So you don't want to get into that.
And that's what happened with PTM.
Yeah, exactly.
The RBI asked them to stop the business right on the day, and they had consequences for that.
So that's where they understand the value that you are bringing by, ensuring that you're compliant.
Correct. I think that's a large message. One I see And this is a drastic change because, we have been here for around more than 2-3 decades. And the drastic change what we are seeing, the board having an oversight, the cross-team functioning, the conscious awareness about the risk governance to the company organization itself. Paytm, one of the examples we took. These have all gone a very wrong way, and I think much has been also contributed because of social media and the news which is available the next second, that has played its role itself. But again, on the numbers also, it's not only about the companies doing wrong, it's also the regulator which is now into action. So today, Reserve Bank of India, SEBI or any authority like CCI, etc., if there is a news that, if you book an Uber via using iPhone versus Samsung, the Competition Commissioner is very watchful of this situation. Let me give you some 2-3 numbers before I go to the next question on geopolitical, right? SEBI has increased enforcement 30% in last 3 years, right? So if the complaint gone up by 35%. India stem from poor legal oversight. Whistleblower complaints in Indian corporates have grown 20%. 40%, as Devashish pointed out about the boards also, 40% of board want deeper compliance dashboards curated by General Counsel. That's the trending situation we are there. Going to the next question, we face this situation of political situation, we face changing regulations which are flowing in every day. Bhavna, my question to you is that with this ever increasing complexity around global political scenario, right? Today, if you're doing a business with Iran, or you have been buying Russian oil, or you are trading with certain country and something goes wrong, and there are changing regulations. GDPR, of course, has been there as, draconian for a lot of people, but because of the level of the fines they charge. What kind of mitigation strategy for the legal department to convince the organization business, or there are consequences to follow?
So I think we obviously live in a fairly complex world. Or even, while pandemic was on, there was just competition now increased multifold with your Russia-Ukraine war, with what happened in the US in terms of, the HB1 visas, your tariffs, etc. That today is real for all of us who are doing roles in legal and compliance regulatory functions. And those conversations are real not just because you're being asked, I think you are being asked to see how that law then transforms into action. Doable risk, not doable risk, every point. So gone are the days where you would just be told, send me on notice and what kind of impact this will have. Now the expectation is that you know where the organization gets impacted. The questions are interesting. They don't want you to pitch the regular dashboard. They want the compliance person who's sitting in front of them to tell them, how are you mitigating this risk? What is your short-term view? What is your long-term view? So I think to my mind, the roles that all of us play from the traditional GC roles where you were responsible for contracts, you were responsible for compliance is now more and more complex and interesting times ahead for us.
I think, and just to support her view on further statistics we have today for the day, 1 out of 3 listed companies face some form of regulatory notice now. 62% of investors evaluate governance as a top investment criteria, right? One of the examples Preeti gave on ESG. Previously, when you used to have investors putting 5,000 crore in your company, they would give ESG as a guidelines in annexure. Those nomenclature of guidelines have now become obligation, which means if you don't follow ESG, if you breach any norms of environment, social and governance, whether it's a posh complaint, whether it's anything to do with the fraud in the company, etc., they can terminate the contract and call back for the money. That's the difference in the level we have found. ESG non-compliant penalties have increased by 30%. Board and general counsel closed door sessions have increased by 45% to strengthen oversight, and which we will now peculiarly see. The board wants to sit down with the general counsel of the company to understand, was there any fraud, because they understand that either the general counsel reports to somebody as a CEO or a managing director. This is what JP Morgan addressed it very well. So the general counsel of the JP Morgan company reports directly to the chairman of the board. So none of the CEOs or managing directors can come and say, this is my business call, please sign the contract. Because his reporting is directly to the chairman of the board. He is as neutral and independent to say to a chief executive of a company, you can't do this because this is not legal and therefore not permitted in my opinion, right? That's the independence movement we have seen. Amber, you have seen the whole world, you have seen the heydays dealing with NEC Corporation, government affairs are involved, government people are involved, the leadership side of it. One is the, I wanted to know, how do you steer on this leadership side of a general counsel, keeping governance in mind, risk in mind, compliances in mind, when there are projects like DG Yatra, right, which is one of the app which is made by a company. The government wants to launch the project, the government also wants to have access to the data, but then there is risk, compliance, governance which is involved. If there is a data breach, it can be in the news that NEC Corporation was one of the companies which is handling this. How do you steer your management and board to also upkeep with that while launching such massive projects?
Thanks, Zamir. So I'll keep the discussion very generic, not confined to my organization because of obvious reasons.
4-5 pointers from you. Words of wisdom.
So just keeping it generic, general counsels, and this is not a new trend. In fact, this trend has been there for last 10 years now. General counsels are now becoming very, very integral to the business and very close to the senior management. Regulation coming up in India, the way regulators have become oversensitive in today's world, every management, the shareholders, the board, everybody is wanting the general counsels to apprise in this. Counsels overall has a very, very critical role to play, because if anything goes wrong, the first question is to the general counsel. Now, general counsels have a role in keeping the management ahead of time. You just mentioned about the artificial intelligence. It's a huge disruptor that's coming up. Organizations are incorporating artificial intelligence into their core businesses. There are data which are going to show that incorporation of artificial intelligence into the system, into the core business areas has increased productivity, right? So all these things, the general counsels are grappling with it. End of the day, general counsels are required to keep the management, the leaders, the stakeholders apprised of the potential risk that comes up, and that's where the leadership is all about. Does that answer your question?
Absolutely. And, but just from the perspective of how much do you interact and how much is conscious the board about these compliance and of non-compliance, what's the up to down instruction? Organization, yeah.
No, any organization.
Any organization. Board, and I agree.
Yes. To take position that, okay, there is a today, because of severe regulatory actions that is coming up, and we talk about all the agencies, ED, so aggressive 5 years back. Absolutely. It has suddenly become very, and I'll give you another very interesting aspect. Today, what is happening is one regulator is talking to another regulator.
Yes.
So there is one set of offense which will have multiple subset of offenses, and therefore everybody will get involved. And it's a huge problem for the board, huge problem for the organization. So the situation is severe regulatory actions, and therefore even the smallest of the organizations want to play very safe. The best thing to play safe is to remain on the right side of the law.
Agree. I think that's the board itself is now a conscious board. Since 2014, when the Companies Act changed, I think there was some touch point to that. But now I think the news on governance is too much circulated on the fines and penalties, and all regulatory authorities are also very proactive. You never know at one point of time, we were told by CCI, you never know that your company must be under some study of abuse of dominant position. So that's the kind of level of interactions are there at the regulatory body. To go to you, Kumudina, you know, you work for a company known as Oil India Limited, traditional sector, sensitive sector, lot of data, sensitive data with organization. As a true leader, you have adopted artificial intelligence in the legal team. Just give me or how your management was proactive that AI in the department of Oil India Limited. You know, we see it as a tradition. How did you achieve that as a great leader?
Okay. I think in the business sector, everything is driven by the cost. So you would know the crude price have stabilized between $60 to $65. Our cost will remain the cost. We are a PSU, which have certain additional burden of the governance and the compliances. So in any business, there is a cost factor. The cost optimization is there. So in today's world, if you think of optimizing the cost, we are looking something around 1,000 crore cost optimization. So where do I cost optimize? That is technology. That is a simple doing The process is still going on because digitalizing the process is a long-term process. You have 10 processes, you build in five more, 10 more. So it's an ongoing process. It is still going on.
But as a leader in an organization on the legal side of it, did you see enhancement of efficiency and productivity by using AI?
Yes, definitely. Technology does help. To my view, technology should serve me. Like technology should be my slave. It should not sit on my hand. If I have that capability of training the technology to this kind of a perspective, then going to aid your efficiency and your operational efficiency.
One is the efficiency and productivity. Did it help you on the turnaround time, and are you only using for India or even global jurisdiction?
We are the company which has got presence in seven countries. So all the jurisdictions, the work pertains, it is relating to my work. I am not jurisdiction specific, it is only for India or abroad. So it is across my work profile.
The leadership, what we were looking at from this particular forum, 2026, because that is what we will really give you in the last month of the year, that what should be your priority for 2026, specific survey for general counsel, and what's going to come for future for the legal. First, we spoke about the board consciousness with Debashis. Second was about governance has now become a value driver. Third was on the mitigation side of it. Leadership leading the organization, CEO, board through and throughout for being a conscious board and the organization on governance, and actually implementation of artificial intelligence in a mammoth organization like Oil India, and also using it for the efficiency and productivity. That is what the great leaders here are leading about. We are conscious of time, and therefore we wanted to really give you the tangibles. Instead of more questions, we wanted to give you one question, but a lot of inputs in that from the experience point of view. For 2026, when we go, the strategic priorities which were laid down by statistics and surveys on the legal front, on the legal side, legal fraternity, the legal side of it for the organizations and company is the legal transformation is the top priority of 70%. Contract automation will reach about 50 to 60% organization. Over 1 billion is expected to be invested into Indian legal tech market by 2026. 55% of the Indian general counsels plan to centralize compliance into enterprise-wide platforms. Legal teams are expected to upskill in AI, data and analytics by over 60%. Indian M&A market is projected to grow about 25% annually, increasing GC involvements. Litigation cost in India is going to rise by 12 to 14% each year. 70% of the GCC India centers are adding legal compliance and ethics units. Cross-industry collaboration on compliance and digital governance is growing 30% year on year. This is for 2026 on the legal side of it. Thanks once again to all the great leaders here, the mammoth years of voluminous years of experience, and thank you for your time and the views which you have shared. Thank you so much to the audience also for listening us. Thank you very much.
Thank you so much. सबने टाइम बहुत बचाया है. But thank you for ending it on time, sir. Thank you for moderating a picture. This was the JC's agenda for 2026. Leadership and strategic priorities. Thank you, and thank you, Zamir sir, for moderating that. With that, we come to an end for the panel discussions of today. A couple of keynote addresses by some very senior members of the fraternity, and then we'll start with the RGC 100 Awards ceremony as well. Please join me in welcoming to the stage Ms. Manjuri Chaudhary, Senior Executive Director, General Counsel and Chief Compliance Officer, Maruti Suzuki, India. I only see her table getting excited for this, nobody else. Yeah. Thank you. Thank you so much.
Hi, good evening. Wonderful to see a room full of people. I'm sure you're waiting for the stand between you and the awards for more than 10 minutes. And reason to speak is because I always like to come to a BW League event, that I have a long association with, so the commitment is there. And this time they asked me to speak on something which I'm sure is something that we all think about. So the topic is charting the next frontier, excellence in law, governance, and strategic leadership. It's broad, it's very relevant, and I think it has some very interesting aspects which, if you lend me ears for the next 10 minutes, I hope to share some of my views and thoughts on the same with you. When we talk of today's legal world, so to speak, we are at a very transformational period. Today, the legal fraternity looks different. We have the litigators were always there, then we have a whole slew of law firms, and then we also have the in-house community. And together, this whole bunch of people have exponentially grown over the last couple of decades. And today, when we look at Viksit Bharat 2047, and we looked at Atmanirbhar India, the role of the legal fraternity becomes exceedingly important. It is already important and will continue to grow. And therefore, we as legal practitioners in different forms, who are sitting in this room today and those who are outside and even otherwise, we have a huge role to play. Now, why do we have a huge role to play? I think there are very compelling reasons. One, the country is coming up with a regulatory regime that is so fast evolving. We are wanting to become a developed nation by 2047, isn't it? That's what we all hear Modi ji talk about. That's what Viksit Bharat 2047 is. And some of you who may have attended the GCI event in September, we talked of legal reforms with a view of Viksit Bharat. What is the requirement at that point in time? So to keep pace as a developed nation, to become a developed nation, you need to regulate many, many things. Things that we didn't think about, say for example, data, which is today the new oil. So we need some regulations around that. A few years back, we had competition law come in. 2 years ago, we had the world of ESG sort of exploded around us. And then we started having the BRSR reportings. Gradually, every day, now recently the AI guidelines have been brought to the public for comments. So you see is moving very, very quickly, very fast, and therefore fraternity really becomes our job to see and to keep pace with that. So that is where I feel enforcement again. So companies, clients, stakeholders, shareholders today are more concerned that nothing should go wrong. Are we really, well assessed for risk? Are we looking at the right aspects? Because in the growth path of any organization, the last thing you want is to be slapped down for the wrong reasons, right? So that creates a business discontinuity. The second part of the equation is governance. Usually when we think of governance, and usually when you think of ESG also, E, S, and G, environmental, social, and governance, the first thing that comes to mind is, compliance with all the laws of the land. That is there, I feel. That is the prime basis of that. But it has a bigger dimension than that. And you will appreciate that who does these compliances in any organization, anywhere? It's the people who do it. Without people, you'll not be able to have those compliances. So therefore, even a step more important than just pure management of statutory compliances is having the right kind of culture, having the right kind of integrity, professional integrity and ethics become increasingly important. So today when you look at IPOs, today when you look at investors, you look at shareholders, you look at your own investors and shareholders, I was very surprised at the Maruti Suzuki AGM earlier this year in late August, when one of the shareholders asked the chairman a very interesting question. He said, "What is your ESG score as opposed to last year?" Now, that is a very telling comment. You see shareholders, Maruti ke shareholders ऐसी बात कभी पूछते नहीं थे. And I remembered it. I said, wow. And somebody had to quickly, of course the numbers were there and they were fed to the chairman and he spoke about it. So shareholders, investors, even your customer today wants products which are compliant, which are environment friendly, and they want to be part of companies either as shareholders, investors, or customers, or even employees, companies who are well governed. So by good governance is not only restricted to just making sure that you're meeting the law, and that is, you've got to move to a level above that, which is about making sure that you have focus on ethics and integrity. So it's just not about the compliance of laws with the external environment, but it is also internal compliances. Do you have the right kind of risk assessment committees? Are you looking at risks appropriately? Is your management involved in those risks? Is the last person standing on the shop floor or even in your office, the youngest employee, understands what good governance is? What kind of training regimes do you have? What kind of a culture do people walk into in an organization when they say that I'm proud to work for an organization that's well governed? So this becomes another area. Alongside with that, I think none of us in this room can say that we can shut our eyes to another very important aspect that has really taken off in the last 5 years, which is digitization and technology, and now AI. As lawyers, sometimes we think that, at least I, to start with, to be very honest, always felt that, our brains are far more important than just some tool that is going to aid me into doing things. But gradually, over a period of time, I have changed my thinking to the extent, not that we, as lawyers, our minds are not important, they always will be. But I have come to an understanding that there are things that digitization, good technology, and AI can support you on. So while we take our time to get used to it and see the relevance of these things into our everyday working, I think it's important that we cannot ignore it, or we just can't shut our eyes to it. So in future, when we look at the next frontier, this segment will continue to have an important place and play a rather significant role in how we are going to shape up in the next 5 to 10 years. Lastly, coming to strategic leadership. Now, all of you are leaders here. And I also tell my team that each one of you on the team is also a leader. Think of yourselves as leaders. What do you think is strategic leadership? Leadership today has different meanings. Gone are the days of the old form of leadership, which was top-driven down. Today, it is a collaborative leadership. Today, when you look to hire leaders, you have to see whether
besides their intellect, the value they bring to the table in terms of their expertise, are they also having good EQ? That's also important. How do you deal with people around you? The world is so meshed with each other in different things that you cannot work in silos anymore. For whether it is in the government, whether it is, say, when you're dealing with your clients as litigators, or whether you are in law firm, more importantly as in-house counsels, you cannot say that I'm legal, I'm sitting on my table, something comes to me, I'll take a look at it, and that's about it. No, you got to know the business, understand what your stakeholders are all about, and collaborate. Every time, the more the collaboration, the better the results. And I can say this from my personal experience of now over collectively 37 years. So that if you start with your stakeholders early and you make the effort, you don't expect them to come, do make the effort of going to them, give them the proof of the pudding is in the eating, let them feel that by your joining them early, they've had better results and better outcomes. You save the organization a huge risk, and you save them vital time, which becomes a highly important ingredient when you are trying to, you are on a growth path and everything is time bound. So collaboration becomes key. Integrity becomes huge. Today, you got to, with so much of change and so much of transformation happening, people can slip up. So leadership has having professional integrity, personal integrity, and that will require a huge amount of courage. It's not going to be easy, you're going to be pushed. There will be times and there will be occasions when you would be, walking that thin line. And like in the automobile parlance, we always say, drive somewhere, if you're driving on the right side, don't go to the curb. Don't drive completely to the curb, because if there is a little push, you're likely to tumble and go into the ditch. So try and drive closer towards the center, which actually just says that when you are working, err on the side of caution, and also don't hit too much the gray. Remain more this side, so that when you get pushed, you still do not cross the line, and you're able to keep your organization within that sphere of compliance before they do the business. That becomes important. It's also important to see, and some of my colleagues here would know that, but imagine your company in the newspaper tomorrow. All of us would love to see it for the right reasons. You would want it to, we've done this merger, we've done this, we've sold so many cars, we've done whichever work your company is doing. But imagine if it came out that, you have abused your dominant position, you have, your audit has shown that you have evaded this duty or that duty. Immediately, if you are a listed entity and even otherwise, it breaks stakeholder trust. One very important factor when we do business, and we leave it as lawyers to our commercial stakeholders to think about this, but I think we need to be equally mindful that stakeholder trust, and I call it stakeholder, I'm not talking shareholder only. It's your customer, it's your own employee, it's the regulator, it is your entire value chain, could be it your upstream and downstream, your suppliers, vendors, and your dealers. Everybody, if you break the trust once, it takes a huge amount of time to build it back. And people who've, the famous example of Cadbury's and then Maggie and many others, even Volkswagen for that matter. I remember reading about the Volkswagen CEO saying, oh shit, we've lost the trust when that episode happened. It was not about that how much revenue is at stake. It is about losing the trust, because if trust is lost, then everything is lost. So that becomes another very important ingredient for strategic leadership. And lastly, innovation. We have to innovate. We cannot live in the world of the past. We have to be part of companies that are highly progressive on technology and innovation. We need to support them. We need to understand what that innovation is and be part of it. You got to join that bandwagon. You can't remain behind on it. Your personal preferences aside, but let's shed those and think more broadly on this subject. Innovation will have to be done with great responsibility because it can go wrong. And therefore, as people who are the conscience keepers of the organizations, it's our job to ensure that not only do we know about it, but we help the organizations to tread that path carefully and yet achieve the desired results. So I think bringing it down, it comes down to integrity with courage, governance with empathy, and innovation with great sense of responsibility as leaders. And lastly, it is your people. Today we are in this room, we are having BW Legal World Conference because nobody can have it without all of us being here. So it's all about people in any aspect of life. So if your teams are with you, they are Gen Zs, they knew, we just outside we were having this whole conversation that we all need to relook, rethink, and redefine the way we work with people and how we collaborate. I think that will be the secret sauce of success going forward. And with that, thank you so much for your time. Thank you.
Thank you so much, ma'am, for your address. Moving ahead for our next keynote address, we're being joined by a distinguished senior advocate practicing primarily in the Supreme Court of India and various other tribunals with over 50 years of experience in specializing in corporate, commercial, and insolvency laws. We're being joined by Dr. U.K. Chaudhary. Sir holds a Master of Laws degree and a PhD in law as well. A qualified company secretary and an associate member of the All India Management Association. He also serves as the president of the National Company Law Tribunal Bar Association and is an active member of numerous other professional bodies, including the Supreme Court Bar Association and INSOL International. Please join me in welcoming to the stage Dr. U.K. Chaudhary, Senior Advocate and founder, UKCA and Partners, LLP.
Good evening, councillors. For a moment, I thought that what I am doing here, appears to be a complete misfit amongst the general councils. My job starts only after the briefing in a real court of law, hardcore litigant lawyer. And therefore, when Dr. Batra told me that we have to have a keynote address on resolution resilience, and that is too relating to IBC, I got completely perplexed. For last 9 years almost, 5 cases a day, 200 days a year, I'm before the courts, that is the National Company Law Tribunal, then the Appellate Court, that is the National Company Law Appellate Tribunal, and then the second appeal directly to the Supreme Court of India. And trust me, I'm not yet done. So I do not know what to tell you of this subject, which I'm still learning, despite my, as I told you, 5 arguments before the tribunals and the Honorable Supreme Court. But I can share a few thoughts with you. When I say that where does this word resolution comes? All along from the day one that I started practicing as a corporate lawyer, the companies were always sued for recovery as far as the banks and financial institutions were concerned. They were recover their money which they have lent to them. So when suddenly we find out there is going to be a resolution of the debt, it was a completely misnomer to me. That how do you resolve the debt issues? But then when the IBC came, we found out that provisions which were being enforced. We in 1956 and we started with the winding up proceeding in 1956. Completely failed. It has no effect of any recovery. The DRTs in between the Board for Industrial Financial Reconstruction, then surfacing, and eventually when nothing succeeded, even the Reserve Bank of India issuing various monitoring and regulatory guidelines to the banks and financial institutions, nothing worked. The things remain where they are. And then suddenly a new legislation comes which hand over a complete change in the prospect of lending. From the borrowers controlled regime, it suddenly became a creditors controlled regime. And that changed. Nobody ever in their wildest imagination in the history thought that on the day of an admission petition under the IBC, the board of directors will completely be bent, will not be from that moment. And what will happen to their business? The business will go in the hands of a person appointed by the tribunal, first interim, and later on it could be appointed as a resolution professional permanent, till the resolution takes place. And this was such a change that it made this legislation success. And as you must have heard the phrase that nothing succeeds like a success. This is the success story which comes on a change of the mental block, that from the borrower's world, it becomes a creditor's world between the banks, financial institutions, and the companies. And the smallest first default, the one can lose the entire control of the company. And there are big examples, successful examples. Bhushan Power, Bhushan Steel, SR Steel, one of the largest corporation in the country, they change hands. So much so that before the it became effective in 2006, there was officially state reserve figures 16.5 lakh crores NPAs with the banks, and the best of the effect was that you and me and hundreds of thousands of the citizens were under a threat to lose their money with the banks. The banks were literally folding their gates. 16.5 lakh crores NPAs with the industry, borrowed but not paid back. It was this situation that when the IBC came, persons like me who have been in the litigation defending the companies from time to time, We were very skeptic that if nothing has succeeded, including the Companies Act 1956 up to SURFACE, how this legislation will change. But it did change. It changed the entire perspective that how quickly the same persons who were not bothering about any litigation were on the knees to pay back to the banks. And if not paid, there were other people to take over the ongoing company for a song. And I can say for a song because anywhere the haircut which the banks were agreeing from 50% to 85%. This is the scenario in which this success story of the IBC was written. And that is how, though in every word and in every meaning of the money, it's a recovery of the bank's money, but they call it a resolution of the debt. Why? Because there is a resolution plan to be put up by a person who calls a resolution applicant and when succeeds become a successful resolution applicant. And the two persons who wrote this success story was the first president of the tribunal, and I was there to see this success story because I was the president of the bar in the year 2016. 9 years later, I'm still the president of the bar. So the president ensured that every application filed by the banks, by the ARCs, by the NBFCs is definitely admitted, if not within 14 days, at least within a period of 6 months. Not 6 years or 60 years as the winding up was taking. The second person who made this success story, Justice chairperson of the 80% recovery of the NPAs totaling to 12.5 lakh crores. Banks are laughing back to their own banks. There is a surplus, they are declaring dividend to the government of India. From the situation that they were folding the gates. And you and me both were about to lose all our money in the banks and the deposits. And you know the pathetic situation. If you have more than 5 lakh of rupees in any bank, even today, you don't get any money if the bank folds not more than 5 lakhs of rupees. So just imagine if a wealthy person has a bank account, current or fixed deposit. In crores, he loses all money except a sum of rupees 5 lakhs. This is the pathetic situation even today. I don't know what the Reserve Bank will do, but something is required to be done. 5 lakhs is nothing today. Though it's a poor country, and for some people 5 lakhs may be still a big money. But when you look at the bank account, that how much money they contain today, 5 lakhs is nothing to assure you that if the bank goes bankrupt or insolvent, you will not get more than 5 lakh of rupees. So imagine the same bank recovering 12.5 lakh crore, have another figure. The total filing between 2016 and February 2025, I can't give you the figures up to October 2025, but I can give you up to March 2025. Total cases filed by the banks, financial institutions, ARCs, and operational creditors, over 75,000. 62,000 already resolved. 45,000 settled even before the petition is admitted. This is the magic of a creditors controlled regime of the IBC. Creditors, that is the banks and the financial creditors. Therefore, this is the one big change which has happened. And I can share one thing more. You search on any AI operated search systems. Nowhere in the world except India, nowhere, including the best of the democracies like US and UK. This kind of absolute creditor controlled regime is not in place. There is not a single insolvency court anywhere in the world except India where it can be stated by law, settled by the Supreme Court of India, that if the COC takes a decision in its commercial wisdom, this commercial wisdom is not justiciable by any court, including the NCLT. So, the creditors controlled COC has a final say in the matter. And that is why that 45,000 cases could be settled either under section 7 or 9 or even 10 is admitted. This, my friends, is the success story. Then why there is an amendment now? Why we are having the IBC Amendment Bill 2025? The complaint is one, and that complaint is that there is still the so-called delay in the opinion of the banks and the Government of India. So what are they doing? They are now making amendments. I can't discuss. There are more than 90 amendments in the bill. But I can point out two, because two are very important. Number one, that despite the Supreme Court holding again and again that all timelines of the IBC are directorial in nature and not mandatory. So 14 days, 330 days, 150 days, further extension of 1, 2 or 3 times, not exceeding 90 days. All these are directory in nature and they are not binding as mandatory timelines. But then comes an amendment. The amendment again reiterates that there is going to be a 14 days sacrosanct time for admission of a petition. Now, I, as a lawyer, cannot stand such kind of an amendment. 14 days judicial process to reach a conclusion, judicious in nature, that the petition filed, there is a default and there is a debt. Even to reach these two conclusions, that there is a debt and there is a default, even the first judgment of the innovative by the Supreme Court says that debt means that the debt which is payable in law and in fact. So somebody has to determine that whether in fact there is a debt or whether in law there is a debt. Similarly, if the default has occurred to the satisfaction of the tribunal, so the tribunal has to be satisfied that there is a default occurred in the payment of the debt. That satisfaction requires an adjudication. Adjudication requires an argument. Argument requires some time. So filing, listing, argument, and every member dealing minimum with 50 and maximum 150 cases every day. And the tribunal, as of now, has only 57 members. As per the Companies Act 2013, National Company Law Tribunal, which was supposed to deal with only the company litigation under the Companies Act 2013 or previous 1956 litigation continued. This tribunal was to have, as per section 419, 63 members made by the Parliament as a statute mandatory requirement. 63 members. And only to deal with the company matters. But we have added in 2016, after the tribunal was established, the second jurisdiction was given was the IBC. And every one case out of 5 cases filed in the NCLT today is an IBC matter. 1 out of 5. Sorry, 1 out of 5 is only company matters, 4 out of 5 are IBC. I'm sorry. So you can see the magnitude of the IBC cases, that 4 out of 5 are the IBC matters. How does the member deal? 57 members, 28 benches, sitting only half a day. So what will happen to this amendment? Therefore, the so-called experts in the committee which was established to make amendments in the IBC has found out another way to deal with the speed. And that is what they call now creditors initiated corporate resolution process, CIIRP. And what does that mean? That means that to start with, you don't go to the NCLT at all. If financial creditors decides, the financial creditors can have a COC constituted of his own financial creditors, and on the very first day, filing a petition within the COC itself can decide about the admission. Then admission leads to a public advertisement that creditors initiative corporate resolution process has come into effect. Only after that advertisement that the company, the promoter, will then have the right to challenge it before the NCLT. Both that public advertisement as well as the admission of that petition. This is the second important amendment which is coming, and as I understand from the sources, it is going to be due and approved in the coming Parliament session. Which will be that companies, what turnover, what nature of industry. This all is yet to be prescribed by the rules, a delegated legislation, not commonly permitted in the democracies where the law laying powers are with the parliament or the state legislature. But since it's a union legislation, it is with the parliament, and therefore the parliament should lay down the criteria that this CIIRP will start with which kind of companies. Nothing is known as yet. The last part, because there is not much of a time and you are waiting also for other speakers as well as for your awards. The last, that what is the way out? The way out is, at least I have been trying for last almost 9 years, approaching the Chief Justice of India, approaching the second puisne judge in the Honorable Supreme Court, who is the always a chairperson of a committee which elects the members for the NCLT. Writing to the finance minister, who is also in charge of the corporate affairs ministry, because they don't find that there should be a separate minister in charge of the corporate affairs. They feel it is good enough to tie it up along with the Ministry of Finance, so there is only one minister. Nothing is coming out in terms of the total number of members. This so-called committee, which has suggested these amendments, which I feel are 100% going to be challenged as soon as it becomes the law, on both sides, whether it is mandatory 14 days, and if not admitting the petition, the member has to give a reason, including he can say that the roof in court number 5 has collapsed and therefore I am not holding the court these days. That is the reason that I am not able to. He can also say that I am holding the court only half a day because there are no other technical member for me to support. But whatever the reasons, he has to give all these reasons. How much effect it will have on the government, I am not aware. But in my personal opinion, I have been consistently writing for 3 things. Number 1, there should be an increase in the members in the National Company Law Tribunal, not 63, but at least 163. Committee after the committee agrees, but nothing has happened. I am still with 57 members running 28 benches. 6 or 7 of them only half a day. One bench sits from 10:30 to 1 o'clock, another bench sits from 2:30, 4:30, because courtrooms are not available. 6 benches, but only 3 courtrooms. So one courtroom is to be shared by the 2 benches, one in the forenoon and another in the afternoon. This is the state of affairs. Second, I have been telling it's a specialized tribunal. It has recovered 12.5 lakh crore of rupees for you. The banks which were collapsing have been made to work. You are now laughing it out to the finance ministry with the 60,000 crore dividend from only one bank. So where is your problem? Why are you not creating the infrastructure? Why can't we have the courts comparable to the insolvency courts in US? Nothing has happened. So we are stuck with this second problem, that no infrastructure. the third problem. The third problem is all pervasive. At least in our high courts and the Supreme Court, you can say that there is a well-established, well-guarded system of elevation to the bench from either the bar or from a long service due, even in the position as an additional session judge or a session judge, at least he has some judicial decorum. I ask myself a question, please put your hand on your heart and tell me, is it good that on a national compel tribunal to appoint an additional secretary of the Ministry of Transport to deal with IBC and Companies Act? How does that man look sitting over there? An IAS officer who has no other experience except he is an IAS and he has been a secretary in the Ministry of Transport or Ministry of Steel and dealing with the minister on day, night and day out. How this person is important. I was just looking forward that I could meet Justice Sikri here. He is the one person who has written the second judgment relating to the establishment of the NCLTs and their constitutionality, upheld by him by writing a judgment when he was a Supreme Court judge. And he said, I reiterate what Justice Ravindran has written in 2010, that no person who do not have the relevant domain knowledge, even if an additional secretary or secretary retiring from Government of India, will not be appointed to the National Compel Tribunal. Despite that, committee after the committee, we are having these persons coming again and again. They sit as technical members, spend their post-retirement period of 3 years, 4 years, 4.5 years. You compare them with the quality of the High Court judges. I have a friend sitting right here, practicing in the Delhi High Court for almost 26 years or 27 years before elevating to, and he made one of the most appreciated judge in the Delhi High Court. Most appreciated judge. Why? Because he has the relevant domain knowledge and the judicial experience. Ladies and gentlemen, that is the third pain which never let me sleep in the night as a president of the bar, because the quality of the members is horrible. I'm saying from a public platform. Out of 28 judicial member position, you know how many only retired judges applied? Only 4. And out of 4, only 2 joined. Why? Because they have been told outside the premises that there is no infrastructure. Please do not go to that place. You will have a complete sadness hanging on you because you have been a High Court judge used to certain privileges and certain infrastructure which you will not find even 10% of it in the NCLT. So they have not joined. My friend, this is the third part of it, that what is the pain now? This is the pain. A tribunal which is one of the best in the country, the most important tribunal, I can say it, not that because I'm associated with the tribunal. I'm saying it because you see the importance. It deals with the company litigation, a company worth about even 1 lakh crores per year to 100 crores per year. It deals with this kind of companies and LLPs. It deals in terms of the net worth and revenue running into crores and crores and thousands of crores. So we require members, we require quality, we require infrastructure, and requires that there should be a power and privilege associated with this tribunal, which not I am saying, which the two Supreme Court judgment, one in 2010, another is 2015, have stated, and one of the person was supposed to be here, Justice Sikri, who has written the second judgment. Ladies and gentlemen, I don't want to take much of your time, but thank you very much. I told you that I may be a misfit in this kind of a gathering here. I'm a hardcore litigant. Anything in the court, I'll be very pleased to argue, but to give a lecture like the politicians is not my cup of tea. But anyway, thank you very much. Thank you, Dr. Batra, to invite me. Thank you very much.
I had the good fortune of knowing UKC sir for a long time. 19 and a half years back, I had a case in one of my companies, and I first went to see him, and subsequently I've got to know him both personally and professionally. I can tell you that he's passionate about it, not just in a public forum, but I remember about 3 years back, one day he called me. He said, why don't you come and meet me? I went to meet him, and everything that he's talking here today, he talked to me, and we did a cover in the business world on that. And he explained through data and the team that discussed. So he's really passionate. He just completed 50 years in the profession. So he's very passionate selflessly about it. It is, I mean, he is doing well, you know, I don't have to tell you. So thank you, Dr. Chaudhary, for being, I'm sure somebody will listen, and someday the compounding effort of your initiatives will lead to something, you know. So I'm sure it counts, sir. Just wanted to say. And Justice Meera and Justice Ansari are there. So I'm sure Aditya wants to take this forward.
Thank you. Thank you so much. For the next keynote, before we do that, my only request, because जो speakers यहाँ पर आपका औहदा बहुत बड़ा है, and we also want to make sure कि आप you wanted to present awards to a set of winners who will be joining us. Many of them have flights to catch back, जो बार-बार हमें देख रहे हैं. We've changed the order thrice. Now I'm only requesting for the ones who come up, be a little careful of the time. And next, it's a keynote address on the reform in arbitration laws by Justice J.R. Midha. Justice J.R. Midha served as a judge of the Delhi High Court from 11th April 2008 to 7th of July 2021. And as a judge, he presided over several jurisdictions, including a judge in charge of the original side of the Delhi High Court, also headed a division bench or hearing criminal appeals involving life and death sentence references. Sir served as a chairperson of Delhi International Arbitration Center, and during his tenure, various new initiatives were successfully undertaken, naming framing of rules for empanelment of arbitrators under the new rules, stage-wise disbursal of fees to the arbitrators, improved website of DIAC with added features, and more. And also as a judge, so actively initiated judicial reforms in various jurisdictions, namely arbitration, motor accident claims, execution cases, maintenance in matrimonial cases, and more. And post-retirement, Justice Midha is actively involved in reforming legal education, so is imparting value-based education to law students, and he's a professor at Galgotia's University, professor of practice at BML Munjal University, and also distinguished professor at the Rajiv Gandhi National University of Law. And Aj, he'll talk on reforms in arbitration laws, and he's also formulated model operating procedure for arbitration cases, जिसके बारे में वो अपने इस keynote में बात करेंगे. He's also shared his views on amendment of the Arbitration Act to the government. A very famous quote by him, which he formally believes in also, is that in the court of justice, both the parties know the truth. The judge is on trial to find out the truth. Ladies and gentlemen, please join me in welcoming the judge who's always looking out for the truth, Justice J.R. Midha. I only saw 3 of you cheer while he's walking up. For the others, thank you.
My dear brother, Justice Ansari, my dear friend, Mr. U.K. Chaudhary, Dr. Batra, learned counsels, general counsels, ladies and gentlemen. I'm thankful to Dr. Batra for inviting me here. And I'm very glad to wonderful views expressed by Mr. U.K. Chaudhary. It was really a great pleasure and delight to hear him. We have been hearing him in High Court, and I'm thankful to him for the appreciation he had given to me. When I was invited, I was thinking what to speak today, what is very interesting for the general counsels who are participating here. You see, I had been heading Delhi International Arbitration Center, and then post-retirement I am extensively involved in arbitration cases. And I find that arbitration culture is not growing in our country. So I did a complete research on it, and also depending upon the cases which I am doing. So first of all, in all cases which I am conducting, I have formulated a model operating procedure. I have requested Mr. Joshi to share with all of you, because otherwise it is very difficult to complete the proceeding in 1 year. And maximum time is consumed when the case goes in evidence. 8, 10 hearings, cross-examination, lengthy cross-examination going on. So there in the model operating procedure, in all my cases, after the evidence is filed, I direct both the parties to serve the interrogatories on the witness. So that saves the time, and the witness has to reply the interrogatories on affidavit. After the reply has come, if the counsels find that the witness has told the truth, then there is no need for cross-examination. In 60% of the cases, counsels say that now you can straight away put the case for final arguments. Wherever they find the witness has told a lie, the right of cross-examination is still open, but now it is a limited right, because now you know to what extent he has told a lie. Now we record the cross-examination, but this cross-examination I do not record in a question-answer form. I do the complete video recording, and the procedural order says that the entire cross-examination will be video recorded and will be saved on a pen drive, which shall form part of the judicial record. The witness will sign only one paragraph statement saying that I have seen the pen drive, it contains true correction of recording of the cross-examination. In this method, I am able to record about 100 to 150 questions in 1 hour. So at times, many of the senior counsels, they came, they said, we want 8 sessions. I said, we'll start today. And it was completed in 4 hours, 500 questions. And you are able to see the demeanor of the witness. Everything is recorded later on. Later on, a true transcript can be prepared only of the question which you want to refer in the final arguments. So this saves a substantial time. Then also the format of the final arguments. So this we'll share with you. And now the question arose in some of the platforms where I shared these model procedure. They said in an ad hoc arbitration, the arbitrator may not be willing to follow it. Then how do we enforce this model procedure? Then there I have given a suggestion that in future, whenever you are executing an agreement, you can do a separate arbitration agreement executed where you say that whenever the matter goes to the arbitration, the arbitrator will follow these model rules of procedure. So as a general counsel, you can have this, and it saves, let's say you save 10 hearings of cross-examination or 20 hearings. You save substantial amount of money. It is not only the arbitration fee, it will be mostly schedule 4, but the counsel fee is of course there. So this is one major reform which I suggest will be beneficial to the more to the litigants than to the lawyers, because lawyers will be of course facing difficulty, their appearance fee will go. And second important thing is last year when the government put that amendment bill 2024 on the website and invited objections. So I submitted the suggestions, then also did, and my major suggestion was that in all jurisdictions, whether civil, criminal, labor, company, everywhere, we go on a principle that human judgment is fallible. So one appeal is provided everywhere. Arbitration is the only exception, where in 34 is not, you can't look into the error of facts, you can't look into the error of law. Therefore, does a person who has agreed to go by arbitration, does he has given a consent that I will not even raise my objection? And word over, I have done the research which also I have shared with you in UK in 1969 they had a right of appeal. Not on a question of facts, they said finding of facts are final. On a substantial question of law, with the leave of the court, you can file. Then on the same model, Hong Kong also incorporated. On the same model, then Singapore also has a right of appeal. Then on the same model, then in 2002, probably, I think that year I have mentioned in my note, then in UK they said whether this law is working well, they said it is working very well. And here what is actually happening in courts? Today what is happening is, and DMRC is the best example, where the award was totally against all principles. The approach of the courts at times is that not in 34. You hear a matter for argument 10 days and then say not in 34, only one line. So therefore, to my mind, and I had also advised and suggested to the government, section 34A should be there, that right of appeal on a substantial question of law of public importance with the leave of the court. So 4 rigors are good enough that every case will not fall. But now, last week, the government has put that 2025 amendment bill on record, where they have not gone by this format, although this was submitted to the government. They have framed a new provision, which I am not discussing today, we are short of time, you can look into it, but to my mind that does not satisfy the, and it is saying that the appeal will go to the tribunal, which to my mind, as Mr. Chaudhary has rightly said, tribunalization has not succeeded in our country. Let's see all the tribunals. It is not only NCLT. You see all the tribunals. There was a judgment of the Supreme Court earlier where they had said that we should dissolve all tribunals and everything should come to the High Court. We should increase the strength of High Court. The culture of the High Court is different from the tribunals. Therefore, but once again I see in that 2025, which also I have shared with Mr. Joshi. Mr. Joshi, you can share with everybody. And one last point I'll share with you, which again is one of the provisions which is very rarely invoked. All of you know that scope of 34 in Arbitration and Conciliation Act is very narrow. Supreme Court in the last judgment said you will not look into the errors of fact, you will not look into the errors of law. It is very, very narrow. So that front gate is very narrow. Therefore, we are saying there should be appeal. But the explanation 2, subsection 2 says that if the award is against the most basic notions of morality or justice, it can be set aside. Whereas in civil law in RFA, the judge is not supposed to look into morality. Judge can only see into legality. If anybody wants to argue on morality, the judge will say that, look, I am not supposed to look into morality. But Arbitration Act gives one wider power. Most basic notions of morality and justice. This term has been interpreted by Justice Nariman in Associate Builders to mean that which pricks the conscience of the court. So therefore means that if something pricks the conscience of the court, then the award can be set aside. So this matter came up before me, even prior to Associate Builders, I think in about 2013 or so. Briefly take 1 minute facts are very, very, very interesting facts are there. Where the Kotak Mahindra Bank took a property on lease at 10 lakh rupees a month per rent for a long lease for 9 years. After 4 years, the rent fell down to half. So the bank approached the landlord in Noida that said, look, that the rents have fallen down. So either you reduce the rent to half or we'll take the adjoining property. So landlord reduced the rent to 5,50,000 by a supplementary lease deed, and the bank started paying the low rent. After 3 years, the landlord said, give me the whole rent. They said, but we had reduced the rent. They said, no, I don't agree. So the landlord invoked the arbitration. Matter went to a retired judge of Allahabad High Court as the arbitrator. There the landlord took the plea that, look, this supplementary lease deed is unregistered and it is unenforceable. So the arbitrator rightly said it is unenforceable. When the matter came in 34 before me, I said, yes, award is legal. Arbitrator is perfectly right. Award is legal. But the award is against most basic notions of morality and justice. I said, this person had signed the document. He has made a false statement here. I should notice under 209 IPC why he should not be prosecuted, and also why the award should not be set aside on morality. After that 209 notice, the matter was settled. I could not write a judgment. But in 2021, Ganesh benzoplast matter came before me, where again I invoked the doctrine and quoted this matter also. But other than this, I find that this, although on both these occasions, I suo motu invoked this doctrine of morality and justice, but I don't find any case law on either side or by the lawyers also to have invoked this. But it is a very important doctrine. It is a wider power given than even the civil code RFA. which even a RFA or any civil matter, even the court can't say that you can't look into morality. In fact, the lawyer have argued at times. They said, sir, you can't look into my morality. You look into the law. And if there also if we go by law, then the landlord was right because the document is unenforceable. But if you go by morality, then it is a most immoral landlord and immoral award. So this also I have shared in my note. They will share with you. So I think this model rules of procedure, suggested amendments, which I think likely in this session they will be discussed. And also this Ganesh Benzoplast judgment, they will be useful to you. So when you go back home, you go back with some added new features. Thank you very much.
Thank you so much, Justice Mehta. And now for the next and our last keynote address today before we conclude the award ceremony. It is by Justice Iqbal Ahmed Ansari. So sworn in as the 39th Chief Justice of the Patna High Court in the year 2016, and following his retirement from the High Court, he took on the role of a chairperson for the Punjab State Human Rights Commission in 2017. Also known for his advocacy and addresses on human rights issue. Please join me in welcoming to the stage Justice Iqbal Ahmed Ansari, everybody.
My friend, Mr. Mirda, Justice Mirda, Dr. Chaudhary, learned counsel present here, ladies and gentlemen, we have to start the award ceremony. And thereafter, I think it is followed by dinner. I would not have minded if you were delayed for dinner, but as far as awards are concerned, they are anxiously awaited. And therefore, the topic which I had chosen, I am changing it to another. My topic was media trial, but I will very briefly speak what I think to be justice. What is justice? I give you only one example, one illustration. There is a famous film star, Salman Khan. Some time back, he was alleged to have driven a car under the influence of liquor and passed over a few of the pedestrians. Obviously, the media was very hostile. The matter landed up in court as it ought to have landed. And the court also gave the verdict that Salman Khan was guilty. Now, as far as the victims and their family, the general public were concerned, they all said justice has been done. But Salman Khan's friends and family said, no, it's a great injustice. He is so good a man. He was not the one who was driving. It was his driver who was driving the vehicle, etc. Question is, was the justice done? The matter moves to appellate court in Bombay. And the Bombay High Court takes the view that Salman Khan could not be proved guilty of the charge. So the appeal was allowed and he was acquitted. Now Salman Khan's friends and family, his fans say it is justice which has been done. Victim's family and few members attached to them said, prosecution said, it's a great injustice. Third context was, as far as the victims were concerned, their families say, members of the family, we are not concerned whether Salman Khan is punished or not punished. We were promised compensation. That compensation is the justice for us. It has not been paid, so justice has not been done. So what was the injustice? Was justice conviction of Salman Khan? Was justice acquittal of Salman Khan? Was justice payment of compensation to the victim's family? According to our perception, justice cannot keep traveling. I will take the view, no, justice has not been done. Dr. Chaudhary will take the view, no, justice has been done. Justice Mehta is very much always concerned with compensation and justice. He will say, no, compensation ought to have been paid. It can't be like that. Though to set our anxiety at rest, I would say, and I think most of you will agree with me, I don't say all of you will agree with me, that if a decision is reached according to law which is relevant have been made by us I mean whether it is parliamentary law or it is law made by the legislature, both are made by our representatives. So the law which Prime Minister Modi makes is not his law, it's our law, whether we have given him vote or we have not given him vote. If that, according to that law, a person has been correctly adjudged as guilty, then he is guilty. And justice ought to be said to have been done, no matter whether I take a view different from what a judge takes. If the judgment is not according to law, then we have to say that it is not justice. I would, as I said earlier, not prolong your pang for injustice, and therefore close my address and leave all of you to enjoy the awards which are being very anxiously awaited. Thank you.
Thank you so much, Justice Ansari. With that, we come to an end of discussions for today, which also means that it is time to begin with our awards ceremony. This is the 6th edition of the BW Legal World's General Council 100 Plus. My name is Aditya Malik, and I want to welcome each one of you to this award ceremony. This initiative is to recognize and reward the prolific general counsels like yourselves who have made a mark for themselves in the profession. This annual marquee event is conceptualized to fuel excellence in the legal ecosystem by identifying the best corporate legals in India who have the potential to lead the way. The award ceremony is being broadcasted on all BW Business World platforms, including the social media channels and also on www.bwlegalworld.com. In your opinion, happy picture, moment that you wish to share online, please also use the hashtag BWLegalGC100, where 100 is numeric. A big thank you to our partners, Joy Travels Private Limited, Phantom, Beanley Coffee, The Thick Shake Factory, Reality Plus, Exchange for Media, IWM Buzz, Impact Weekly Magazine, and also Pitch. A heartfelt gratitude, thank you to our jury members whose rigorous deliberations have led us to the exceptional awardee list which have just been given. अगर आप अपने आप को नॉमिनेट करते हैं, हमारा ऐसा मानना है कि आप ऑफ कोर्स एक ऑलरेडी अवॉर्डी हैं, बट ऑफ कोर्स अ लिस्ट इज अ लिस्ट, numbers are numbers. We have the jury will be first to show you and also to give you sort of a feedback कि उनका क्या मानना है about your work and the process that happened on that day. Can you please Play the jury AV first.
Thanks to BW Legal for nomination as one of the jury members for the selection of in-house counsels. The role of the in-house counsel has become very critical over a passage of time due to business dynamics, achievement of organizational goals, and also to maintain the highest standards of corporate governance. It was truly a daunting task to select 100 nominations out of many. Yes, assessment was carried out independently based on certain objective parameters. We have tried our best to do justice to the given assignment. Congratulations to those who have been selected. Our thanks to others who have participated, could not get selected this time. Our best wishes for them as well for their future endeavor. Thank you very much, BW Legal, once again. Thank you.
The nominations were evaluated on 5 parameters: leadership, impact on the legal domain, and absolutely the work done by them. And this independent evaluation by the juries were aggregated to meet the final 100 list. I am really happy that we could do justice to the situation, justice to the task. Reason is, it was an assessment based on the data as well as objectivity and not subjectivity. Congratulations who made it to the top 100 global GC list, and I wish best those who could not make it in the list for the next year. All the best to everyone, BW Legal, for the GC event. Thank you.
It has been an absolute privilege to serve on the jury panel for this wonderful event. What stood out at the event the other day was not just the immense talent on display, but the sincerity, discipline, and creativity each participant brought to the stage. Every performance reflected hard work, thoughtfulness, and genuine desire to grow. My compliment to the organizers for creating a platform that recognizes excellence and encourages the next generation of necessary framework. Events like this nurture confidence, character, and community within the society. My advice to everyone would be to keep refining their craft, keep showing up and keep believing in your voice. If today is any indication, your potential is extraordinary. Thank you once again for inviting me to be part of this excellent experience.
Let's please give a huge round of applause to jury members. And formally welcome all of you and also to inaugurate this award ceremony. Please join me in welcoming Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business and founder of the Exchange for Media Group. Now you can.
I just want to be quick in thanking the jury, thanking Dr. UK Chaudhary, thanking Justice Mida, thanking Justice Ansari. And I just want to say that one, I don't know about law in even 5% what you know. But for last 15 days, there's a thought in my mind that, again, Dr. Chaudhary put in my mind in a conversation. He said, we were discussing his favorite topic, and he said, in India, the promoter, instead of consulting the lawyer, first goes to the CA. In the US, the same promoter would first go to the lawyer and then to the CA. So I think both of us have a role to play. But I think given the complex regulatory environment, for example, now DPDP has come in, it has tremendous implications. So the role of a GC, the role of the legal guide, advisor, whatever word you want to use, in-house counsel, is going to the next level. More and more GCs are making it to the board. The GC's voice in the boardrooms is being counted more than ever. It is also reflected in we have data on the remuneration being paid to the GCs. You could still argue they should get more, and why not? But the fact is the role of GC is growing. The role of GC as an advisor to the founder, to the board, to the CEO is growing, and people represented in this room are in some way contributing to that. So congratulations. All the best. Mr. Amar Sundaram is sitting here. 2 years back, I discussed with him an annual survey of GCs. This year we are doing it, and hopefully in Jan and we'll have that with you. I don't want to stand between you and the awards. Congratulations to the winner. I don't see Miss Manjari Chaudhary, but if she's around, Manjari ji, thank you for being. It can't see because of there's no other reason. She's been a winner of our Hall of Fame. The first year, Mr. Hemant Kumar was a winner of our Hall of Fame. This year, we have not given it to anyone. But I'm grateful to you for your involvement and patronage, and to all the jury members for making today happen. Thank you, and I congratulate all of you. Do applaud for your friends, colleagues, and people who you know well. Clapping is good for heart muscles, plus when you will be up here, the karmic balance you build by applauding for others will come back to you. Thank you. God bless you.
Thank you so much, Dr. Batra. And now for the award ceremony for all the winners. Once you've received your award and you step down from the stage, please proceed to stage left, and that's audience right, for a group, for an individual picture. And we also stay for a group picture, both for editorial purposes. Again, reminder, any picture you share online, please use the hashtag BWLegalGC100. And with that, yes, let us start with the award ceremony to present the first of awards. Please request Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business and founder of the Exchange for Media Group, along with Dr. UK Chaudhary, Senior Advocate and founder of UKC and Partners LLP, along with Justice J.R. Midha, former judge, Delhi High Court, to please join us on the stage, gentlemen, and we'll start with the award ceremony. Aye. It's a long list. We'll try and keep it as quick and as happy and as cheerful as possible. Chaliye, the first person to join the 2025 power list of BW Legal World Top 100 General Counsel. Please. Zamir Nathani, Global General Counsel, DNEG. For Zamir, everybody. Congratulations. And the next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Sachin Mishra, General Counsel and Company Secretary, Jana Consulting Engineers. Congratulations. Yeah. चलिए आगे बढ़ते हुए the next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Renuka Shastri, General Counsel, Reliance Retail Group. For Renuka ji, everybody. And the next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Ajay Kapoor, Chief Legal Regulatory and Advocacy, Tata Power Company. And the next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Ajinkya Jain, Group General Counsel, Company Secretary, Compliance Officer and Investor Relations Officer, Physics Wala. Winners, reminder, your individual picture and then a group picture in the end as well. With that, the next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Amar Sundaram, General Counsel, Senior Vice President Legal, Chief Compliance Officer, NEC Corporation, India. Please request Iqbal Ahmed Ansari sir to please join us and help us present the awards. आगे बढ़ते हुए the next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Vice President, Legal and Land Acquisitions, Purva Green Power, a renewable energy arm of RP Sanjeev Goenka Group.
Give Amit a bigger round of applause.
The next person to join the 2025 Power List of BW Legal World Top 100 General Counsel. Compliance Officer, India and Middle East, Journey Technology Services, India. Hey, you should clap. I mean, you can, and you're thinking. चलिए आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Ashish Kumar Pandey, General Counsel and Company Secretary, Luminous Power Technologies.
Mr. Pandey, a bigger round of applause.
Congratulations, and the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Ashit Garg, Head of Global Legal Service and Company Secretary, Rambol, India. Ashit. Congratulations, Anwar sir. Congratulations, Ashit. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Bhavna Ranganan, Senior Vice President and Deputy General Counsel, ZPAC, India. Congratulations, winners. Reminder, individual picture, group picture in the end, and with that, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Vineet Kumar Khurrana, Senior Vice President and Group Head, Legal, DCM Shriram. For Vineet, everybody. Sir, what do I need? Congratulations.
Chaudhary, thank you. I would request Ms. Manjari Chaudhary ji, one Chaudhary gone, so I get another Chaudhary, so you know that. Please give Ms. Manjari Chaudhary ji a big round of applause.
चलिए इसी के साथ the next person to join the 2025 power list of BW Legal World top 100 General Counsel. Nilo N.S. Puri, General Counsel and Head ESG, Bajaj Electricals. For Binu, everybody. Surely the next one. The next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Devashish Roy Chaudhary, General Counsel and Head Legal, Compliance and
Secretarial Institutions Global.
This is the moment you applaud, guys. You don't. I'll keep reminding you because आपका number भी आएगा. इसी के साथ the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Postman on the head, legal, Senipolis, India. इसी के साथ the next person to join the 2025 hour list of BW Legal World's top 100 General Counsel. Dr. Subodhni Sharma, Head of Legal, All India. Congratulations, man. इसी के साथ the next person to join the 2025 power list of BAW Legal World's top 100 General Counsel. Dr. Mukul Shastri, Group General Counsel, Cube Highways. Congratulations. इसी के साथ the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Hiranmay Ralabandi, General Counsel and Chief Governance Officer, US, India. Everybody? Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Kaustubh Nandan Sinha, General Counsel, JP Infratech. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Kuldeep Sharma, Group General Counsel, Vishal Megamart. Kuldeep, everybody. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Vipunjay Kumar Singh, General Counsel, Ahluwalia Contracts, India.
Give Mr. Singh a round of applause, yeah.
आगे बढ़ते हो the next person to join the 2025 power list of BW Legal World Stop under General Counsel. Munish Sod, Senior Executive Vice President Legal and Compliance, Royal Life India Asset Management. Munish, everybody. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World Stop under General Counsel. Prakhar Sharma, General Counsel, National Investment and Infrastructure Fund, NIIF. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal. Congratulations, sir. Reminder, winners, individual picture, group picture in the end. And with that, the next person to join the 2025 power list of BW Legal World Stop under General Counsel. Pratap Galra, General Counsel and Compliance Officer, India, Southern Africa, East. Congratulations. इसी के साथ the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Preeti Balwani, General Counsel, Bristol. For Preeti ji, everybody. We've almost reached the first half of the list. जो बाकी बचे हैं, आपका नंबर अब आएगा. That means you to applaud harder because you're going to be in that one. With that, the next person to join the 2025 power list of BW Legal World Stop 100 General Counsel. Priya Jaswani, Associate General Counsel and Company Secretary, CME Group, India. Congratulations, man. With that, the next person to join the 2025 power list of BW Legal World Stop 100 General Counsel. Rahul Sharma, Assistant General Counsel and Head Legal, India and South Asia, Tech Mahindra. राहुल के लिए एक बार congratulations. Moving ahead, the next member, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Rajbir S. Sachdeva, President, Group Legal, JK Organization. Rajbir ji, everybody. Congratulations, sir. इसी के साथ the next person to join the 2025 power list of BW Legal World Stop under General Counsel. Ramhao Rudraji Kinkari, President and Group Head, Legal, Secretarial and Administration, Thomas Cook, India. Congratulations. Moving ahead, the next member to join the 2025 power list of BW Legal World Top 100 General Counsel. Richa Mohanty Rao, General Counsel, Urban Company. Guys, this is the time not to go silent. Congratulations. इसी के साथ the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Ru Lomba Legal Head India, Axel Noble Powder, Coatings India. Roop everybody. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Samir Chugh, Chief Legal Officer and General Counsel, Play Games 24/7. Sameer. Thank you. Chaliye, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Sanjeev Sachdeva, Chief Legal Officer, Elan Group. Congratulations, sir. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Shalini Kutsishta, General Counsel, South Asia, Gensu, India. Congratulations, ma'am. And the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Shishir Kumar, Chief Compliance Officer and General Counsel, Asim Infrastructure Finance. Sheshaji, everybody. Congratulations. You know, I'm sorry to keep reiterating, but the music, it's to help your applause, not to eliminate it. आगे बढ़ते हुए, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Soumya Agarwal, Group General Counsel, Fractal AI. Congratulations, ma'am. Moving ahead, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Kamishna Ghosh, Group General Counsel, Chief Risk and Sustainability Officer, Strides Pharma Science. Congratulations, ma'am. इसी के साथ the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Sunit Misra, Board Director and General Counsel, India, Regional Senior Counsel, AMEA, Fall Corporation. Senior everybody. Congratulations. With that, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Sudipta Ghosh, Head Legal Real Assets Business, EAAA India Alternatives. Not here. Sudipta ji, नहीं. चलिए, congratulations to her. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Congratulations, sir. इसी के साथ the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Vinay Bhagawan, Head Legal and Compliance, Nano India Commercial Vehicles. Vinay, everybody. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Gopal Jain, Senior General Manager, Legal and Company Secretary, APL Apollo Tubes. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Akhilesh Kumar, Legal Head, MBD Group. Akhilesh, everybody. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Bharti Balaji, General Counsel, Indian Sugar and Bioenergy Manufacturers Association. Bharti Balaji, everybody. Moving ahead, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Saurabh Malhotra, Head Legal Risk and Compliance, South Asia, Intertech India. For Saurabh, everybody. But please request Dr. Rajesh Saigal to join us on the stage as well, sir, to present awards to our next set of winners.
Why, Krish?
Can you request? He is here, Dr. Saigal. While he is coming, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Sayan Chakraborty, General Counsel, Maharashtra, India.
Give Mr. Chakraborty a bigger round of applause.
आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Vikas Goyal, Senior VP Legal Group General Counsel, VS Group. Vikas, everybody. And with that, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Prakash Pandey, Head of Legal India and APAC, Innova Solutions. Jai Prakash, everybody.
Give Mr. Pandey a bigger round of applause.
Congratulations, sir. And now we're down to our last few awards. The winners couldn't be here, but they have sent their representation. We'll move ahead with them as well. I'll also request Vineet Vish ji to please join us on the stage and help us present awards to our last set of winners. Sir. Thank you, ma'am. Thank you so much. Also for ma'am once. चलिए जी आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World Top 100 General Counsel. Anubhav Kapoor, Senior Vice President and General Counsel, Samvardhan Motherson International. We have with us Shivam Opal to receive the award on behalf of Anubhav. For Anubhav, everybody, we also have Shivam with us. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's Top 100 General Counsel. General Counsel, Manipur Academy of Higher Education. We have with us Nikhil Bhardwaj to receive the award on behalf of Mirul. Congratulations. With that, the next person to join the 2025 power list of BW Legal World's Top 100 General Counsel. Shobna Nikam, Executive Vice President and General Counsel, United Spirits. The IGO India. We have with us Harsimran Singh to receive the award. विनय तो है ही Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's Top 100 General Counsel. Pooja Sehgal Maidani, General Counsel, Sun Life Global Solutions. We have with us Amarji to receive the award on behalf of Pooja. Congratulations, down to our last 10 awards. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's Top 100 General Counsel. Dr. Sagar Suresh Dhole, Senior Counsel, India and South Asia Region, Law and Policy Department, Mastercard. We have with us Andrew Kumar, AK and partners to receive the award. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's Top 100 General Counsel. Ramani Dhalla Group General Counsel, Zomato. We have with us Ashwar. Nope. Congratulations to Damini. Moving ahead. Our next member to join the 2025 power list of BW Legal World's Top 100 General Counsel. Sandeep Chaudhary, Group General Counsel. We have with us Nikul Shastri to receive the award. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's Top 100 General Counsel. Aparna Robert, Chief Legal Officer, L&T Finance. We have with us Mohit Kumar to receive the award. Yeah. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Sanjota Kulkarni, Executive Vice President and Deputy General Counsel, LTI Mindtree. We have with us Sri Jagannath to receive the award. For Sanjota, everybody. Moving ahead, the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Royal Hindi, the President, Legal Upgrade. We have with us Rahul Parashar from Upgrade to receive the award. For Koel and also for Rahul, everybody.
Give Rahul a bigger round of applause.
Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Dr. Rajiv Chopra, we are Managing Director, Legal Accenture. We have with us Siddharth Kumar Dubey to receive the award. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Sandeep Rajput, Head Legal Retail Assets, RIFL Finance. We have with us Sonali Kumari to receive the award. For Sandeep, everybody, we have Sonali also to receive the award. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. Anil Lale, Head Legal Geostar Sports Studios and IT Geostar India. We have with us Soumya Mishra. And Soumya is not here along with Anil. Congratulations. आगे बढ़ते हुए the next person to join the 2025 power list of BW Legal World's top 100 General Counsel. चलाइए. Dr. Vivek Mittal, Executive Director, Legal and Corporate Affairs, Hindustan Unilever. And he is not here as well. But congratulations to Dr. Mittal as well. You can clap for him. He's नाम तो आया है. With that, we come to an end of the award ceremony. इतना ही कर दो. He's very excited. With that, we come to an end of the award ceremony for this year's 2025 BW Legal World's Top 100 GCs. आप सभी को बहुत बहुत मुबारक हो. Now please request all the winners to join us on the stage with us for a group picture. Please. Please come. And after that, we have dinner and drinks. No, dinner only, sorry. All the winners, please, with your trophies, आइए. Justice Ansari, please request you for picture के लिए. Do we have any hotel person here? जितने विनर्स ऊपर हैं उतने ही फोटोग्राफर्स नीचे भी हैं. वेरी गुड.
behind you also, sir. And we just see from a symmetry standpoint.
Can we please have 2 chairs here for Justice Mishra and Dr.
Chairs and chairs. Feel like old. Just see, Aditya, just see, no one see.
So now we'll do your individual phones. You got 10 seconds for that. जहाँ जहाँ आपके मोबाइल फोन्स हैं. Dr. Batra, can I request you? You should click this. Once done, please also हाँ अपने phones आप रखना ताकि मालूम पड़ जाए. Done, mobile phones done. Ma'ams. Okay, 5, 4, 3, 2. Thank you. Now the center camera, please.
Done?
And congratulations to all of you. Please enjoy yourselves. Join us for dinner. For everybody traveling back home, safe journey. We'll see you next year. Thank you. Hello. For the ones who want boxes for the trophies, we have them here. You just need to come towards the first table and take one for yourself.